So happy to see all of you here. You know who I am. I'm Roger Benz, the Dean of the Law School here. And first and foremost, I want to thank all of you for putting together this conference on immigration law. So I'm going to start with a bizarre citation. So if you go on Judge this morning, I'm really proud of us. That's an odd thing to do. Even he concedes that we are all utterly and completely panicked about the election and the press. Right? So it's my job to get us undepressed and excited about thinking about public policy and immigration in a pretty powerful way. So I'm with my law professor here. I have some citations. And so first I'm going to start with George Washington. Okay? That's a good place to start. George Washington, quote, "The bosom of America is open to receive not only the opulent and respectable stranger, but the oppressed and persecuted of all nations and religions, whom we shall welcome," spelled by George Washington correctly, "to participate in all of our rights and privileges with our decency and propriety of conduct and adhere to merit the enjoyment of our country." That's a Boston quote, right, from our founding leader. Second quotation from FDR. You might have heard the apocryphal version of this, where he was, in 1938, addressed the daughters of the American Revolution, starting with the phrase, "My fellow immigrants." That actually didn't happen. He did address the DLR in 1938, and he did talk about immigration, but the quotation is actually much more interesting and powerful. So he said, "I thought of preaching on the text, but I shall not. I shall only give you the text, and I shall not preach on it. I think I can afford to give you the text because it so happens, through no fault of my own, that I am a descendant of a number of people who came over in the Mayflower. More than that, every one of my ancestors on both sides, and when you go back 4 generations or 5 generations, means 32 or 64 of them, every single one of them was in this land in 1776, and there was only one Tory among them. The text is this. Remember that all of us, and you and I especially, are descended from immigrants and revolutionists." Awesome quote. So, urges to give a text. So I actually have a real text here. It's from Leviticus, which is a very strange book of the Bible to begin with. So let me start with one text. Text the verse. "When you reap the harvest
processes much more legally complex without necessarily ensuring access to counsel and legal knowledge for people who might need it. So this picture is so consequential and so missing from public discourse. Students of the law review decided to that they were interested in framing a symposium on immigration. I was very excited to see that it coincided with this 20th anniversary of the 96 immigration laws, and would give us a chance to reflect that, but also to think about the contemporary implications, what lessons are learned from that period, what are the consequences today of that sea change, especially as the dean noted that we are in a moment of toxic politics around immigration once again. And this picture is not simply one, or maybe even primarily one, of immigration. Immigration is an idea that has come to the fore to describe the convergence between immigration control and criminal law enforcement in various ways. But the picture is much more thoroughgoing than that. If what advocates seek today is a comprehensive immigration reform, this is really one I would suggest is a comprehensive immigration severity. So we have an amazing lineup of national experts, and I couldn't be more excited by the array of experts, practitioners, scholars, advocates, policymakers who are here today to share their reflections. Many of the folks in the room and participating today have been involved with these issues for many years. Many at the time of the 96 legislation were deeply involved in the debates around what came to transpire, in dealing with the consequences in the immediate aftermath, and certainly living with the legacy, resisting and challenging in many cases the legacy of those laws today. So I don't want to say much more. I do want to make sure to thank several people who have been very helpful in bringing this program about. Dean Roger Dennis for his support, Dean Mary McGovern for all the work that she has done, Sarah Greenblatt, Emily Storch, Jerry Harrison, and especially our terrific, wonderful law review students, Jackie Porter, the symposium editors, done a wonderful job of helping put together, Autumn Pavina as editor-in-chief, and really a large number of volunteers today. So with that, I will say no more, and we can just move right into our first panel. So,
let me start by saying a huge thank you to Anil and to the law review editors for putting together this amazing panel. And I just wanted to note that 1996 was my first year of law school and Anil's second year of law school. And I'm saying that not to age my dear colleague there. But just as a reminder, and I think that's one of the great things about today's conversation, that the way we regulate immigration now has the aura of inevitability, and that this is the way it should be, this is the way it always has been, but at that time, it was really seen as contingent, and I still remember Chief Judge Peters brewing every single moment of the implementation of the one-year filing deadline, and so much conversation about this new law and the way it changed everything, but now we have a whole generation of lawyers and law professors who've grown up under IRA. But I think it's important in today's conversation to remember that this is not the way that it necessarily needs to be, and that we should think about the way things could be different. I've been asked to provide a few reminders. First of all, this symposium is being streamed live and will be recorded. Please silence all of your cell phones. And for folks participating by live stream, if you want to join the conversation on Twitter, use the hashtag #Drexel LR16. And if you want to email questions, you can send them by email to drexellr16@drexel.edu. So let me start by introducing my esteemed panelists. First of all, to my immediate right, we have Immigration Policy Institute. From 2010 to 2015, he was the Deputy High Commissioner for Refugees, and he has as do all the panelists, a much, much longer and very impressive biography that's available in the program. To his right is Nancy Moravec, who's Professor of Clinical Law at NYU Law School, where she directs the Immigrant Rights Clinic. And then finally, to her right, we have Maria Saeed, who is Professor of Law at the University of South Carolina School of Law. I'm really looking forward to this conversation. I'm going to ask
So as I was getting into this panel, Mike Wishney turned to me and said you have a lot of explaining to do, which was an unfriendly remark. And maybe I'm here first because I'm probably one of the oldest people in the room, was actually present at the creation of this law. I was working in the Immigration Service at the time. It's not IRA. Why do you say IRA? I've never understood this. But does he want a law, this law, because of his name? Anyway, IRA was adopted. I'm realizing now that I remember little of what happened, and what I remember is probably not true, so I hope I'm not here as someone who can tell you what the real inside story on this was. And I'm supposed to talk about a much more limited topic, which has interesting consequences for today, but I'll spend in the middle of that. I'll talk a little bit about what I do remember at the time that this law was adopted. So my topic is expedited removal and the credible fear determinations that were working as part of expedited removal to protect asylum applicants. This was a problem that actually, and this is typical of legislation, it took years to get Simpson was passed in 1986. Nothing just comes fresh. There are always things that people look back to withdraw from as they produce legislation. There's almost a path dependence to a lot of the provisions and the like. So it'd be actually interesting as we talk about the various provisions over the course of the day to think about how many of them actually started somewhere else or came and turned around. And there are very few new ideas in the world. And expedited removal was not a new idea. It started back in the 1980s, actually. It was then called summary exclusion. And it was to deal with asylum applicants, primarily Haitians, and also some effort after the Mario Cubans, not to handle Cubans, but with the sense that people could, this was the problem that's here. People could come to the border, request asylum, they'd be released into the country and never heard from again. That was the INS, we then called it the INS, because it was the INS before it became DHS, etc. That was the immigration authorities' view of what was happening, that asylum was being abused, and because there was very little detention, which was a good thing for asylum seekers, and because the process took a long time, there was a huge incentive for so-called abuse of the system. And so the expedited removal provisions came out of an attempt to get rid of abuse. And I've always been pretty sure that the district director of New York spun this up and got it on 60 minutes to make the point. But the idea was that people came into JFK, asked for asylum, were released, and disappeared and never showed up again. This was a major system of abuse. Imagine if this were happening. Now, this was the pre-9/11 security days, but nonetheless, it was seen some major way into the U.S. And then the golden ventures. We were worried about Chinese boats arriving with lots of immigrants. People, again, would apply for asylum and disappear. disappear. And so the Clinton administration proposed, again, summary exclusion in the early 1990s. And then comes the 1996 legislation. And at that point, actually, Doris Meissner was Commissioner of the Immigration Service, and David Martin was her general counsel. And they argued against the summary exclusion provision that the administration had originally decided to advocate for. And so the administration's proposal was one of simply having a standby authority to use expedited removal in extraordinary migration situations. Congress didn't accept it, went back to the original Clinton proposal, actually, and this is other Clinton, wrote it into the law. So this is what we got, was expedited removal, section 235B of the Immigration Code, and it says the following, that if you show up with no documents, fraudulent documents, or you committed fraud in the past, you can be turned around at the border by an immigration officer without going through an immigration judge, without getting judicial review. Very limited judicial review was dismissed. There never was a successful attempt to invalidate expedited removal on due process grounds, which would have been an interesting set of cases. But the purpose there was to give, again, immigration officers a quick way to turn around people with no documents and not have them work their way into the system. And again, it was directed, it came out of this idea of helping to get rid of abuse of the asylum system. To protect asylum applicants, however, which the INS, Doris Meissner again, and David Martin argued strongly for, what was built into the law was a determination of credible fear, meaning that if somebody indicated that they wanted to apply for asylum or had a fear of returning, they would then be given a quick hearing to determine whether they had a credible fear of return, and if they did, then they would be scheduled for a full asylum hearing before an immigration judge. This was a way to balance the harshness of the immediate return with protection for true asylum seekers. And again, this is what the Commissioner of Immigration at the time, Doris Meissner, wanted. And I do actually remember meetings at the White House around this time. The person in the White House handling this agenda was Rahm Emanuel. Some of you may have heard of him now. And what he kept telling Doris and us was, the message is, Frank, remember this, the message is out, it's not in. And I used to think, INS officers, they hats that said INS on it, which was ins, and I always thought Rahm wanted to change that to outs and not ins. But clearly, the message of the Clinton administration. And when Emanuel became the chief of staff for Obama in for the first few years, again, the message on immigration was, immigration reform was the second term program, not the first term. It was a tough message. But it was the INS, it was Doris Meissner, who was defending the rights of asylum seekers at the time, saying we have to have a credible system that protects asylum seekers. So I think in the context, and here I guess I'm defending the work I was a part of, so take it with a grain of salt, it was not a bad compromise at the time, which was we knew we were going to have expedited removal. The Clinton administration had asked for it earlier. It had been around for a while. But built into it was a credible fear system. At the same time, the asylum office was created, and new asylum officers were there. People were being trained on asylum law. It was taken away from the district directors where it had been decided in the INS. And there was a thought that you could have a credible system that protected people's rights. Importantly, I think proof of this is importantly, the law said that you could use expedited removal for anybody who showed up anywhere with no documents or fraudulent documents. So it could have been used for anyone who entered without inspection, no matter where they were found inside the United States at any time. And Meissner limited it, the INS limited it, it was a Department of Justice regulation, but from at that point, INS was part of the Department of Justice, so it was a DOJ rule, that said, no, we will only invoke it for people arriving at ports of entry. It wasn't available between ports of entry, it wasn't available on the southwest border. So there was a clear attempt to limit expedited removal to the place that gave rise to the problem and to adequately protect asylum seekers. Well, it was assailed at the time as violations of due process and not adequate protection for asylum seekers, and I understand those comments. Anytime you have anybody being given an order of removal, based on simply an immigration officer or a quick or supervisor review. There are serious due process issues there. David Martin ends up defending this and writes an interesting article called Two Cheers for Expedited Exclusion in 2000, which is sort of, I think, the best history of what was going on at the time. Okay, so what happens? I can ramble on this stuff. So what happens? New administration comes in. There's a boat arrival in the Bay of Biscayne with 216 Haitians and Dominicans who want to come ashore, and some applied for asylum. Expedited removal didn't apply. It only applied to the ports of entry, not in between the ports of entry to boat arrival. So Attorney General Ashcroft then issued an order to extend 216. Can you imagine the world of refugees we have now? The arrival of 260 refugees in this exchange, but potential asylum seekers. So Ashcroft extends expedited removal to all boat arrivals. So anytime a boat shows up, no matter where it's stopped, people can be put in expedited removal. And then the big shift happens in August of 2004, and suddenly expedited removal applies at the border now for all persons coming across the border within 100 miles of the border who cannot demonstrate that they've been in the United States for more than 14 days. This is permitted. It's not the full extent. The law could have gone further to all entrants without inspection anywhere. It was limited to people within the border. The idea was if we see people coming across the border, we should be able to give them an order of removal and have them go out. Why? Why do you want that? Well, the order typically would happen on the south of the border. People would just turn around. They would voluntarily withdraw their applications for admission, I guess was the technical phrase. There would be no record of that and they go away. With expedited removal, you actually get an order of removal, which means there's a deportation order that says you've been here, you've been kicked out. If you come back, there's serious criminal penalties. If you do it a number of times, etc. So it was a way for the Border Patrol to put real weight behind these removals suddenly, and also to increase the statistics for the administration on removals rather than simply returns at the border. So what starts as an asylum fix on the East Coast moves to a major enforcement effort on the Southwest border. Now, in the early years, when it was just on the East Coast, it was not widely used. It was used a bit, but not what it really is now. Now we're up to almost 200,000 removals a year, expedited removals a year. Most of them happen from the West Coast. And this is 40% of all removals from the United States. So if you put together expedited removal with criminal removals on the interior, you get most of the deportation orders. It's also happened at a time when apprehensions to the border have dropped dramatically. When I was back at INS, there were over 1 million apprehensions a year. We're down to about 200,000 or 300,000. So it's a huge drop. So this idea that there are people flowing across the border, it just drives me crazy given where we were 10 years ago. There's been massive enforcement at the borders, everybody in this room knows, and the numbers have dropped 80%. It's incredible. What's gone up are these orders of removal, or because expedited removal orders are being issued rather than people simply being turned around. What's happened on the credible fear side? Well, again, there were a few thousand a year at times, but last year we were up to about 50,000 people asking for credible fear determination before being returned. On the one hand, if you increase expedited removals, you're going to get more credible fear requests. But more than that, you have the large flow over the southwest border of people coming from the Northern Triangle, Guatemala, Honduras, and El Salvador, who are claiming needs for protection in the United States, people escaping violence, domestic violence, or gangs. Some of these claims have not been well received in the Board of Immigration because nonetheless, lots of people claiming asylum, which then kicked them into a credible fear determination and made those numbers go up. Well, what was the response? The administration's view, the Obama administration's view, and here I'm quite critical of the administration, declared an emergency on the southwest border because of these people fleeing violence rather than welcoming people who should have been taken care of because of the violence they were seeing. It was seen as it was deemed a crisis because of concern about DACA and comprehensive immigration reform. The administration thought if it couldn't be tough on the southwest border and couldn't deter flows on the southwest border, the rest of its immigration agenda was going going to lose. All of that proved to be wrong for about 12 different reasons. Anyway, okay, I won't go through that. But meanwhile, the people who took the brunt of this were people on the southwest border, people fleeing violence in the northern triangle who were initially detained until the courts got involved, and then, I guess we're talking more about this, so I won't go too much more into the story. But what happened as part of this effort to deter the flow, the administration sent asylum officers to the southwest border to handle all these new credible fear determinations. And these credible fear has been granted in 70 to 80 to 90% of the cases coming through. It's a fairly low standard. It was set up that way when it was originally set up 20 years ago to be a low standard. It was consistent with what was going on around the rest of the world. UNHCR had approved a sense of claims were manifestly unfounded. That was the phrase that was used internationally. That people could be denied a fairly low process. And credible fear was supposed to mirror that manifestly unfounded standard. It's gotten tightened a little bit, but it's still considerably lower than what you need to show to actually make your asylum claim. So asylum officers sent to the border these thousands of credible fear determinations. At the same time, asylum officers were being taken away from doing asylum cases by the administration and put into the process of admitting refugees. The way the U.S. brings refugees in is they send adjudicators around the world to do refugee adjudications, trade them in, in order to show the numbers that Obama wanted to show, which is a very good thing, getting 85,000 and 10,000 Syrians, the asylum officers emptied out to the credible fear on the one hand, refugee determinations on the other side, and the result is we now have a backlog of about 150,000 cases in our asylum office. At the same time, people who were, if you're granted credible fear, if you found out credible fear, you actually don't go to the asylum office. You're kicked into immigration court before immigration judges. And there, for lots of reasons, the backlog is 3, 4, 5 years in some districts. Not really due to the asylum situation, because the asylum numbers are a fairly small slice of the overall work being done by the immigration court. But they get thrown into the backlog of the immigration court, and you now have cases waiting 3, 4, 5 years, having passed credible fear, to have a decision on the merits. So what do we do? So the unintended consequence, to summarize here, what was supposed to be a small but precise intervention in ports of entry on the east coast to deal with asylum abuse is becoming a major enforcement tool on the southwest border, and then also led to a situation because of asylum claims that has now put the asylum office in a deep hole in terms of handling asylum. So all of this was obviously unintended consequences. What can be done in the last 10 seconds? Some people say get rid of credible fear because 78% are approved. I don't think that's right. I think you probably still want that slight screening at the border for whatever discipline it shows for the system, provided it's a low enough standard. Probably you need to develop a credible fear core that is not fully trained into asylum games, but would nonetheless do credible fear determinations at the border and put the AOs back into the asylum office. And you probably ought to have people passing credible fear should go to the asylum office, not the immigration court. That's no reason to go to the immigration court since we have that backlog. And then we ought to figure out, and Eleanor will talk about this, some other form of relief for people fleeing violence in the southwest border, over the southwest border, fleeing domestic violence or gang violence, rather than putting them through the asylum process. Thank you.
Hi, so I'm going to talk about a part of the immigration law from 1996 that doesn't really follow the same story of how a bill becomes a law. I think what Alice was describing was a situation in which, different people see a problem, people see the problem differently, they have different proposals, different ideas about a solution, Congress adopts one. Maybe they haven't thought it through, maybe there are unintended consequences, but you have a sense that it was an intentional policy adopted at the time that then had whatever consequences it had. So the provisions I'm going to talk about are some of the provisions having to do with long-time lawful permanent residents. We're talking people who might have come as very small children, who lived in the United States legally, worked in the United States legally, raised families here, are often married to U.S. citizens, and who at some point have had some contact with the criminal justice system. It could be relatively minor contact, it could be more significant contact. And how the laws in 1996 changed what happens to those people. And I would say, my argument essentially is that parts of the change in that law were, in fact, part of this general narrative of people, sort of policy people identifying certain problems and coming up with certain solutions. But that these laws, and the laws that we've become familiar with over the last 20 years, have what I call stealth provisions. They have provisions that were not in the House bill, were not in the Senate bill, were not considered by either committee. They weren't thought about in terms of this very complicated immigration statute, in terms of how different provisions interact with each other. And instead what happened was that they appeared for the first time in a so-called conference committee, and I call it so-called because at the time there was a lot of anger about what happened in the conference process. And what people said at the time, representatives, was, the bill was rewritten in part, and nobody got to see it, and nobody really got to vote on it. A lot of Democrats refused to sign the conference report, which was somewhat unusual. And then when it came out of conference, this was a particular moment politically in 1996. The U.S. government had shut down earlier in the Clinton administration in the sort of the great problems of those days in the early 90s. And in 1996, there was a sense that the government could not shut down again, and that bill that came forward had to be voted on. And the immigration provisions, the entire Immigration Reform Act, got rolled into an omnibus budget bill with a day or two to look at it, and really no choice but to vote in favor of it. So what you have here is you have these provisions that appear for the first time in conference, and they become part of this statute. And I think it's important because there's a tendency to think this law was intentionally severe in all of the ways that we know it to be severe. And that is something that's found in policy discussions, it's found in the media, it's found in court cases, it's found in the government's briefs defending aspects of these laws, saying, well, Congress intended to do the following thing, and they extrapolate this from the fact that a provision is in the bill and that there was a general intent in the bill to address certain issues. But the specifics of what that bill did were actually not something that could really fairly be called a congressional intent. So I think it matters. And it matters in litigation, I think, because I think this sort of legislative process underscores the need for a rule of lenity in interpreting immigration statutes. Because the political economy of changing laws having to do with immigrants who've ever had a criminal conviction is very similar to the political economy with respect to criminal justice issues. And the very same reasons that you would want to make sure that the harshness was really intended by legislators, I think carries over to these provisions. So let me give you a couple of examples. So maybe the biggest change was on restrictions on relief. So it used to be before '96, as anybody who does immigration law knows, that people who had a criminal conviction, unless it was a fairly serious conviction and they had served 5 years in prison, were eligible to go to a hearing in front of a judge who would decide whether they should be allowed to stay in the country, looking at all the possible factors, including things like being a veteran of the U.S. Armed Services and other things like that. So the 1996 laws closed that off for anybody whose conviction was labeled as an aggravated felony, and eliminated the idea that your sentence mattered in any way and whether you got this relief hearing. Well, I think notably, the bills that had been passing through the House and had been passing through the Senate closed off relief only for people who were sentenced to 5 years. They changed it from served 5 years to sentenced to 5 years, but what actually came out of the committee was one that just was based on the aggravated felony label. Now, this can be partly defended as part of this legislative process because in the middle of 1996, in the Antiterrorism and Effective Death Penalty Act, which was the bill sort of rushed through Congress while these immigration bills were in committee, there had been a provision like that about the aggravated felony definition. But the thing that was really different in the fall of '96, when the big comprehensive law was passed, was that that law also included provisions that changed the definition of aggravated felony in really big ways. So, before this Reform Act, the aggravated felony definition, it's a weird definition. It's got lots and lots of things in it. It doesn't require that it could be a felony. It doesn't require that it be aggravated. It's this very odd basket of offenses. But before the Reform Act in '96, a lot of the provisions required that you had been sentenced for 5 years. So in a sense, it was sort of redundant to this restriction on relief as these bills were going through Congress. But the Reform Act, as it finally came out, put in a provision that was in the Senate bill, not in the House bill, which had that changed a lot of those thresholds for calling something a so-called aggravated felony to a 1-year sentence, and also made lots and lots of other changes. So nobody ever thought about in any committee anywhere, as far as you can tell, unless they thought about it in this conference committee, which was a very sort of questionable process, what it meant to use this incredibly expanded definition of which crimes would suddenly be called aggravated felonies, which have since been a label applied to misdemeanors and all kinds of other things. Nobody thought about what it would mean to use this incredibly expanded definition and then cut off relief from removal. So, I mean, this example of how those two things work it's an example of something which sort of seemingly went through the legislative process, seemingly was responsive to these different bills, but where the interaction of these two provisions, as they ultimately came out of the Reform Act, had never been before any legislative committee. It hadn't been before the House committee or the Senate committee. It hadn't been debated on the House floor or the Senate floor. It just hadn't been there. And it was something that came out of the conference committee bill and was very, very important. So that one, as I say, was sort of in the prior legislation, but had consequences far beyond anything anybody had explicitly considered in the House or the Senate. But then there are some that just appeared for the first time in the conference report. So, as an example, today, the Supreme Court is conferencing on a case called Esquivel-Quintana, which is about where there's a clear split in the circuits, which is about really the breadth of this new aggravated felony category from 1996 called sexual abuse of a minor. Sounds like a really bad crime, and so the question is, what did Congress really mean? What kinds of crimes did they mean to include? Did they have a concept of, did they mean to include strict liability crimes? Did they mean to include crimes of older teenagers and people not that much older than them? Did they mean to include all of those crimes when they added sexual abuse of a minor into the aggravated felony definition, and then made that per se grounds for not being able to have a relief hearing? And it's both deportation, and you don't get a relief hearing. It doesn't matter how long you've lived here. It doesn't matter what your legal status is. It doesn't matter if you speak the language of the country you go to or all the rest of that. So that's in front of the Supreme Court. Well, how did that provision get in the law? Well, it wasn't in the House bill that came out of committee. It wasn't in the Senate bill that came out of committee. The whole idea of adding this deportability ground, which was largely a redundant ground. I mean, most serious offenses that would be included in this ground, would potentially be considered crimes of violence or crimes involving moral turpitude or other things that are already in the immigration law. But they added this ground. It was added by floor vote on this amendment in the Senate. But it was added as a deportability ground, not as a bar to relief from removal. It was not added as an aggravated felony. Well, that Senate, that conference committee, whatever was written up by the staff, just felony definition, proceeds to the Senate, sounds like the ordinary process of give and take. Then it says with modifications. Well, the modification is taking this provision and turning it into a mandatory deportation ground when neither the House nor the Senate had proposed doing that. So that's the history of that provision. And it's an example of one of these ways in which the conference just did its own thing. So when you have something like, you have the Solicitor General in their opposition to cert in the case being considered today, when you have them say, Congress, by putting this in, intended a comprehensive scheme for addressing this, they're making that up. That's not there anywhere. It's just, yes, it's a statute, it's a provision, that's the text of the law. You have to deal with the text, but how should it be interpreted? But there's no showing that that's what was meant. So a couple of other things. For anybody who teaches immigration law, some of the most absurd parts of the law are things that came in this conference committee. So for example, if a lawful permanent resident takes a short trip out of the country and comes back, under pre-96 law, they were treated the same for deportation as if they'd never traveled. And under the law as proposed by both the House and the Senate, they would have pretty much been treated the same as if they hadn't traveled. But in the committee, they added these provisions that basically say, well, if you, and just to give an example, a single violation of, a small amount of possession of marijuana is not a deportability ground. It is and what's called an inadmissibility ground for people starting to come into the country. Well, they changed the law to say, well, those people now would be subject to removal just because they traveled. That wasn't something that the House thought was a good idea or the Senate thought was a good idea. It was something thrown in there by the conference. Another example. The House and the Senate were concerned that people were stringing out their immigration proceedings and to make themselves eligible for relief. So they said that the law requires that there be some period of residence to be eligible for certain relief. We'll stop the clock when your immigration court case starts. That was in the House bill and the Senate bill. Well, lo and behold, in the conference report, they added the idea that for people, these lawful permanent residents who've been here a really long time, the time they had actually committed the offense, like that small drug offense from 15 years ago or whatever, that was now going to stop the clock. And a lot of courts now say, well, that stops the clock, and it stops the clock retroactively to before 1996. This whole idea that you could stop the clock based on an offense was just added by whatever staffer was in that room and wrote that into the final bill. So how do you interpret that? How broadly should courts interpret that? I think that this legislative history is pretty relevant. And then two more examples. The House in '96 decided to codify a rule called matter of Oscott, which was something about how do you treat, expunge convictions and things like that. What should the test be? They tried to codify it with a set of rules. Well, the Senate had no provision on this, and the conference just said, well, here's a three-prong. So they just slashed out that last prong and left it as this new definition of conviction. But the government now goes around and argues means that even a conviction that's on direct appeal to the courts should be considered a deportation ground. And here was, something that happened in conference to try to overturn this. Basically there were a couple things that were designed to overturn BIA case law that these conference people didn't like. But, it's the opposite of what that. The House was codifying a rule from the Board of Immigration Appeals, and the staff person in conference was doing the exact opposite. And another one just like that, neither house had anything to say about suspended sentences. A lot of states in the United States use a suspended sentence instead of probation as a way of sort of saying to somebody, yes, you're convicted, but we're going to give you a year to show that you're behaving properly. They give you a suspended sentence. Well, that conference report inserted a provision that wasn't in either the House or the Senate bill that said if it's a suspended sentence, it's exactly the same as a sentence that you were that was imposed to be served. And then that rolls back to the thing I was talking about at the beginning, because a lot of these aggravated felonies, so-called aggravated felonies, depend on a one-year sentence. And the conference decided to say, well, that'll even be these suspended sentences where nobody served a day in jail. So these last two about conviction and about the conviction definition and suspended sentence, I didn't even know about until I was getting ready for today. I mean, I found a lot of these other ones before, and so I thought, well, let me just look into a couple more. This is no comprehensive look at what happened in that conference committee. It's just the few provisions I bothered to look up. And therefore, I can tell you that as to any provision, if you're a litigator, as to any provision that you're litigating, I recommend going back and seeing how that provision got in there, because the government litigators will be saying, oh, this was part of a comprehensive experiment in severity that was being done in 1996. Whatever it was being done by whoever managed to get that language into that report on a bill that was must-pass legislation.
Thank you very much to Dr. Callahan. Is this working? My voice will get markedly animated. So I'm actually worried. But okay. Well, I wanted to thank Professor Callahan and the Drexel Law Review editors for inviting me, because my area of academic research is a little bit outside of the immigration field generally. In fact, over the last 10 or 11 years, I've been looking into the laws and procedures that govern criminal prosecution of individuals suspected of being terrorists in the United States, so federal terrorist prosecution. Now, the criminal area does overlap with immigration to a significant degree, or a not insignificant degree when we're talking about national security. Specifically here, something I'm going to talk about in the second part of my remarks, this concept of material support to a terrorist organization is something that I've been, I used to litigate about it, and then I've been writing about it and researching it for well over a decade. And that's something that these 96 laws brought to us, both as I mentioned, basis for criminal charges, but also as a basis for exclusion and or deportation, or removal as it's now called. But before I talk about material support, I wanted to say a few things about secret evidence in immigration cases, because that also is one of the bigger kind of national security areas, that the national security implications of these 1996 laws. First of all, I want to recommend Professor Ramji Nogales' excellent article from 2008 in the Columbia Human Rights Law Review for a thorough treatment of the subject of secret evidence, which I am not going to give, so I should say that. Because I think it remains, having looked at this issue for some time, I think it remains the leading resource on the matter, the leading scholarly resource on the matter. So that's the first thing I should point out to you. The second is that the 96 laws, specifically the horrifically named Illegal Immigration Reform and Immigrant Responsibility Act, or IRIRA, or whatever I heard some talk about how the acronym is not settled. Yeah, I better not comment further. That provided regulations that allowed for the use of secret evidence in removal proceedings where the non-citizen is perceived by the government to be a threat to national security. And those regulations were actually used, those regulations governing the use of secret evidence and secret evidence itself was actually used in several cases in the late 1990s after the passage of the law, 2000s, and the pre-September 11th period. It's kind of notable cases that people read about, heard about, litigated, all of which I believe, by the way, involved Arab non-citizens or Muslim non-citizens. And the only federal court to rule on the issue found that the application of the regulations violated due process, but it didn't rule on the constitutionality of the regulations themselves. That was in a case called, this happens a lot, by the way. The guy's name is actually Severity, but it was rendered into English as IRLD. Okay, and in that case, by the way, the secret evidence turned out to be from the non-citizen's wife, who she had divorced, and she later was revealed that probably fabricated the terrorism allegations against her. But anyway, the most maybe interesting thing to point out here, the third and final point, is that the 1996 laws, this in their EDPA, or Antiterrorism and Effective Death Penalty Act version, created something called the Alien Terrorist Removal Court, which was supposed to govern the procedures when the government wanted to use secret evidence against non-citizens it believed had terrorist ties or were terrorists themselves. And that process had provisions for the use of secret evidence. And this is most interesting, I think, because the government never activated the Alien Terrorist Removal Court. It's never used it to this day. Now, in the pre-September 11, 2001 period, I want to tell just a minor or a very short story here about what could have happened to secret evidence, because there was pending in Congress at the time of the attacks something called the Secret Evidence Repeal Act. Now, I worked on a case as a criminal defense matter, which involved the main defendant, or the sort of marquee named defendant, was a fellow by the name of Samuel Ariane, who had been a computer science professor at the University of South Florida. And this was quite a big case in Florida. It's been in the media quite a bit. In fact, in our conceit, both the prosecution, the federal government, and the defense alike to boast that this was the biggest terrorist trial in the United States history up until that time. Whether or not that's true, I don't know. But we said it anyway. In any event, before the criminal case was initiated, before there were indictments issued, Samuel Ariane's brother-in-law, a fellow by the name of Mazen al-Najjar, had been detained on the basis of secret evidence that he was involved with terrorists. And Samuel Ariane, who happened to be, as I mentioned, I think his brother-in-law, started to advocate on behalf of his wife's brother to stop the use of secret evidence in these immigration proceedings. And interestingly, because he was a big figure in the Florida and nationally as well, Muslim community, American Muslim community, he was favorably impressed when then Governor George W. Bush, during one of the debates with Vice President Gore, said he was against the use of secret evidence, and if elected, he would get rid of it. He would stop the use of secret evidence. So Samuel Ariane helped organize many of the Florida Muslim community to vote for George W. Bush. So this is a kind of a forgotten footnote in the history of the 2000 elections, that the American Muslim community, which I'm pretty sure ended up regretting that vote, voted in the majority for George W. Bush. I also make this Professor Ramsey Nogales talks about in her papers that we don't know, especially in the post-September 11th world, where the practice has kind of exploded, although there isn't much data at all about the use of secret evidence in immigration cases with a terrorist event. But we presume that it's quite significant. And much of it creates inaccurate information and generates, as a result, fairness concerns. Well, the interesting thing here is, in the case of Mazen and Najjar, to show you that, okay, I'm a former public defender, I write about terrorism prosecutions, and I think the government has exaggerated a lot of the claims. So I say that so you take this next bit with the caveat that I provide. But I would say this, it definitely provided a great deal of points to argue for the defense in the Iranian terrorism prosecution, in which there were 4 defendants, one of whom I represented, not Samuel Ariane. But Mazen Najjar, his brother-in-law, was finally, after being held on and off for more than 4 years, deported in August 2002. And the indictment in the case came down in January in 2003. And the government later superseded the indictment. That is to say, they issued a new, updated version of the indictment based on a lot of errors that we pointed out in the original indictment. So that's, you do that at your own peril if you're a defense attorney pointing out errors in government indictment. But in the newer version of the indictment, Mazen and Najjar, who had not been listed as a defendant, right, was now a defendant in this supposedly most important terrorism trial where people were looking at life sentences for very dangerous terrorist activity. So it was kind of almost like what you'd call an own goal for the government, because now we can say, well, here they had this guy for 5 years, and they held him on the basis of this evidence, secret evidence, and now they've sent him away. He couldn't really have been that dangerous, could he? So it underscores, I think, the idea that that when you start down the path of using secret evidence like the government has done, frequently accuracy concerns are at the forefront. And I think one other point to make here is that secret evidence in immigration proceedings has served, and this is a point I can't really flesh out right now, but it's served in its own small way as kind of setting the legal framework towards what we saw initially proposed in the military commission's procedures and regulations that were to govern the prosecution of the Guantanamo detainees. Now, segueing into the material support context, in the criminal setting, in 1996, Congress became concerned that terrorist groups were raising money under the cover of humanitarian activity in the United States, so they closed what they saw was a loophole that allowed them to do that, on the theory that money is fungible. So even if a terrorist group has legitimate humanitarian activities, money for charity frees up money for weapons. Money is fungible, that was the idea. And to that end, it banned the provision of material support, money, but also things like weapons, tactical equipment, etc., to what the State Department would designate as a foreign terrorist organization, or an FTO. There are three prongs to that. The group has to be foreign, it has to engage in terrorist activity, and that terrorist activity has to threaten the United States nationals or the national security of the United States. The national security is defined quite expansively to include things like foreign relations interests of the United States. And you can't challenge that last designation in court. And interestingly, there is no corresponding domestic terrorist organization, just the foreign terrorist organization. There are currently 60 groups on this list. And support is criminalized to the point where someone who's convicted of providing material support to an FTO can go to prison for 20 years. You've seen it probably, if you followed it at all, you've seen it more recently used in these ISIS cases where the government usually sends an informant to pick on someone, usually a sort of a sad sack individual, who supposedly is right on to get on the plane to Syria to go fight with the Islamic State, and then the FBI naps them. This is, in the last 2 years, been growing. There's been almost 100 cases like this. One more point here about material support is that we initially envisioned it as money or kind of tangible support. It's now gotten to be much more than that. It's actually become, in 2010, the Supreme Court said in a decision called Holder versus Humanitarian Law Project that material support in the form of speech can be actually banned and prosecuted under the statute. It doesn't violate the Constitution. In another prosecution called the United States versus the former directors and executives of what was then the largest Muslim charity in the United States, the Holy Land Foundation for Relief and Development, the defendants were convicted on a theory, and the Fifth Circuit affirmed this theory, of providing material support in the form of legitimacy. That is to say, material support to charities that were not a front for a terrorist group, but that were associated in the public's mind, that is the public in that case in the West Bank and Gaza, with a terrorist organization, the FTO, Hamas, the Islamic Religious Resistance Movement. That does not offend the Constitution either. So not money is fungible, but money that creates the or of legitimacy for a group can also be banned with material support. So we've gone way beyond just material support as money is fungible, etc. Now, to get to the immigration context, material support serves now as a kind of a basis for exclusion and a bar on asylum and discretionary withholding and Convention Against Torture relief. And the interesting thing is, in the immigration context, it's not limited to that FTO list. So a non-citizen who tries to claim, say, asylum and withholding and cat relief would be barred from that relief if they provide material support to any group of 2 or more people using violence for political purposes. Okay? So it doesn't matter how sympathetic the facts are. So there's a case that I've written quite a bit about over the years, a 2006 decision by the Board of Immigration Appeals called In Re SK. That involved a young woman who had been providing, I think she ended up giving something like $700, $800 to the, I'm running out of time, power through. Okay, who had been providing money to the Chin National Front. The Chin are an ethnic group in Burma who were fighting the Burmese junta, at the time one of the most repressive governments in the world, that our Congress had issued numerous declarations on how horrible they were. She was supporting a group fighting them. But the BIA said, well, the law is written broadly, and she was supporting a violent group, so she can be excluded. And, well, she wasn't excluded, but she is barred from obtaining asylum on the basis of providing material support to a terrorist organization. Just recently, in June of this year, the Board of Immigration Appeals also decided that there's no implicit exception to the material support bar in cases where the material support is provided under duress. In a case involving a woman who claimed that she had been forced to give material support to the Colombian FTO, the FARC. Now, this is very interesting, especially in terms of the current Syrian refugee crisis, in terms of how broadly material support is construed. Because if we take it to its logical conclusion, the law basically says that any non-state violence for political purposes is de facto terrorism. Okay? And so arguments about the justice of a cause, that's just illegitimate. It's irrelevant as the law is written. And if the government wants to get around it, it can just issue a waiver, like it did in SK's case. It basically said, well, yes, she's barred and this was material support, but she's not really such a big threat, and we have a waiver. It's interesting that the government can grant waivers in cases with terrorist overtone. It's a little bit different in the criminal context, and maybe I can talk about that a little later. I don't want to go deviate too much, but this is certainly a far cry from the pre-9/11 situation where you might see in a political asylum case issues about the justice of a cause or justness of a cause being adjudicated and litigated, whereas now that possibility seems foreclosed. So I'll stop there.
Thanks very much to the panelists. Someone who's listening to the live feed asked if we could speak into our microphone because they're having a hard time hearing. I'm going to open up for questions. I'm first actually going to ask the panelists if they have questions for each other, and then open up to the audience.
Well, I have just one tweet to Nancy, probably, but I would ask for Frank's help, and I think Mike left the room, but on this is that what you described as a game that everybody plays, and the Republicans have been in charge of the Congress for a while, but Democrats have very frequently tried to use staffers to put in their particular favorite provisions. So I assume you're not assailing the legislative process, the political process. I think what you're commenting on is that as lawyers do this work, they should occasionally call to the court's attention that if the court wants to treat a provision in a particular way, that to talk about the provenance of the provision may be a helpful tool. But that just then goes basically to the jurisprudential point about statutory interpretation, which is we shouldn't be looking at these micro legislative history moments in any event, in any decent system of statutory interpretation, but rather the overall purpose and the meaning and flow of the statute. So it's sort of a layered set of comments. But comment.
So, yeah, of course, legislation is sausage making, and absolutely what everybody says. I guess I think this is relevant for a couple of reasons. One is that you often see the court trying to discern some great pattern in a statute and assuming that things were really carefully considered. And so I think it's relevant to the degree to which that's an appropriate thing to be doing. I think it does, it is striking that despite, that when people litigate these issues, they don't litigate them as though it's only about looking at the words of the statute. I mean, the government certainly brings in legislative history to sort of support the idea of a maximalist interpretation of these provisions. And I think knowing a little bit about how they came about and how well the interactions were considered is relevant in terms of like the strength of that congressional purpose. But I also think it's important doctrinally for issues like the appropriateness of the rule of lenity, something that the Supreme Court has never backed off the rule of lenity in immigration cases, but it often doesn't really apply it. Last year in the Luna Torres case, the opinion was a case about a particular new aggravated felony ground from 1996, and the opinion is full of sort of presumed intention of Congress, which I think doesn't really match sort of the history of how all of this happened. But I also think it's very relevant in the ongoing legislative debate. I mean, I think that if people in Congress today realize that this was not a carefully thought through piece of legislation, they might be a little bit more willing to revisit some aspects of it. I mean, what's so difficult is that, when immigration reform happens, it happens with a lot of issues on the table, and it's very hard to advocate for humane provisions related to people who have ever had any contact with the criminal justice system. But I think this maybe is one more thing that might help make the case that nobody ever really thought through in a considered way, barring this sort of full equity relief for such a huge swath of lawful permanent residents who've shown full rehabilitation, where deporting them means their kids. I mean, literally, these cases, and we see them in our clinic, case after case in which somebody's been, whatever problem they had in the past, they're now at a job, they're having a family, everything's going fine, and there's a knock on the door at 5 in the morning, and there's a police officer saying, we're looking for some criminal in the neighborhood, and they want to be helpful, and they open the door, and then the ICE officers, the immigration officers come in and say, but guess what, that's not who we are, we're ICE officers, we're handcuffing you in front of your family, we're taking you and putting you in detention, and then people have a very hard time getting relief, but when they get out of detention, and I've had like 4 cases like this in the last 2 years, and we don't have that many cases in our clinic, they've lost their home. Sometimes, the family, the children have suffered terribly, and was this really intended for such a wide spectrum of offenses? I think it matters if you think nobody ever really meant it to be that way, except whoever was in that very last process.
Thank you. Lenny?
I'm going to shout it out, I hope. Alex, when you were sitting in the meetings with Meisner or with Martin and saying we can apply expedited removal across the whole country, I disagree with you. There's a constitution. And I also think I always read the case Yabatai and Fisher in 1903 to say that there's the difference of the territory. So when I teach this material, I say how generous the regulations are, that they incorporate some constitutional dimensions. So thank you for that. But do you want to cut back on your statement, Congress could have applied expedited removal across the whole country?
No, I said the administration could have.
Right.
Congress wrote the law that broadly. The administration could have tried to, it would have been subject to a constitutional challenge. But I don't believe in I don't believe in the line of the border in any of that. So the administration, the INS never took the position it should be. Certainly, David and I would have raised the constitutional question if it had been attempted to be applied inside the country. We would have done that. But it was never the kind that Congress could have done it. The language permits it, it wasn't adopted. So I'm agreeing with you, correct, but yeah.
Okay, just to come back, the
Yeah.
judicial review problems, which I'm sure we'll talk about
Yeah.
as well, and now the most recent loss in the Third Circuit, which I hope someone's going to speak about, where now even habeas cannot be raised or maintained, and it's not an unconstitutional suspension. The vestiges of this harshness in the 1996 Act, trying to raise a due process claim, it's just so difficult. So I guess what I was hoping for the students in the room too is to know that when government lawyers see statutes that go too far, they say, but we can't apply it in a way that would be unconstitutional.
Yes, should I repeat that?
Yeah, so repeat that, what I'm thinking.
No, I mean, the government, yes, I mean, the government lawyers, had there been an attempt, interesting question, if there had been an attempt by the administration, if the president, the White House had called and said to the Attorney General, tell your Commissioner of Immigration that we want to apply expedited removal inside the country, what would have happened? It's a long time ago, and I don't know, I would like to think what I would have said is we will not do that, and we will resign if you ask us to do that, because that would be unconstitutional. But I think the Clinton administration would have gone to OLC, and they would have been told they couldn't do it inside the country. I hope, yeah.
Other questions from the audience?
I have a question for Professor Lindenbach regarding, I think, your statement about the importance or the possibility of creating an asylum corps or some kind of new corps. I'm curious what your thoughts are about where that corps should be located and what the role of Border Patrol should be in your vision for the credible fear.
Yeah, the suggestion was, I don't think at this moment that, we're not going to get rid of expedited removal. That's just not going to happen. So there has to be some protection of asylum seekers you get, and I don't think you'll get rid of credible fear. I think people will view that as too much of an easy way into the country. So the credible fear is a very small screen, but still I think symbolically it's an important screen. I don't think you need asylum officers to do that. They should be handling asylum cases in the asylum office. So I would create a new corps, credible fear corps, that could be trained more easily because most of these cases pass. You don't need to know every detail. Asylum officers, the federal asylum law, nobody's on them. That has a credible claim. Where that should be located is the question. I actually when I was at UNHCR, I lobbied with DHS on this point, and the question was, and we volunteered to train people at the border to do credible fear and to monitor their use of it because we felt this is important asylum protection. And the question was, I think I suggested it's kind of something like this, that there was an answer back from the government, well, maybe it's better to have the Border Patrol do this and for them to learn how to do this properly so that they then begin to inculcate these norms. And that can go either way. It depends on whether you think you can actually train Border Patrol folks to be good on these issues or whether you think you need an independent group there. And I would want to think that through and hear both sides. But the main point is to get this away from asylum officers so they can do asylum cases and get the backlog done there, but reserve some role for credible fear. I think, I'm still sort of thinking this through, so a suggestion as well.
So I have a question regarding what kind of judicial review might be available for fear, whether you think there should be some judicial review, what the layers are now, and what for those who are not.
I'm just going to repeat the question for those who might be in the audience. So should there be judicial review for credible fear? What should that look like?
Yes, some real lawyers in the room here maybe are answering that. I can tell you from the policy perspective on that, since the vast majority of people pass credible fear, you've got to have to do sort of do a Matthews versus Eldridge balance on the due process side, but also put you on the policy side. If you added a layer of judicial review, would you make the process so expensive and burdened that people would want to get rid of it in some way? Or are the number of cases that would be killed so small that it wouldn't actually be much of a burden but would provide one additional level of protection? I'd want to think more about that and know more. But as I said, really smart people who thought much more about this and may want to say something about this.
Yeah, well, I don't, this isn't really my area of expertise, asylum issues, and so I won't speak to the administrative review, but I would say that, it is very important to retain access to the courts in the form of habeas, and what Professor Lenny Benson was speaking about before is very troubling if there is action by federal officers that deprives people of liberty and is subject to no judicial review at all. That raises very serious constitutional questions, about suspension of the writ of habeas corpus. And so it is, the access to some sort of court review does seem important, especially, if they're, yes, if the system's working fine, it seems like, well, there isn't a problem, but what about those cases where it isn't working fine? And, I think habeas corpus has a very, very long history in this country of being a check on what was happening right at the border as well as in the interior.
Yes, and sorry, can you briefly identify yourself for asking a question?
Sure. David Bennion, district attorney. I wanted to follow up on the question about credible fear. There's Border Patrol CBP is often, there have been reports that they're not properly referring cases for credible fear. They're not properly screening applicants or people coming up. And it's, at least in at the Tijuana border, or port of entry down there have been reports recently of it developing beyond that to the point where CBP is, or Border Patrol is, allotting 50 tickets per day for people to come to present themselves at the port of entry. And they're collaborating with Mexican authorities to basically stop others. There are Haitians and others who are sort of amassing in Tijuana. Is there any remedy for that? Is this really taking place before they even get to any position where they would have access to the court?
I think it's
Sorry, let me just repeat the question. Sorry, so the question was, I think it would be OFO, right, is, by the MPP, is at the border, whether there's any remedy for restrictions on allowing people to access the credible fear process.
Yeah, I think it's a really good question. I didn't get a chance to mention this, but I agree that I think there are two things happening that are problematic. One is on the referrals. Are people, people express a fear, they actually getting the credible fear determination. It's true on the boats interdicting people in the Caribbean, how many people pass the so-called shout test and actually get taken into the fear by the Coast Guard, virtually zero. So I'm skeptical of those numbers, and I'm skeptical of what the Border Patrol is doing. And I and David Martin, in his 2000 article, which basically 2 cheers for expedited removal, talked about the need to monitor that referral process. I think that's right. There needs to be some monitoring, some way of what the Border Patrol is doing so that people can get credible fear. But even take this one step back. Think about the U.S. action, not at the southwest border of the United States, but at the southwest border of the southern border of Mexico. And it's quite clear that the reason the flow went down to the U.S. in part was because the U.S. was financing and putting pressure on Mexico to stop the border that traveled through Mexico. And that was justified by saying people from the Northern Triangle face incredible hardships coming through Mexico. Absolutely true. Smuggling and trafficking and victimization and the like. But nonetheless, an awful lot of our immigration enforcement has nothing to do with anything in this 96 law. It has to do with operations overseas that pushes the problem back further so we never even see it. Right? And so I think there's got to be, there's no judicial review with that. I mean, that's an issue of politics and political pressure and probably trying to come up with some kinds of remedies in the region that find ways to bring people in who have serious claims of violence and the like. So you're right that you got to get to credible fear. There are lots of ways to go and prevent that.
I think we have time for one more question. Any last question? Yeah, Joe. Sorry, Joe Family.
Hi, Joe Family from Widener Law Commonwealth. Nancy, I was wondering if in your research you came across any more details about what exactly happened during the conference. like Jaya and Anil, I was still in law school at the time, and I've always sort of wondered, what actually happened during the conference. I know you said some Democrats refused to sign the conference report, but when it came out of conference, was the scenario just that there was, no way for people to object? I mean, did people make a big stink about this, or did it just happen so fast?
Let me just repeat the question briefly. So Joe was asking Nancy if she knows what actually went on in that conference. You're applying the law.
So I don't know exactly what went on. I know some rumors about what went on, but Barney Frank was a very, very active congressperson on these immigration issues. At the time, said that he had really pushed in the House for an effective date provision that would prevent all the retroactivity of the law. And that was in the House bill. There was that whole effective date provision. And he spoke immediately about the bill when it sort of came out of the so-called conference because there were a lot of provisions that didn't have that effective date. They had essentially instead retroactivity, and then of course we had 5 years of litigation about the retroactivity of eliminating relief. But there were lots of other retroactivity provisions. So there was talk immediately, and there are articles in the Hill and so on about how the conference hadn't met, that Democrats said they hadn't been able to see the legislation, and that it was an irregular process. I'm not enough of an expert on legislation to know how unusual this was, because obviously there's a lot of swapping of provisions that often happens at the conference stage. But what happened here was really quite massive, especially when you took a provision that didn't exist in one bill, existed in the other bill in one direction, and then flipped it to be the opposite direction, or added like totally new things. I mean, those things happen. Usually when they happen, if the bill comes out, it then has to go back to the House and Senate floor, and people can object, that something strange happened in conference. But when a bill gets wrapped up in an omnibus budget bill, the stakes are just very, very different. And obviously that's also happened in ways that have been advantageous at times on immigration issues, and other times when it hasn't been advantageous. But I just think that these provisions, because they involved, there was basically nobody advocating for this constituency. There were people advocating on the one-year bar. There were people advocating on splitting the bills about legal immigration and illegal immigration. There was nobody advocating about the immigration provisions. A lot of things that came out, nobody expected, before they actually came out. So, I mean, maybe I shouldn't say there was nobody advocating, because I know there were some discussions on some aspects of it, but so many things happened when the staff got involved in tinkering with the law that they weren't really sort of something that involved real discussions by policymakers. And what we've heard is the rumor is that there was somebody detailed over the conference committee from the Office of Immigration Litigation or someplace like that, who knew specifically that what they were trying to do was overturn this precedent and overturn that precedent, and just generally make things harder. I don't know whether that's true. But that sort of thing is what people think. Because obviously, whoever was in there, some of these things I think were unintended in the sense that the way things interacted, I don't know that anybody ever thought it through. But some of these things, like on the conviction definition of the suspended sentences, were extremely intentional with, passages in the conference report detailing that they mean to overturn a matter of Oscok, they mean to overturn a matter of Castro, where, what you had in the bills coming into the conference were codifying Oscok and not mentioning Castro. So, that's what happened.
I think Alice might have
That's
something.
right. So these discussions bring back all sorts of repressed memories. And I'm have to go lie down at this session. But on this last point, I don't know about the conference, but I do have a very strong recollection now of, so the Office of Immigration Litigation is in the Department of Justice. They represent the immigration authorities in the courts of, in the BIA, in the courts of appeals. And the immigration guys did the lower court hearings. Nancy's exactly right. Oil, as we call it, without standard immigration litigation, was quite restrictions, more than the INS was. There were times when I had fights with oil when I was general counsel with INS, thinking they had taken too restrictive a position, because they had basically two views on legislation. One, if there's no jurisdiction, and if there's jurisdiction, there's plenary executive discretion. That was the two major arguments. And we actually thought there should be limits. We thought there were reasonable limits on what on this particular case, there in fact was a member of oil who was sent up to, was invited up to the House, to the committee. I'm not sure the House or Senate, but the Senate was Republican at that point, the House was Democratic, I'm trying to put this back. But one of the committees to advise on the bill. And we heard about CINS, and I'm almost certain, I can't be exact, but I'm almost certain we wrote a letter objecting to this oil lawyer being taken up to the Hill, because he did exactly what Nancy described. They had a long list of BIA precedents they wanted overturned. And they went down the list on these in very particular ways that no one on the Hill would have understood it going. And I'm quite certain that that's responsible for most of what happened. And this was our Department of Justice sort of going against the wishes of the Immigration Authority. I don't know what the White House thought about this, to make their particular litigators' points to the Republicans on the Hill. I thought it was scandalous at the time, but there it is.
Well, I just want to say a huge thank you to our panelists for their
So we'll take a break and resume at 10:15 as this program educates.
delighted to be here to moderate. I get to be here with old friends, people that I co-counsel with, have co-counseled with, and people that I've admired for many times. Also, 1996 legislation was actually a very formative time in my legal career. Like others in this room, I was in law school, but I was in law school in DC and working for the ABA Center on Immigration. And while I've been hired to do language access work, I ended up doing all of this stuff. And ended up, I wrote a memo on the unconstitutionality of mandatory detention. I sat in DC at the ABA waiting for the call from the Hill that a vote was going to happen or not happen. Finding out, hearing rumors that provisions might be in the bill, might not be in the bill, and scrambling. And at the same time, representing an individual in a law school clinic in asylum proceedings. And getting asylum from my client and losing on the Hill. Sent me in the direction of direct legal services and as far away from policy work as I could possibly go. But I'm happy to be back and part of this as folks continue to fight the fight on mandatory detention and many of the other provisions of the 96 legislation. So we have a great lineup here. Lucas Guntag, who is a professor of practice of law at Stanford. Eleanor Acer, Senior Director at Human Rights First. Jason Cade from the University of Georgia. And Becky Sharpless at the University of Miami. And I'm just going to let them jump right in and we'll have time for discussion.
Good morning, everyone. I'm going to stand here. And thank you very much. Thank you to Professor Callahan for organizing this and for this extraordinary opportunity to reflect on the 1996 law. For many of us, it's a trip down memory lane, although, as Alex pointed out, not necessarily particularly happy. I want to start first. I'm currently working at the Department of Homeland Security as Senior Counsel and Secretary. And I want to emphasize, and I need to emphasize, that I'm here in my personal capacity. I'm not speaking on behalf of the department. I'm not here in my capacity as an employee of the department. And likewise, I can't really speak to, because of that, the current policies of the department. Nonetheless, I can listen to any comments made about the department's current policies. So, with that introduction, I've been asked to reflect on the INS versus St. Cyr case that we litigated, that I argued in the aftermath of the 1996 law. There are obviously, as we've already heard, incredibly broad aspects of the so-called IRA, the mushrooming of aggravated felony definition, the creation of expedited removal, the enactment of the 3 attainable bars, the imposition of mandatory detention. There's just a broad array of issues that essentially frame the contemporary enforcement regime. My focus is on the judicial review, or what we call the court-stricken measures enacted in the 1996 law, the extent to which Congress tried to limit or restrict or eliminate the role of the courts in the immigration, in the oversight of the immigration process. And there are a lot of aspects to this, and the outcome of a lot of litigation, including St. Cyr, is significant on its own terms, but I'm not going to get into sort of the legal, technical aspects of the case, although some of us find it fascinating. More, I want to talk with the hope that, the experience that we had with regard to St. Cyr and that litigation can provide some helpful or useful insights into some contemporary strategies and issues. And the key thing for me in terms of reflecting back on the case, and also in terms of how we thought about it and the issue really more broadly at the time, was that this was a huge collaborative and multi-pronged effort to present the issue and to address what really was a kind of stunning and sweeping effort by Congress to stricter courts of jurisdiction. Not just with regard to the issue of final orders of removal, which ultimately with regard to persons convicted of crimes, but more broadly, the restrictions on class action litigation, the restrictions on review of expedited removal orders, and then, of course, the restrictions on the final orders themselves. Many of the people that you've heard today and many others, Anil himself, Mike Wishny, who you're going to hear from, Nancy Morowitz, who you've already heard from, were deeply involved and engaged in this collaborative effort in the litigation. In 1996, I was leading the ACLU Immigrant Rights Project, and at that point, the project was actually relatively young. And what we had been doing and focused on, in my view of the Immigrant Rights Project, was really to bring the strategies of the civil rights movement to the issue of immigrants' rights. And that meant principally doing class action litigation. And that's what we've been doing for the preceding roughly 10 years. Big class action litigations on behalf of refugees representing hundreds of thousands of Central American refugees who were denied a fair asylum process that ultimately led to the American Baptist Church's settlement. Other class action cases with regard to the adjudication of asylum, 20,000, 30,000 class actions, other kinds of litigation of that sort that was addressing systemic issues and doing affirmative litigation. The ACLU did relatively little individual representation and virtually no defensive individual litigation. That wasn't really the focus. It was an active bar that was doing that. That said, the effect of the 96 law, IRA, the first and most immediate impact was to try to deprive individuals of judicial review of individual removal orders, namely those individuals who had criminal convictions. And the government's initial position was that a person who had a removal order based on, or even a deportation order, who had a deportation or removal order based on criminal conviction, had no right to judicial review at all with regard to any challenge of that deportation. Well, that meant, and the way the law was written, and I think as Nancy mentioned, there were successive statutes. First, EDPA had the court-stripping provision that was kind of small in relation to what ultimately came down with regard to IRA. And they both had provisions that not only eliminated or sought to eliminate the judicial review of individual orders, but also applied immediately to all pending cases. So what that meant was that an individual who was already seeking judicial review and whose case was already in the courts of appeals on a petition for review, that case was immediately governed by the new court-stripping provisions, and that the courts were being asked to immediately dismiss any petitions for review, any pending appeals governed by the new statute. Well, that meant that there was not an opportunity to develop a big affirmative litigation, identify the perfect client, gradually develop the claim, find the best court, and a lot of the other strategies that we generally try to do with regard to class action litigation, framing the case, identifying clients, and that sort of thing. What we needed to do was have a strategy for immediately addressing the jurisdiction-stripping provision that was being applied in every case under the new statute. So against all my instincts of wanting to do affirmative class action litigation, my immediate reaction is we cannot do this through the gradual process of bringing an affirmative case. We have to have a new strategy to address this new particular provision. And so that strategy, in my view, had essentially three aspects. One, as I just mentioned, we had to have the mechanism by which we would assert the legal theory or principles that we sought, and that had to be through individual cases. Secondly, we needed a legal theory. We needed some argument by which to actually argue that Congress's very broad power over immigration, its so-called plenary power over immigration, nonetheless did not allow it to provide that a person who was deported, even on a criminal conviction, could not have some mechanism, some access to get to Article 3 courts in order to get judicial review by the judiciary of any legal claims or arguments that that person wanted to assert with regard to their removal. So we needed a strategy, a tactic, if you will, legal theory, and then third and critically, I felt we absolutely had to have a broader advocacy structure. That if this issue were seen simply as a question of rapid summary removal of so-called criminal aliens who had been in a court of a serious or arguably serious crime, that in the immigration realm, where A, there's not a lot of sympathy, and B, there's enormous judicial deference, that if the only issue was that question, we were going to lose. And that there needed to be an understanding of the broader principles implicated by what Congress was seeking to do with regard to the court-stripping measures that we wanted to challenge. So let me just say very briefly kind of the steps we took with regard to each of them. One, in terms of representing individuals. What we did essentially was, through existing networks, and the American Immigration Lawyers Association and National Lawyers Guild were two critical parts of that, reaching out to the immigration bar through existing networks. And this was before the era of blogs, it was before the era of electronic and social media communication. The best we had was emails, and those were kind of in their early days. So the first thing, so we did, through that network, what we did, colleague Legal Alert and I, and others at the ACLU, we sought to be involved in every single case where a court was considering this question. Oftentimes, after the case had been fully briefed, after the case had been scheduled for argument, and through the gradual process of literally appearing in every court of appeals in the country, and filing briefs in dozens and dozens and dozens of cases, some of which never saw the light of day because they were rooted out. We gradually educated the courts and began to play the role of presenting the legal arguments in every court around the country. Secondly, in terms of legal theory, we engaged the academic community on every aspect. In particular, the legal theory, and specifically the role of habeas corpus with regard to so-called executive detention. This was in the era when habeas corpus, because cases the court had decided earlier, the trustee and others, habeas was seen as this very narrow remedy that was applied in cases of people who had been convicted of crimes to challenge their conviction in a collateral proceeding. So habeas in that context, both by the courts and then by EDPA, had been really narrow to raising very, very few claims. But the first step here was to explain and to develop the argument that habeas corpus in the immigration context is really very different. It's only access to a court to challenge the executive's action, and they now have to Davidian and there's broad understanding of this, but this was in an era when habeas was seen as a very narrow remedy, not as a fundamental vehicle for getting access to the courts. So Jerry Newman wrote and we engaged the community not only in terms of helping, but actually developing very deep legal analysis through scholarly articles, and then directly engaging by filing amicus briefs and presenting those arguments to the court. So Jerry Newman played a critical role, as many others. Nancy on the issue of retroactivity, which is the merits issue, and if I got into that, we'd do it for another day. So lots
on our website called Lifeline on Lockdown, but it's from a couple of years ago because there really isn't current data. The huge challenges that we found, among many others, one of course just an overall shift and increased use in detention. About 42,000 people daily now are held in detention according to a recent Wall Street Journal report. Some of you may have seen it as a significant increase, which means over the course of a year, we're talking about several 100,000 people at least who are held in detention. It's believed that now a much higher proportion of those individuals are asylum seekers. We don't have the hard data to demonstrate that because that data has not been provided despite multiple requests, but the overwhelming majority are believed to likely be asylum seekers who are held in immigration detention now. One challenge that we've seen over recent years is that even though the Obama administration, under the first years of the Obama administration, the Department of Homeland Security issued, and ICE issued, a memo making clear that asylum seekers who pass through this screening gauntlet should be eligible to seek release on parole if they meet certain criteria. The criteria are spelled out and detailed in the memo, but despite that fact, the release rates have plummeted. The time that USERD did an interim report, I think back in 2013, the release rates were pretty high for people who actually passed through all that. They've got established identity, they've got to show community ties, there's the criteria they have to show they do not be a risk. Now, we find with our pro bono clients, many of them are operatives, and they continue to be detained for 6 months, 8 months, a year. We have a Syrian refugee client who's now been held for over a year. It's shocking, frankly, that the administration's own policies are not being followed. In some parts of the country, for example, Georgia, we issued this particular report just on Georgia. People not only do asylum seekers not get parole, but even if they're held in detention, they're not going to be granted asylum because nobody's granted asylum in these facilities. So instead, we're taking asylum seekers and shifting them into these detention centers and just sort of leaving them there for 6 months or a year for little purpose if they have no shot at all of getting granted asylum or getting released and being able to seek asylum, even if they've got strong asylum cases. One huge problem in the system is that for these individuals subject to expedited removal who are considered arriving aliens, they don't get access to a bond hearing under our procedures. Meaning, in effect, the local INS officer who's judge and jailer, that they never actually have a right to go in front of even an immigration court to get an assessment of whether or not they could be released on bond or potentially their home or policies. The United States in its domestic practices at home now has really shown that it's responding to the global refugee crisis through a border enforcement lens, treating asylum seekers as though they are criminals who are convicted of crimes and are now being sent to serve their sentences, falling back on the convenient availability of detention centers and jails, rather than launching a response that could both respect the rights of asylum seekers and protect U.S. interests and security. So I've got a few quick recommendations to throw out in my last 60 seconds, or maybe 50 seconds. First, the U.S. government at its highest levels, and I mean the President, the Cabinet, officials across the board, must shift the overall approach to refugees at the U.S.'s doorstep. We've got to shift from a detention and deterrence-driven approach focused overwhelmingly on border enforcement and border and safeguards U.S. interests. A crucial part of this approach has to be a shift away from the massive overuse and over-reliance on summary proceedings like expedited removal and reinstatement and detention, and to develop a real system of refugee reception. In terms of other recommendations, quickly, we've got to eliminate the asylum filing deadline. Expedited removal should be repealed, or at least absolutely rolled back in the border in the areas covered by Border Patrol. We've got to provide court review through bond hearings for arriving aliens and other categories of individuals who are not allowed to have access right now, even to that limited safeguard. We also have to provide bonds that are affordable, champion access to counsel, and prioritize the hiring of immigration judges and asylum officers. And significantly, the next administration must significantly reduce its budget requests for detention jets. So I've got a lot of other recommendations which I'm happy to talk about we'll return to the question and answer, and really look forward to further discussions on how to fix many of the problems created by the 96 laws, or at least encouraged by the 96 laws. Thank you.
Looking for the mouse. Thanks. I'll add my thanks to those. So that for organizing this wonderful conference. I'm glad to be here. So I'm going to talk a little bit about an article I'm working on called Judging Immigration Equity. This is the latest in a series of articles that I've been writing that concern aspects of law or practice that either enhance or detract from proportionality in the immigration system. My earlier articles have focused on the executive branch and its implementation of the structure, and there's sort of some things to praise there and lots to criticize, of course. This article turns to the Supreme Court, and I look comprehensively at what I find are all the court's key deportation and enforcement decisions since the St. Cyr case that Lucas talked about, was issued in 2001. So I'm going to start the discussion with a case called Immigrant, and this offers a window into some of the issues that I examine in this paper. So Mululi is a person who was Mululi, who's from Tunisia. He was lawfully present in the United States since 2004. He earned several degrees here with distinction. He was an actuary and taught mathematics at the University of Missouri. Became a lawful permanent resident. Was engaged U.S. citizen. In 2010, was pulled over for some driving offenses, driving under the influence. He was put into detention as a result of that, criminal detention. And while he was there, the jailers found 4 Adderall pills in his sock. When they were conducting a routine search. And as a result of that, he was charged not just with the driving offenses, but also with drug trafficking, contraband, and jail. Somewhere along the line, though, a deal was struck, and he pleaded just to a DWI offense and to possession of a sock as drug paraphernalia. He got a suspended sentence and 1 year probation, which he completed no problem. And as soon as that was completed, ICE picked him up, detained him, he was put to deportation procedures, and in fact was actually deported in 2012 to Tunisia. He was ineligible for any kind of cancellation of removal or other forms of equitable relief. And his case court, through in a 7-2 decision, reversed the deportation. I'm not going to get into the details of the sort of technical way they did that, but they applied something that many of you know called the categorical approach. It's the sort of fourth immigration case in the last 10 years where they've applied this approach in a case involving a lawful permanent resident who the government sought to deport on the basis of a fairly low-level drug crime. The offense that he pled guilty to is not even a criminal offense, and something like the United States. There's no federal deportation category for possession, not a removable offense, and even the federal definition of possession doesn't include ready-to-wear items like a sock. So, and of course, there are other technical reasons that the categorical approach was appropriate. So this illustrates the phenomenon one of the phenomena that I'm really interested in here, which is we have this extremely broad code we're hearing about already today that was enacted with the 1996 laws, and then we have extremely aggressive enforcement of those criminal provisions by the executive branch. And then in a number of cases like Mululi, we actually have a response from the Supreme Court that I argue is an equity-driven response to inject some form of either proportionality or an opportunity to bring an equitable claim in certain cases. So this paper looks at all these cases holistically, and I think of multiple strands that I think mostly have been considered in isolation. I believe, or I argue, that the court has endeavored to increase the structural possibilities for equitable balancing and has employed methods of analysis in cases like Malouly's that curb at least the most disproportionate outcomes in the removal system, especially with respect to persons with criminal history. So here's a little bit of an image that ties into kind of what I think is going on here as a matter of theory. As everybody knows, in the 1990s, Congress dramatically expanded the categories of removable offenses, particularly on the basis of criminal history, and at the same time took a cleaver to possibilities for equitable balancing by immigration judges, both for lawfully present and unlawfully present non-citizens. Removing adjudicated discretion from the system, though, does not necessarily excise all consideration of discretion and fairness. Police, prosecutors, frontline federal enforcers become the system's normative gatekeepers. This is a phenomenon that's in which federal officials, as an initial matter, must decide whether it makes sense to pursue removal at all, and that discretion embraces immediate human concerns. Talks about certain examples of deportable non-citizens who might not warrant deportation as a matter of discretion. And at the end of this passage, she says, returning an alien to his own country may be deemed inappropriate even where he has committed a removable offense or fails to meet the criteria for admission. So this is pretty striking in its candor, because this is the Supreme Court, majority of the Supreme Court, acknowledging that not all deportable non-citizens are similarly situated. And in my paper, I go through each of its preemption rulings, and I try to tie them, I believe the court ties them to the value of the executive implementing equitable enforcement decisions. And in fact, I think that would influence the court more than a kind of concern about discrimination. And I can say more about that in questions. And interestingly, most people that will have benefited from a decision like Arizona benefit from macro level enforcement or resource choices, not individual case-by-case balancing, which I think has pretty significant implications for the deferred action programs. Okay, another key touchstone Supreme Court cases is, of course, Virginia v. Kentucky. This was a criminal one, Moncrief. They work hand in glove with Padilla to help inject some consideration of fairness into the deportation process. The categorical approach cases help insulate the kind of criminal court deals with the court envisioned in Padilla. And sometimes that means preserving what narrow possibilities for equitable relief remain, or sometimes it means, as in Louis' case, averting removal altogether. And in Moncrief, in Malooly, Justice Ginsburg's mortuary opinion specifically acknowledged this and said that criminal defendants who are non-citizens might be enter safe harbor pleas, and that the categorical approach protects them. So, and of course, I'm not going to read this quote, but this is the court really speaking to the government and directly admonishing them for their aggressive approach in these kinds of cases. So, in the paper, I talked about Arizona, I already mentioned, the criminal history cases, second look cases, the sort of cases involving wishes to reopen, and detention. And I'm not going to say anything more about this now, but I'll just turn for a moment to some of the implications and limitations of this. So, in particular, what's interesting here is that you have the court scrutinizing the system's tight linkage of criminal history and deportation. And really the court, not just the Supreme Court, of course, but the federal courts in general, have emerged as the sole federal branch that seems to believe some consideration of normative justifiability of removal is appropriate, even in cases involving persons of criminal history. The holdings also benefit non-citizens who are present without authorization, who don't have a formal path to legal status. And so what that means is that the Supreme Court's conception of membership is actually broader than immigration law, the formal code law. It's more broader and more inclusive. The formal code law sort of assumes non-membership, right? Especially for undocumented persons who have the burden to show that they belong. Now, of course, I don't want to give too much credit to the court. As you heard from Lucas, these decisions are the result of tremendous advocacy and scholarly attention. They also are quite limited in their overall impact. So there are many drawbacks to an enforcement-based system of equity. Enforcement discretion is obviously highly unreliable, very inconsistent. It often results in something that I call status quo equity, which is that the person remains in sort of legal limbo, and they've not actually achieved a kind of regularized status. And then, importantly, the court's reliance on procedure and structure in these cases, rather than substantive rulings, or the articulation of actually a substantive proportionality principle, allows for the system potentially to get much worse still, right, at the hands of Congress or even the different executive. In the absence of significant legislative or executive change, or some new willingness on the part of the court to actually recognize the substantive proportionality principle, we're really seeing the court throwing the bucket on a raging fire. We're in another, I did this presentation last week and I used the person chipping on a mountain as my last slide. Whatever the metaphor is, I think we can, unless we have dramatic legislative or executive change in this area, we can expect the court to keep a kind of steady diet of these cases on its docket, just chipping away at the harshest edges of the system that's marked by insufficient consideration of humanity and justice.
Pulling up my technology here, switch from I was using this for my notes. So I'm Becky Sharpless. As will become apparent, apparent here in the talk, I am both a clinician and an academic. I practice law and I teach law, and I have therefore a bit of a schizophrenic identity sometimes, and I hope that will come through today. I'm going to be talking a little bit about what's called Chevron deference. Who's heard of Chevron deference? Okay. I'll be going over the basics of that. In particular, I'm going to be talking about judicial deference to agency interpretations of what are called hybrid statutes.
or hybrid statutory terms. This might be a term of civil immigration law and criminal law. And I'm going to talk about whether there should be difference in those contexts and how we can start chipping away at the mountain by arguing that there's a lot more out there that can be termed hybrid and that there's no Chevron deference to the agency interpretation. I'm going to then talk a little bit about a case that's pending, that actually Nancy mentioned, a case that's pending conference today to see if the Supreme Court is going to be granting cert. And I'm going to place my arguments against Chevron deference in a larger context of what Jason was also alluding to, this larger movement to try to disentangle civil immigration system from our criminal justice system. But first, I wanted to pick up on something that Jason also alluded to indirectly, which is that the 96 laws place a big marker between the two stages of immigration proceedings. And I'm going to put to the side the fact that lots of people don't get into immigration court for a full removal hearing, either through expedited removal or what's called administrative removal, which is that if you have an aggravated felony and you're not a permanent resident, you don't actually get a hearing before an immigration judge. So everything I'm going to talk about today in this talk won't even come up because you're not even in front of the judge. Okay, but if you do get a hearing before a judge, there are these two stages. And in the first stage, we're going to call that the contested immutability stage. And that is where you try to find arguments. You have a person with a criminal conviction, that criminal conviction doesn't fall into a bucket of a removal ground or a deportation ground. We now call them removal grounds, post-96. And the second stage of relief, a second stage of proceedings, is where you apply for relief. And that's what the 96 laws really do. The 96 laws affected both of those stages. Broadly, people have said the grounds of removal, but it also took away the grounds for relief. What I think, and I agree with the conspiracy theory that Nancy, that there was an oil litigator in the conference room who knew that we were winning the old forms of relief. We were winning the 212C cases that Lucas was talking about in that second stage of proceedings for people with somewhat serious criminal convictions. I started practicing in 1994, 2 years, I had 2 years of pre-IRA law. And we won a lot of cases. I think it was definitely over, in my case, it was over 50% for sure. And I think that oil attorneys knew this, and that's why those provisions were put in there. Okay, so what happened was that the advocacy community started focusing on that first stage of proceedings. What are the arguments that we can make, some of which are quite technical and have to do with categorical, but what are the arguments that we can make to say that our client isn't even removable? Because if they are, that's it. It's a rubber stamp deportation because there's no relief beyond that. And so there was a lot of energy starting to be poured into that first stage of proceeding. And that raises the question of whether or not reviewing federal courts have to defer to the agency's interpretation of whether a conviction falls within the ground of the interpretation of that ground rule, that question of law. Does there have to be deference to the agency's determination? So there's been much written about Chevron. I'm realizing this. I took this as my topic to try to write a symposium piece, and then realized there's a lot written on Chevron. And some folks may be in this room today who can correct me on what Chevron said. But it's a 1984 opinion, and some would say a very good opinion. It was a Justice Stevens opinion, and here I am arguing against it. It was a Justice Stevens opinion that arose in the question of the environment. The question was whether federal courts should defer to an agency's interpretation of a statute when there was ambiguity. In that case, it was the EPA's construction of a term in the Clear Air Act. And for environmentalists, it was actually very good construction. In that case, the agency was doing good. And so partly when you think of Chevron is, of course, whether you like the agency that is doing the interpretation. And so while we might like the EPA, or certainly Justice Stevens did, you may have a different opinion of, of the BIA and the Attorney General when it comes to their interpretations in immigration law, which tend to be very result-focused, very anti-immigrant and restrictive, especially when it comes to criminal convictions. The doctrinal concern with Chevron, of course, is that it's telling courts who under Marbury versus Madison, who remembers that from the 1F class, right? Marbury versus Madison says that the courts are the ultimate arbiters of what the law says. And what Chevron says is that when there's an ambiguity, and the agency has been charged with the implementation of that statute, that the judiciary shouldn't say what the law is. As long as it's reasonable, the agency can fill out any ambiguity. So it's a delegation of power to the executive branch. So there are sort of some concerns that runs up against delegation concerns based on Marbury versus Madison. And there's also this sort of sense that, well, agencies are better at interpreting things that they have experience in, and so they have this expertise, and we're going to talk about, well, is that expertise really there, or what they're interpreting are things having to do with criminal law, or terms that also have played in the criminal justice system. Okay, so there are 3 steps. Well, first there were 2, and then people added 1. So now we have 0, 1, and 2. Okay, step 0 of Chevron is, does Chevron even apply? Is this a statute or a statutory term that Congress intended the agency to interpret? And if not, end of story, there's no Chevron deference at all. If it was delegated, then the second question is the statute ambiguous? Because if the statute isn't ambiguous, then there's no need to look at what the agency said. The court can just say what the statute says. And the court should use normal statutory interpretation in order to do that. And then step 2 is if there is ambiguity, then you ask if the agency's interpretation is reasonable. Now you may say, well, so there's a reasonableness check on Chevron that the BIA or agency can do, or Attorney General can do. But the truth is that there are lots of cases in which the court said, well, we would have come out with a different result, but it was reasonable what the BIA or Attorney General did, so it's actually a very big deal. So what does then the statute say generally about delegating to the BIA and Attorney General? Well, it is pretty clear that Congress delegated through the Immigration and Nationality Act to the Attorney General the administration and enforcement of the statutes, and said that the determination of ruling by the Attorney General with respect to all questions of law shall be controlling. And then by regulation, the Attorney General said, okay, Board of Immigration Appeals, you can have that power as well. And the Supreme Court has held that the BIA can operate through case-by-case adjudication. They don't need to pass a reg. You notice the comment every time they want to interpret, they can do it through case-by-case adjudication. Okay. And in addition, the Supreme Court has held that because of plenary power, which I think Lucas alluded to, this idea that there's plenary power over immigration because it, among other things, implicates foreign national security interests, that the Chevron deference sort of goes hand in hand with plenary power, and Chevron deference is especially important in the immigration arena. But now let's circle back to the real question, right, which is what I would argue is that the scope of Chevron deference when there is a hybrid statute, one that has claimed both immigration and criminal, is actually quite narrow. And that there are lots of things that we can characterize as hybrid statute or a hybrid term, and therefore we can advance interpretations that the judiciary should just adopt and not the BIA power. Okay, and this is really important also because if we can show that the term has play in the criminal justice system, the rule of lenity that Nancy was referring to definitely kicks in, because in the criminal context, not only is there no deference to the U.S. attorney or prosecutors, right, in interpreting criminal laws, there's no deference at all. Not only that, but there's a rule of lenity that says when there's ambiguity, that it should be construed in favor of the defendant. All right, so let's start with the areas of consensus. There have been some cases already. There is broad consensus that whenever the BIA or Attorney General looks at a state law question, there is no deference. And sometimes this comes up because under the categorical approach that Jason alluded to, the courts are always asking, the BIA is always asking, does the state criminal conviction fall within this federal rule?
and they have to look at the elements of the state offense and compare them to the federal standard. And so it requires, John for Florida, requires doing Westlaw Florida law searches to see what the elements of the crime are. There's no Chevron deference to that part of the inquiry. The second area of consensus is that when the INA expressly cross-references a specific criminal statute, for example, the crime of violence definition in 18 U.S.C. 16A and B, that there's no interpretation to that specifically cross-referenced statute. That's very clear. How could it be? I mean, it's a criminal statute, so the courts get to decide what it means. But there's basically a lack of consensus about everything else. And what I want to argue is that almost everything else is at least some argument that it's a hybrid scenario where you say there's no evidence. And the first area is the aggravated felony definition. It's a very long definition, there's many subparts. Only some of them cross-reference federal statutes. Others, like sexual abuse of a minor, or rape or murder, or burglary or theft, are not cross-referenced terms. Rather, they are just terms of art in the aggravated felony definition. And I think that it's pretty clear since the aggravated felony phrase also appears in federal criminal law. That phrase appears and is the basis for sentence enhancement, for example, on someone who's deported and then re-enters after an aggravated felony, their sentence is enhanced. And so the Supreme Court has said that if a term appears in both places, it has to have a uniform meaning. And so it's definitely a hybrid statute. I think it's a no-brainer. But now there's a circuit split on that question that the Supreme Court today, as Nancy mentioned, is conferencing about whether to take this case. And it would go directly to the question of whether the term sexual abuse of a minor is a hybrid statute such that Chevron deference does not apply. And I think it seems straightforward to me. But we'll see, I'm not often right about predicting what the U.S. Supreme Court will do. All right. The other interesting vector, I think, here is that the Supreme Court never defers, even though there's briefing on Chevron deference before it, almost never defers when it's interpreting the parameters of the categorical approach. And they base the categorical approach on a statutory term that's both an immigration term and a criminal justice term, and that's conviction. The word conviction is responsible for the categorical approach. And the idea is that if you can only be deported for a conviction, then when you're looking at the documents to sort of characterize that conviction, you can only look to the elements of the crime, not other extraneous facts that might be in the charging document or plea colloquy or a police report. You can only look at the statutory elements. And that process, about which there have been many cases now, is called the categorical approach, and the Supreme Court just decides. It never even talks about Chevron. And so in my book, that means they're assuming that it's a hybrid scenario, that the word conviction is a hybrid word. It appears in both criminal and civil contexts. And so the question for me then is how much can we push on that to reach many other questions that really there should be no deference, at least the courts are split right now without good reasons on either side. And so one example of this might be, for example, does the categorical approach require that not only you look at the elements when comparing a state crime to a federal standard, does it require that whenever there's a term of art or a removal ground, that the courts come up with a set of generic elements that can then be matched to the federal standard, so the state crime can be matched to those elements. In other words, does it require that the courts take a term like sexual abuse of a minor and come out with a set of elements that's the federal standard? They've done it for burglary and some other crimes, and do they have to do it across the board? Because that's what the categorical approach requires, because that's what the word conviction requires. And if all of that is true, then no Chevron deference is due to BIA when they lay out those elements. Not only once they lay out those elements, but no Chevron deference is due once it goes up to the reviewing court. And so that's, and I think precisely that is what's at issue in the Supreme Court case that might be granted cert today, or Monday in Esquivel, Quintana. I will close from going sort of from the weeds. I find this stuff fascinating, not everyone does, but from the weeds of what's due Chevron deference and kind of vertical approach to the mountaintop, and that is a larger struggle to disentangle. Okay, I will keep it short. To disentangle, I know. You would never do that to me. To disentangle the civil immigration system from the criminal justice system, because that is a larger goal, to make immigration enforcement not about crime control, but rather about regulation of our borders. And what the irony here, of course, is what I'm doing, what I'm arguing for as an advocacy strategy, is hitching our horse to the wagon of the criminal justice system because the rules about deference are better over there. And of course, so there's some tension there, and it's something that we can talk about in a minute if you'd like. There may be a way to resolve that intellectually, but sort of with the advocacy hat on the one side and sort of scholar on the other, I see that there's a tension there that's very real. And I think also it's sort of analogous to the idea that it's really hard to make a frontal challenge of immigration law, and we're chipping away at the mountain by going around the side. And in the context of Chevron, I think we're going around the side to get victories for our clients by hitching our wagon to the criminal justice system.
All right, well, following the lead of Professor Rodriguez, before I turn it over to the audience, I want to see if any of you had comments or additional remarks you want to make, questions about that.
I'll ask you, Jason, on the bubble image, on the balloon image, what's the balloon? Is that the idea that you push in one place and it bulges out the other?
Yeah, I realized that I never actually filled out the metaphor, but yeah, the idea is that, like squeezing out, that removing equitable discretion from the back end of the process does not necessarily completely remove it, instead it forces it to other parts, just like squeezing a balloon. That's right. And all the way from sort of to federal enforcers on down to state and local police taking stops.
And I think that to further the analogy from an advocacy point of view, we're squeezing the balloon from the relief stage to making arguments in the prevention and disability stage. So we focus our advocacy.
Any questions from the audience?
So this question is about the last two speakers. So Jason, I love the presentation of the Supreme Court cases and seeing them as seeking equity, but you left out a couple of cases. So Luna Torres which involves a deportability ground that extends to as it was briefed, somebody starting a fire in their own wastepaper basket on their lawn, although it's called arson, in some states it involves some very minor offenses, that being treated as an aggravated felony. Yep. And then Kawashima and Nijuan, so people with relatively small tax offenses or relatively small fraud offenses, and sort of. So those being three cases in which the court ruled the other way. I know that both Kawashima and Nijuan had really bad facts, but that wasn't the case as much in Luna Torres. And then for Becky, one of the things that's interesting is in all three of those cases, this hybrid statute argument was presented to the court by the Solicitor General's office, by the counsel for the parties. The Solicitor General said you apply Chevron deference. The parties said you don't, and you apply the criminal rule of lenity. And in all three cases, the court issued an opinion that analyzed the statute and didn't doesn't mention the word Chevron, and doesn't mention the term lenity. So it sort of acted like none of that was going on. So we do now have a case where that's been litigated in the circuit court. It's well presented in this case, Esquivel Quintana. But it seems like the court really doesn't want to go there. And so I don't know what you make of that, and sort of also how it applies to the request of the court doing equity.
Thank you, Nancy. So, yes, I did conveniently, for purposes of my presentation, pick out a few cases.
But I do address those in the paper. And so, you know, I mean, one thing to be clear about is that the court is pretty constrained, is subject to pretty significant institutional constraints in terms of what it can do. The court is not in a position to actually, you know, rewrite deportation laws or anything like that, and so and is also tasked with, you know, implementing Congress's intent, right? And so sometimes, I think in some of these cases, it's just that to sort of there's almost no workaround. I mean, I think in, you know, either because of the way that the statute was written for that particular offense, in the case of Najuan, and maybe a little in Torres too, if they had, you know, gone a different way, the court tells us it would have almost been nonsensical because it would have been arbitrary in terms of it either would have had the removal provision would either have had very, very limited application, or its application would be somewhat arbitrary. So I'll just say something more specific about Torres, because I think Torres, this is, I think, the most recent categorical approach case, and the issue in Torres was whether a removal statute that cross-references a federal offense that has as a jurisdictional element interstate commerce, that it involves interstate commerce, when you've got that kind of removal statute, whether a state statute that has all of the other elements the same but doesn't have that interstate commerce jurisdictional element is going to be considered the removal, falling within that removable offense category or not. What's interesting about the Torres opinion is that I think it actually, in a way, it shows that all of the justices do care about proportionality. It's just that some of the majority of justices in that case, which was just a 5-justice majority, found that reading a statute a different way would result in very serious offenders in some situations, you know, for example, involving child pornography, not being removable by implementing the categorical approach, whereas other, you know, more minor offenses would still be removable, or would be, or rather, would not be considered aggravated felonies. So, yeah. So I don't know if that's super responsive or not, but I think even that case shows the court is you know, even the justices who ruled in the majority in that case seem to be grappling with the actual, with what is the equitable result this is going to produce, whether you look at it one way versus another.
So I agree with that. So I'll say a couple things. One is that I found it interesting looking at the cases that in the circuits there's a whole lot more deference, pre-application to Chevron in circuit cases, and they're more likely to say that we get over the hurdle of Chevron 0, it doesn't apply. This is something that Chevron deference could apply to, and then they might ding it on step 1 and say the norms of statutory construction dictate a non-ambiguous reading of the statute, and that would be address it, as opposed to the Supreme Court, which rarely has engaged with Chevron, except that it did, interestingly, in the Justice Ginsburg opinion in the Sock case, Louis, it said it seemed to be a Chevron step 2 decision because it said that the government's interpretation made scant sense, which is a reasonableness. So that's Chevron step 2. So it did seem to see it was relevant there. But when it does what is the categorical approach require, that kind of inquiry, that's covered to the word conviction, it seems to be ignoring Chevron. But in the Louis, it didn't. So I'm interested in sort of how far we can push the word conviction really means that all of this stuff doesn't get referenced.
Lenny Benson, New York Law School. So for Lucas and Eleanor, any comment? I apologize, I came in a little late because on the current Third Circuit suspension of habeas case, it applies to context of the 22 families in detention who criticizing their credible fear review, the adequacy of expedited removal as applies to their lives and their bodies, and it's a challenge to the systematic application of the system, and the Third Circuit not only found a suspension of habeas was not unconstitutional, that these women had no rights, nor even the right to seek habeas, it went out of its way to reach that issue, avoiding all the litigation we did in those years back in '96. We said you don't have to reach that issue because you can construe the statute to create jurisdiction. So thoughts on that case?
So switching gears about a recent Third Circuit decision suspending habeas, or not granting habeas to women detained at courts.
So, and thank you for all your work back in the day. So the part of my comments that you may have missed was that in my position at DHS, I'm no comment on anything, and I'm well aware of the case, but I can't really say anything.
Okay. So it's all up to you, owner.
Yeah, I'm not really a litigator anymore. So, but I will say we issued a press release as soon as we saw the decision condemning it. I don't know if anyone has an update, but I know that there's a petition for hearing that is pending. We signed on to potentially join an amicus brief that would support a stay. For some reason that was denied. So I believe the petition for hearing is still pending. The optimist in me, I guess, is still there because I can't believe that a plenary hearing that the entire Third Circuit would support that decision. I think, I would be shocked if they would. It's such an extreme position that has so many ramifications, not limited to the immigration area. So, I guess I have a little bit of optimism there that ultimately this will be fixed, but it is really a decision that has, I would say, no basis.
I'm Steve Morley. I jumped here, I don't have jumped here, I was civil immigration judge in Philadelphia. My question, my comments are purely in a personal capacity, so all I take is first I want to thank this work and his team's work. Without their efforts back in '96, and I co-counseled with People Learned. It was a great experience for me at learning that kind of complex matters. So, a shout out to you. So I want to sort of shift maybe focus a little bit. We're talking a lot about the court and decisions they make. And I was struck by something that I read in the paper maybe a month ago that reflected on a case we haven't talked about today, Moore versus Keynote, which affirmed mandatory detention as being constitutional. And the department that I am employed by has recently revealed that it made a slight error in their statistical analysis of the time people spent in detention. And oops, it wasn't just maybe 6 weeks or a couple of months, but in fact was well over a year. If you read the Moore versus Keynote, I think one of the pillars of that decision is the brevity of time people spend in detention. So my question to all of you as scholars is, how do you go back and fix that? I mean, to me, this was just an astounding revelation. And it completely undermines the validity for us to
So the question for those who can't hear related to Moore v. Kim and the recent revelation by the Department of Justice that in fact statistics that were provided to the court in consideration of that decision about length of detention was not accurate.
I'll just take the first stab. So that was a very breathtaking revelation, which not the first time that's happened in Antiterrorism. It's written about the problem of the Supreme Court relying on unverifiable facts presented by the Solicitor General in these types of cases. You're absolutely right, Judge, that what appears to have been a critical fact that both that led to a majority consensus that what was going on was constitutional in Moore was the fact that detention during removal proceedings was relatively limited. And of course, in the interim, even if that had been true, in the interim, detention became longer. right? And so the circuit courts who have considered this, who have been adjudicating these kinds of prolonged detentions, have mostly just distinguished Timor and or all actually, on the basis of the change. So to me, this creates, again, possibly completely unfounded optimism that the Supreme Court this term, which now that it has a case in James v. Rodriguez that raises mandatory detention in a couple of contexts, including the one that was before the court before Kim, we'll actually revisit that decision. And I think that disclosure from the Solicitor General, is probably something that will be on their mind.
Eleanor, I know you've been working on an amicus brief addressing the international law, and it's for Rodriguez. I don't know if you would like to comment on that.
I guess like a couple of points I would just add, not from the sort of legally how do you correct such a glaring inaccuracy. I mean, for those of us that deal with the immigration agencies over the years, we're not surprised at all about the lack of inaccurate information provided. A law actually was passed many years ago to require ICE to actually produce statistics that would include the length of time in which people were held in detention. A law had to be passed in order to get them to do that, and they still don't do it. And the statistics that they do reveal, after you file multiple FOIA requests, repeatedly requesting the information and get congressional people on the Hill to say, please produce the statistics. They give you statistics, but they show you the length of detention only as of like one period in time, meaning all the people who are held for longer periods of time are not reflected in that. So the 2014 statistics, they don't include the guy who's still detained 2 years later. They just include how long he was detained as of the moment they happened to release the statistics. So detention times are clearly much longer than information that has been revealed so far. The Burks families, which you mentioned, Lenny, those families have been detained in many cases for a year already. It is absolutely inexcusable. I mentioned in history we're working on international human rights standards. The U.S. Is a party to the ICCPR. The most basic of human rights is the right to liberty, the right to be free from arbitrary detention. It's an essential safeguard under international law and what this country stands for. And yet, the United States is detaining people for long periods of time without even allowing for an individualized assessment of the need for their detention, the proportionality of it. And we're not even letting them ever even have an immigration court, forget federal court, but an immigration court actually conduct an initial review of that and then periodic review throughout. So the current system and the one that was okayed by Timor is absolutely inconsistent with international human rights standards. There's just no question.
We have time for one more question.
My question is in law school. So when a reporter called for comment on what to do about the numbers, I said, I think it's like a home run record in the steroid era for baseball, and should have an asterisk by it. He asked for something more measured for the professor to say. So that never made it into the journal. On the Castro case, the petition for hearing about is still pending. The court recently ordered the government to respond, which it doesn't always do. So that indicates a certain number of judges voted to call for a response. The government filed its brief last night. So the question is for Lucas, actually. The question is for Lucas. Now he points out. And I want to kind of invite you to reflect further on the late 90s period, and not so much as you did on why things worked out so well in the judicial review fight, which I thought was very helpful and fit with my own experience, but rather the preliminary choice to choose that issue of all the many issues in the fall of '96 that one could have chosen to mobilize resources around, the kind of resources you talked about, not only your own staff, but the much broader social mobilization. Because I think that decision about how, of all the issues and all the feasibility analyses and all the pain and all the opportunities, how one says, okay, given the resources, let's do this one. And to the extent you can reflect whether, in retrospect, you think that was the right judgment. Obviously, it worked really well, but that doesn't mean it was, the right pick at the time. Because I think everyone in the room constantly faces the choice of how to choose which issues to invest in.
Yeah, it's a really interesting question. I tried to allude to that a little bit. I guess I'd say a few things. One is, it wasn't the only issue that we were focused on. We also brought litigation, not so successful, so it doesn't get as much attention on the expedited removal process. And because the judicial review provisions of the expedited removal process had both the channeling provision, everything had to be brought in DC Circuit, and a time limit, everything had to be brought within, I think, 60 days with regard to looking at regulations and rules and implementing it. We did bring litigation immediately within that time frame to challenge the expedited removal process, recognizing that was urgent and important as well. And we also had been before 96 and continued after 96, particularly the work of Julia Vinovitz, focused very much on the detention issue, which led ultimately to the Kim case, and now the Jennings versus Rodriguez case, another one which I'm keen to address. So it wasn't the only issue by any means. But then among the other issues, and there definitely were many, my initial instinct actually was to be very concerned with regard to the restrictions on class actions and the channeling provision, because the litigation that had been brought pre-96, the litigation on behalf of Haitians, the litigation on behalf of Central Americans, the other kinds of systemic challenges were affirmative class actions seeking injunctive relief that were brought before removal proceedings were completed, the challenging the process by which removal proceedings were brought, the procedural rights within removal proceedings, interpretation in immigration courts, the Elder Scott decision, there were lots of those kinds of cases. So seeing those restrictions was very problematic. And I thought one of the things we need to do is to address those. The reason that we ended up with the issues that we did focus on were, one, they were thrust upon us for the reasons I was saying, that the prohibition, at least as initially interpreted by the government and then as it kind of evolved over litigation, was the argument that it was permissible to eliminate access to an Article III court by someone facing a final court order. And if it was permissible in the context of someone convicted of a criminal offense, there was no reason in principle why Congress wouldn't then be permitted to expand that to other categories and ultimately to deprive anyone, at least the risk was to deprive anyone that Congress chose to deprive anyone of access to an Article III court. So, and then because of the timing provision that I indicated, because the way both EDPA and IRA were written, the court stripping provisions applied to all pending cases. We made some initial arguments that those stripping provisions themselves should not apply, to a pending case. And I always thought we had a pretty good argument under some 1890s Supreme Court cases, which I don't remember. That was rejected. And so it meant that the judicial decisions on the scope of the power to strip courts of jurisdiction to hear removal orders was going to be decided in this particular context. So at that point, my view is we absolutely have to engage in this because it's where it's going to be decided, and this is going to be the place where the principle is established going forward. So, all of that combined to, in my view, compel us to address that fundamental issue in that particular context. If we had lost in retrospect, it probably would have been a bad choice. But actually, I don't believe that. I think you have to engage in battles when they're presented in the context in which you try to make the best strategic choices you can, but they're rarely ideal. And so you do what you can based on looking at the entire array of options and issues that are presented. And the other thing, I think, you're absolutely right. It's a constant, continuing challenge to try to decide, prioritize, and then move forward. At a certain point, I also think that if you make that decision, then you kind of have to stick with it, and then pursue it even as other issues emerge. Because in my view, one of the risks is that you're constantly pursuing the next issue and the next issue and the next issue, and then the issues that were important fall by the wayside. But what it fundamentally needs is more resources, more people, more lawyering on more issues, and then within that kind of larger community, trying to be as strategic as possible and allocating tasks, issues, and approaches based on expertise, priorities, importance, and strategic opportunity. But you're right, it's a constant and continuing question.
All right, we're out of time. I want to thank our panelists and first see if there are any
So, we'll take a break now, and lunch will be boxed lunches will be available out in the lobby. We ask that you, we'll start the lunchtime program at 12:15. So make sure you're back in here with your lunch by 12:15, and we'll resume that. Thank you. Really great. So we are enormously privileged to have Frank Sherry here to speak with us today. And before I introduce him, I did want to just turn the floor over to Lenny Benson from Professor Lenny Benson from New York Law School, who has an announcement that she would like to make for everyone.
Yes, thank you. Isn't this a fascinating subject we're doing today? Congratulations to Anil and to Drexel and the students. This New York State Bar Immigration Committee is holding a similar all-day COE on October 25th. It happens to be at my school, at New York Law School. It is more geared toward COE, in that many of the speakers are people like you're hearing today, but who are actually this mix of the academic thinking and the applied application. So their registration is still open. I would really encourage people to attend. Right now we have a very low attendance, but I'm just going to pitch one panel. If you can't even make for the whole conference, I think the cost of the conference is worth the last day. Because on one side of me, I'm moderating, is legal learners of the ACLU. Sorry, not Lucas, but the who can talk about the cases litigating right now, including the Third Circuit case. And on the other side is David McConnell, who is the lawyer now in charge of the Office of Immigration Litigation. So fireworks will begin on the last panel of that day, but all throughout the day is great. And thank you very much, Mel. You can find out how to register on the New York State Bar's Facebook page.
Great. And you should tweet out the link using the hashtag, and we'll make sure that.
Okay.
Great. All right. So we are enormously fortunate to have Frank Sherry here to speak with us today. Frank has been tirelessly working on behalf of immigrants and refugees in a variety of different settings for many years, and is one of the nation's leading and most visible spokespersons for immigration reform today. His interest in this work began soon after he graduated from Princeton and was teaching in Singapore at the United World College at a time when refugees were fleeing Vietnam in large numbers. And he soon left his teaching position and began working with the American Council of Nationalities Service in Southeast Asia, where he assisted with efforts to help these refugees resettle in Singapore and Indonesia. When he returned to the United States, he continued to work on refugee resettlement for ACNS, first working in Arkansas on efforts to resettle Cuban refugees, and later working to oversee the organization's resettlement programs in dozens of cities across the country. In the mid-1980s, Frank then moved to Boston and became executive director of Centro Presente, a local organization that worked with refugees who were fleeing civil war and human rights violations in Central America. And while he was in Boston, soon after the enactment of the Immigration Reform and Control Act of 1986, Frank co-founded the Massachusetts Immigrant and Refugee Advocacy Coalition, which initially was formed to serve and advocate on behalf of the individuals who were able to obtain legalization under the 1986 law in particular, but whose larger vision was to become a member-driven coalition that advocates on behalf of all foreign-born residents in the state more generally, and has become a very active voice and leading voice in New England. In 1990, Frank moved to Washington and became executive director of the National Immigration Forum, a position he served in for 17 years, taking a brief leave of absence in 1994 to work on the campaign against Proposition 187 in California, which I take it Frank will probably talk a little bit about. And while at the forum, he was involved in all of the key legislative debates about immigration in Washington, including the debates over the 1996 laws that we are considering today, but also debates over comprehensive immigration reform in the years since then, particularly during the second term of the Bush administration and a number of less visible immigration law initiatives in Congress. And in the wake of the failure to achieve comprehensive immigration reform during the second term of the Bush administration, Frank left the forum and founded America's Voice, which was conceived as an organization that would engage the subject of immigration reform more broadly with the public at large as kind of a communications war room, a hub to integrate various efforts to campaign for immigration reform around the country. Frank is also the 2015 recipient of the National Council of La Raza's Capital Award for Public Service, which honored his lifelong commitment and dedication to immigration reform. Now, to work on immigration reform issues in Washington has long been an unenviable, enormously challenging task. And frankly, I won't go so far as to say Sisyphean, because as an eternal optimist, I continue to hold out hope that immigration reform might ultimately still be achieved. But this is really daunting work. It involves a lot of difficult strategic choices and trade-offs that we can reflect upon for long periods of times afterwards. And I know a number of you in the room have worked with Frank in various capacities over the years, and that many of you who have not had occasion to work with him, and particularly those of you who have taken immigration law with me, have seen a glimpse of how daunting this work is by watching parts of the documentary series, How Democracy Works Now, which gives a window into the work that Frank and other advocates have done, along with legislatures, and just how difficult that environment can be. And that is much of that documentary series takes place at a time when the environment is nowhere near as toxic or dysfunctional as it has become in the last couple of years. So when planning this symposium, we could think of really very few people better positioned than Frank as someone who's been involved with the legislative process, who was involved in 1996, and has continued to remain actively engaged with it since then, to share some insights on what happened in Congress 20 years ago and some of the implications for immigration reform and the immigration reform agenda today, and some of the lessons learned during that period for advocates of immigration today. So thank you, Frank, and I'll turn it over to you.
Thank you. My PTSD is getting worse. All these amazing memories, and seeing so many people who have been fighting for so long and hard. And when Anil first invited me to do this, I was joking with some colleagues that maybe it's going to turn into an accountability session, because I'm one of those advocates in Washington who really didn't understand, as IRA and EDPA were going through, what the true implications would be in terms of particularly in terms of the evisceration of due process and the end to legalizing mechanisms that were throughout the bill, and what the long-term impacts would be. And we learned a lot. We started a campaign in 1997 called Fix 96, designed to try to roll back the excesses, the many excesses, some of the excesses from the many excesses from the legislation that had passed in 96. And as we had press conference after press conference of families that were being ripped apart by the retroactive application of tough laws and mandatory detention policies, etc., it was just heartbreaking to see how the legal framework that had been put in place in 96 ended up really going after people who were legal immigrants who had been in the country 20 years, who were business owners and military veterans, as Nancy was describing. Having kids stand up and say, why is the government taking my dad away from me? Was really remarkable. And Lucas mentioned Tony Lewis in his columns. I'm sure some of you were feeding him the cases that became the fodder for his pieces, but it was really tremendous. And we had some momentum. Fix 96 was resulting in enough pressure where by 2001, Jim Sensenbrenner, prominent in the Judiciary Committee at that point, had agreed to a fix on retroactivity. And I remember my colleague Angie Kelly was meeting with a bunch of advocates in Senator Daschle's office. There was also a minor fix on something called 245I, another legalizing mechanism. And as they were sitting there talking about the final details, they were told to get the hell out of the Capitol because planes were flying into the World Trade Center and one might be headed for the Capitol that they were sitting in. Needless to say, that retroactivity fix did not get through Congress, nor did the 245I extension. But it shows, I think, some of the roller coaster ride that is the immigration policy debate, one of which I relived during the introduction. But I'm really going to focus on what was the context for the 96 debate. How did the proponents of the legislation, what were they going for? How did advocates respond? and then talk a little bit about how things have changed. Also about how things haven't changed, but also but to talk about where we are now and some of the implications going forward. Let me say that it's really hard to understand now the legislative context in the mid-90s. Let me try to tell you what it was like. See, immigration was not the issue that it is today. It wasn't central to a presidential campaign. It wasn't a major, there weren't huge constituencies that were mobilized on this issue the way there are today. It was really a niche issue. And how immigration policy was mostly done was top-down. Ted Kennedy would decide he wants to do the U.S. Refugee Act in 1980, and he would push it through. A Hesburgh Commission appointed by Jimmy Carter had two young members of Congress on it named Alan Simpson and Ron Mazzoli, and they came up with the idea of what became IRCA, the Immigration Reform and Control Act in 1986. As part of the recommendations of the Hesburgh Commission, they said we need to limit, cut down, reorient legal immigration. And so it led to a big debate that became the 1990 Immigration Act, which was for really the first time advocates, pro-immigrant advocates, were able to be strong enough to push the bill in a more positive direction and essentially outflank Kennedy and Simpson and come up with a bill that increased legal immigration and a bill that actually had family fairness provisions that allowed a lot of the family members of those who had been legalized under IRCA to get status. And so we thought the 1990 bill on balance was kind of a win. And I remember I came to Washington in 1990 and bought a suit to go to town and promised my progressive friends I would never become one of them. Stay tuned. We thought we're on offense and we could keep moving things forward. Well, we then became faced with really the biggest populist, nativist backlash that we had experienced up until then in our generation, right? So I remember the first budget that Bill Clinton presented, he actually cut Border Patrol because nobody was paying much attention, right? Doris Meisner and Alex Alenikofer at INS, how could we go wrong? But then the anti-immigrant groups were really effective at using the media to start to focus on the out-of-control border. Remember news magazine shows? Not just 60 Minutes, but 2020. There was every network had them. Every single one of them did multiple stories on how our borders are out of control. That soccer field in Tijuana where people used to amass and run across was highlighted. The B-roll is still used today from 1992, 93. And there was this drumbeat of our borders are out of control, a recession that had allowed Bill Clinton to beat George H.W. Bush in the presidential election was hitting strongly. And we were still in Washington and talking to our friends around the country about what positive changes we could get. Let's focus on Haitians as the first issue out of the box with the Clinton administration. And then the World Trade Center bombing happened in 1994. 4 individuals, a couple of whom had applied for asylum after having come through JFK. The next Sunday after the World Trade Center attack, Leslie Stahl did a 60-minute segment with Dan Stein of FAIR. It happened to be the same night there was a snowstorm, so it had the largest audience it had had in years. And Dan Stein talked about how all you have to say are the magic words political asylum at our airports, and you can come in and kill Americans. Needless to say, all hell broke loose. At the time, the focus was on asylum. It looked like we were going to lose on asylum legislation. I agree with Alex. I thought the administration did a good job of co-opting the reform mantle so that they could preserve the basics of asylum in a new way. It was a very effective plan, effective strategy, rather, to avoid the legislation that was being pushed by Republicans and Democrats in Congress. And then Proposition 187 was qualified for the ballot in California. And I took a leave of absence and went out and worked on it. And I couldn't believe the legitimization of hate that came when a governor stood up and said, the problems in this state are because of those people, and they keep coming. It was a terrifying thing. I also saw another thing, and I'm going to talk some about this, which is that we as advocates in this field were not built for the fight that we were having. We were policy experts trying to figure out how we could work the inside with our champions and our friends to get improvements in policy, while the other side was working the media and working the politics to drive a backlash that was overwhelming our politics. And so when Proposition 187 passed in November of 1994 by a 3-2 margin in California, remarkable to think about California now as the home of the most pro-immigrant policies in the nation, a state that's gone from purplish to blue, in part because of the backlash to Proposition 187, it passed by a 3-2 margin. In California, the same election brought in the Gingrich Republican Revolution and appointed the chairs of the Senate and House Immigration Committees, Alan Simpson and Lamar Smith. And those two guys sharpened their knives and said, let's go for it. Let's go for what we termed at the time. In Europe, at the time, they were talking a lot about how they wanted zero immigration. And at the time, these gentlemen were proposing legislative vehicles, slightly different in each chamber. Smith a little bit more hard-edged on some things. Simpson a little bit more focused on other things, but the same basic idea, which was an Americanized version of zero immigration. So, and the most amazing thing on top of all of this was that a new commission had been appointed, something called the Commission on Immigration Reform, which had come out of the 1990 Immigration Act, and it was headed by Barbara Jordan, the civil rights icon from Houston, Texas, former member of Congress. And they decided that they were going, given the backlash, given the fact that awful legislation was inevitable, they decided to ride the wave, but to try to hold it back just a little bit. And so they, in fact, ended up essentially legitimizing the structure of the legislative strategies of Lamar Smith and Alan Simpson, even as they would argue they were trying to restrain them somewhat. For example, the proposals that were in the Jordan Commission and that were part of the legislative packages, a 40% cut in legal immigration. In fact, the House version of a bill had a sunset provision, which was the dream of the anti-immigrant groups like FAIR. The idea that in 10 years, legal immigration would sunset and Congress would have to affirmatively vote for it to restart it, was the idea that they could finally end legal immigration in America, which is their top priority. The other big priority they had was to limit the number of refugees. They wanted a cap of 50,000. They wanted to restrict asylum significantly. And they wanted a mandatory employment verification system, what we now call mandatory E-Verify. But that was the idea, was let's make sure that undocumented workers cannot get work in the United States as much as possible in hopes of driving them out. What later has become known as attrition through enforcement, or as Mitt Romney called it, self-deportation. In addition, they went after benefits, all manner of benefits for legal immigrants and others. They wanted to securitize immigration through EDPA, as was discussed earlier. And we had already lost the argument about border enforcement. The Clinton administration had decided after that first budget to build up border enforcement. If you remember Sylvester Reyes, the Border Patrol guy in charge in Texas, started Operation Blockade, and essentially said, we can stop people from coming across the border. It was renamed, thankfully, but also spread along the border. And the idea of border enforcement being something that can be done and done effectively took hold, and the Clinton administration backed it strongly. And of course, the more difficult provisions were this notion of let's cut off the legalizing mechanisms. This is what Lamar Smith really wanted to do in his staff. 245I, where you could take advantage of a legal immigration petition and pay money rather than having to leave the country. 212C, where there was a balancing test in terms of equities that was referenced earlier. I mean, the 3 and 10-year bars, you know where those came from? I can tell you where they came from. This is how ridiculous the debate was in a way, but also how naive we were. So, because we lost the border argument, some of us, like me, were saying, let's enforce the laws at the border, not in the interior. And the folks on the border were so upset, you're throwing us under the bus, you're caving, you're giving in to the opposition's frame, you're militarizing our border and our communities, how dare you? And so we said, okay, great. Let's all talk about the fact that 40% of the undocumented population comes in on visas and overstays. And we thought this would take pressure off of the border. All it led to was the 3 and 10-year bars. Okay, good, we'll build up at the border, and then we'll cut off people who have come in illegally and overstayed so that they can't take advantage of their perfidy. Not a very smart move on our part in the end. Nevertheless, we were in a very tough battle, and we weren't prepared for it. This is where some of us, starting with me, made some very controversial decisions. I remember in the spring of 2006, the House bill had passed in March by a margin of 257 to 163, meaning that almost all Republicans and an unhealthy number of Democrats had voted for it. And then in May, a bill that focused on primarily unauthorized immigration passed the Senate by a margin of 97 to 3. I remember talking to Ted Kennedy's chief staff person at the time, Michael Myers, who voted for the bill, and talking to Howard Berman, our champion in the House. These were our champions saying, you guys are so out of touch from the debate, nobody's listening to you. You guys are irrelevant, you're marginalized. You might as well, actually when you speak up, you hurt us on the inside. You don't have enough strength, the other side is dominating the debate, and you're not being pragmatic and helping us. At the time, my organization was engaged in doing something we had never done before, which was some public opinion research. And we realized that I went in with the assumption that our messaging at the time was politicians are scapegoating immigrants, immigrants are good for the economy, that this backlash is based on ignorance, they don't know the real facts, and that the leaders of the movement are operating based on racism, which I actually think is accurate, to be honest, okay? We were speaking truth to power, we thought. Unfortunately, nobody much was listening to us. And we did public opinion research, and we realized a pretty remarkable thing, that we were speaking to 10% of the population when we said that. That the other side, their hardline views represented 10% of the population. And that the middle was comprised of 80% of the American people, cut pretty much right down the middle in terms of leaning anti or leaning pro. And the analysis that was given to me by a progressive communicator who ended up working for the ACLU, Emily Tynes, she sat me down, she said, Frank, I'm going to give it to you straight. You should be working for the other side. You should be. For every one person you motivate, you lose 3 people. You have completely ceded the middle to the other side. So when they talk about reform, when they talk about control, when they talk about fixing, they win the majority of the American people because the American people think something's wrong, something's not working. And when you say they're stupid, they're racist, and they don't understand, it doesn't convince many people. So we decided to reorient our approach. And this was a very difficult decision, controversial to this day, that we decided to be pragmatic and say, all right, let's triage. What can we do to blunt this huge nativist backlash with 2 prominent members of Congress driving it, with a civil rights icon running shotgun for it, and a president that was weakened and triangulated. So we decided to say, all right, let's see how many things we can gain traction on. What gained the most traction was the idea that we should distinguish between legal and illegal immigration. It became known in the tactical jargon of the day as split the bill, but it was, wait a minute, legal immigration is different than illegal immigration, and as we used to say ad nauseum, yes, there may be a right way and a wrong way to come into the country. There's also a right way and a wrong way to deal with illegal immigration. And we thought that if we did focus on border enforcement, we would gain some traction on interior enforcement. And I'll be honest, our biggest priority on interior enforcement was mandatory employment verification. The idea that the millions of workers in the United States without papers would suddenly be faced with a retroactive application of an electronic verification system to replace the paper-based system that was pretty easy to get around, even if it led to more exploitation and lower wages for undocumented workers. The fact is, I was working at the time when employer sanctions went into effect with a mostly undocumented community of Central Americans in the Boston area, and for like 6 months we were like so worried. And then after that we were like, okay, we got this. We got this. People could get documents, they could get jobs, they could be grandfathered into their jobs, and there was not only a stability in the community that existed, family members kept coming from Central America because most of them had to, given the Civil War conditions that they were facing back home. In any case, it was a difficult set of arguments. The folks on the border were rightfully saying, you've thrown us under the bus. The issues on benefits and due process and enforcement, we couldn't even get to. And some argued we made it worse. But here's how it all shook out in terms of results. Legal immigration, again, they wanted to sunset it after 10 years, cut it by 40%. The bills were, in fact, split. The legal immigration provisions were defeated. The refugee cap, defeated. The asylum restrictions, mostly defeated, but as Eleanor rightfully said, a number of pernicious provisions that have had a big impact on people's right to apply for asylum are huge problems. But in fact, the Clinton administration, the Doris Meissner, Alex Alenikov reforms had largely undercut the argument for sweeping legislation on asylum. The legalizing mechanisms, lost. E-Verify, man, that was not a well-known fight. In fact, we were helped a great deal by our friends on the right. We had worked with our friends in the conservative right. A guy named Paul Ryan was part of the right-left coalition. Go figure. Grover Norquist, Steve Moore, who's gone over to the other side now. But all these like luminaries of the right now were young pups working for Jack Kemp and Bill Bennett and pro-immigration guys. They helped us split the bill and get some Republican support for that. And on employer sanctions, what they did is Grover Norquist's crowd, they put barcodes on their wrists and went around to all these newly elected libertarian House members and said, are you going to vote for this? It was crude and effective. And Dick Armey told Lamar Smith, go work out a deal with the National Federation of Independent Businesses, and they came up with voluntary E-Verify rather than mandatory. Boy, talk about dodging a bullet on that one. But on court stripping, on due process, on enforcement, on mandatory detention, 287G, all of that stuff was passed in IRA. Benefits, and we had, it was like we had a three-headed monster. It was like IRA was moving, EDPA was moving, welfare reform was moving, right? Remember NCLR, National Council of La Raza, was taking the lead on benefits. They couldn't do we work on the immigration bill? Do we work on the welfare reform bill? Because the target kept moving. And ultimately, we suffered big losses in terms of benefit access. So, and then there was a final fight. Anyone here remember the Gallegly amendments? Sorry, we're just going to talk about that for a second. So Elton Gallegly was a congressman from California. We used to refer to him as that punk from Orange County. Actually, he was from Simi Valley, I'm sorry. Didn't mean to besmirch Orange County. Nevertheless, he had an amendment. He wanted to federalize Prop 187, give states the right to kick kids out of school. Let's let states decide. That was a federalist proposal that was popular with the newly elected members of the Republican majority, and it started to get tremendous momentum. I remember the first meeting we had with advocates, and it was the usual suspects, and we were sitting around, and I was like, what do we do? And it was like, let's do a sign-on letter saying, how dare you do that to children? I had just been flushed from looking at all of this public opinion research and engaging in this pragmatic strategy that was hugely controversial, but it was starting to connect with people in the middle and with members of Congress so that they could find their voice and stick up for us. And I said, that shit ain't gonna work. So we adopted a very controversial strategy again. Through our friends in the unions, we talked to a police union about whether one of them would be willing to wear a uniform and come to a press conference. This guy from Baltimore did. I'll never forget it. We wrote his statement, and he stood up at a press conference, and the people covering the bill were all there saying, why is a cop talking about immigration? And he said, I can't believe these fools in Congress want to kick kids out of school. What I do every day is to make sure kids are not vulnerable to predators and are not hanging out on street corners so they get into trouble. And these members of Congress are going to put kids out on streets where they're vulnerable and where they might get into trouble or they might be victims of crimes. Tell those jerks to stop making my job more difficult. Now, not everybody liked this strategy, I will admit. But what happened is that it snowballed, and within about 6 weeks, every major police organization in the United States had come out against the Gallagher Amendment. This was not about save the children, it was about how dare you be stupid, you members of Congress, and making our cops' lives more difficult. We knew we were winning when the NRA front group, they have a police group that's a front group that they use, came out in favor of the Gallagher Amendment. And when the debate was between 25 police organizations and police chiefs against the NRA front, we knew we were going to win. And in fact, Bill Clinton promised to veto the bill. Remember this, Alex? He said, if the Gallagher Amendment is in the bill, I will veto it. And we were like, please, Republicans, be stupid enough to keep it in. Please, give Clinton an excuse to veto it, and we'll make it about that issue rather than all the other stuff that we couldn't win on. Unfortunately, they gave Gallagher a show vote in the House where it passed, stripped it from the final bill, and IRA passed. And, you know, what happened? That framework became the platform upon which became built the incredible enforcement machinery that exists now. It wasn't the thing that built up the enforcement machinery. That came with bipartisan collusion on ever-increasing budgets for what became CPD and then became ICE, etc. And what now, as Doris Meisner wrote for MPI, Migration Policy Institute, an $18 billion enforcement machinery that is a larger federal investment in the criminalization of immigrants than in all the other federal crime-fighting activities combined. This, of course, was accelerated by 9/11, and of the many things that happened after 9/11, sweep of Muslims, Arabs, registration program through NSEERS, was a young lawyer at the Department of Justice named Chris Kobach decided to use 287G to go as far and wide as possible so that police could turn people over people they apprehended who were undocumented immigrants, which was then put on steroids by the Obama administration through Secure Communities, a Secure Communities program that the Bush administration had started to go after the worst of the worst, was then expanded to become a dragnet that led to the 400,000 a year deportations in the first 6 years of the Obama administration. So, when this bill passed, I didn't realize exactly what was to follow. But given the backlash, given the challenges we faced, we made tough decisions, and we can debate whether they were the right ones or if we had better options. I'm sure there are people in this room who don't think that was the best way to go, but that is how it came to be. Now, let me turn to what it means for today. So what has happened in the recent years as reform in Congress has been blocked by Republicans repeatedly? comprehensive immigration reform is the buzzword, but any kind of reform that's positive, let's be honest. DREAM Act, I mean, you name it, the Republicans have figured out a way to block it. And Democrats weren't, let me just be clear, Democrats didn't always have their heart in it. Democrats have been divided as well. About 2/3 of Democrats sort of pro-immigrant, 1/3 against. That has changed now. And in the Republicans, about 1/3 of Republicans pro-immigrant, 2/3 against. That has been intensified recently. But the fact is that we couldn't get reform, we couldn't get legislation enacted, meaningful legislation enacted. We had a few wins in the late 90s and in 2000, but after 9/11, we've been on defense again. And then it was comprehensive immigration reform, which was, let's increase legal immigration, let's legalize undocumented immigrants, and let's have, this was the goal, targeted enforcement, particularly mandatory E-Verify, because once you legalize the workforce, then having a new labor standard of employment verification made sense. If you had employment verification without the legalized workforce, you would in fact drive people further underground as well as out of the country. So that was the idea. Reform has been blocked, and I have to give credit. I mean, look, it's been grassroots activists in our movement and local policy advocates working on the front line who said, you know what? We can no longer just stand by while enforcement gets ramped up and Congress blocks reform. We have to shift the paradigm. And they argued that we have to challenge the enforcement platform and enforcement priorities and the fact that so many people are getting caught up in the system. And, you know, people always ask me, how did Obama miss it? Why was he deporting 400,000 people a year when the movement was getting stronger and stronger in opposition to him? And it's because he was operating from the old paradigm that said, you got to do strong enforcement in order to win over Republicans. And that if he showed he was tough here, he would get the goodies there. And we would have a modernized system that would then have a whole paradigm shift that could be refined going forward. That's been the presumption. It's one that I used to share. But by the time they were gearing up to 400,000 a year and 30,000 people were being detained every night, etc., due process eviscerated, no legalizing mechanisms, a swelling undocumented population, police stopping people for driving without a license and turning them over to the deportation machine, raids being carried out by ICE agents, etc., etc., etc. Fact is that they were right, and the whole movement finally came around. That's what led to DACA for Dreamers. That's what led to DAPA and DACA expansion, which we know is held up in the courts. But for people in this room, just as important as far as I'm concerned is the fact that there's been a huge shift in enforcement priorities by the Obama administration that isn't subject to litigation, that has led to a reduction in deportation. It's not enough. We haven't realized the promise. If they can find somebody with a 20-year-old DUI, they're going to go after them. It's stupid. There's not the balancing test and the equities that are in the memo but not being implemented. But nevertheless, there has been a shift. And more importantly than that even is the incredible work that's been done at the state and local level. Right? California, the Trust Act, right? 300 cities across the country limiting the police cooperation with immigration enforcement agents. Measures like ID cards, driver's licenses, in-state tuition, access to services. It's not everywhere. We know there's the Arizona push to make life more difficult, but there's now the California plus push to make life more normal. So what does this mean going forward? And I'll end with this. Look, I understand that it may look right now, given the enforcement machinery and the rise of Trump, that we're in a whole heap of trouble. I actually do see it differently than that. From my point of view, and I'll explain this, I think the rise of Trump is more like they're not going down easy, but they're going down. That this witch's brew of nativism and racism and xenophobia and misogyny, othering of everybody that's not a white nationalist, is actually the death throes of fascist movement in this country. It's not going to go down easy, and it's not going to be quick. But the fact that you have a whole slice of Republicans saying, I can't vote for that guy. We're not talking, Democrats are now unified in favor of immigration. Hillary Clinton and Bernie Sanders were fighting with each other, neither of which has a distinguished past on immigration. Let's just tell the truth. Both of whom were fighting with each other over who's more pro-immigrant. Everything I know about Hillary Clinton is that she's not talking smack, she actually believes it. She's going to make immigration a priority. Unlike Obama, who promised it and didn't do it, I actually have confidence that Hillary's promise is going to be followed through on. When you look at public opinion in this country, it's amazing. In 1994, when Pew first asked, do you think immigrants are a burden on this country? Or do you think that they strengthen America? It was 2-to-1 against immigrants. That was the public opinion climate that shaped the IRA debate. Now it's 2-to-1 in favor of immigrants. That basic temperature taking, what happens is that as immigrants have moved throughout the country and they're better known, public opinion goes up. The people who are most hostile to immigrants don't know them. Or they're in communities where new arrivals have shown up and they're scary others rather than new neighbors. But that process, as difficult as it can be, does work itself out. Look at California. Look at California today as opposed to 1994. On the question of legalization of undocumented immigrants, the country's decided 4-to-1 in favor. 4-to-1. Latest CNN poll was 88%. Latest, I think it was a Pew poll, was 84%. 40% of Trump supporters support legalization. We have won that argument. Right? Muslim ban, 60% opposed. Build the wall, 60% opposed. Stop the Syrian refugee program, 60% opposed. We're winning this argument. We don't have a Congress at the federal level that is going to pass federal legislation so easily, because in our world, that's essentially what we need to do given the federal primacy on immigration policy. So, look, there's going to be a fight on immigration reform next year. If the Senate flips to Democrats and Hillary wins the presidency, look, if the House flips, we're going to have immigration reform. If the House doesn't flip, which is what most people are predicting, it comes down to Paul Ryan, my old buddy from the right-left days in the 90s. I don't have any doubt that he wants reform. I don't have any doubt that his party is going to make it damn difficult for him to pass reform. So I think there'll be a 6-month push for immigration reform next year. And my hope is that the administration doesn't wait on everything else, that we move forward, end family detention, reorient enforcement priorities, make sure that the agents are not going after people willy-nilly, have balancing tests that are real, make sure that we reorient our Central American refugee policy away from deterrence and deportation and detention towards one of protection and regionalization and orderly resettlement. Lots of things that can be done that are not executive actions in the way that Republicans will freak out about. So yeah, I think there'll be a moment of truth on whether reform passes or not. And that'll be much more about the future of the Republican Party than the future of the country. Because we've decided, immigrants are good for America, we should accept refugees, we shouldn't treat religious minorities as the other, and we should make sure that we're a country where our differences are seen as a source of strength rather than as a source of threat. You think of this campaign, it used to be like most campaigns were like right versus left. This campaign is a different axis. It's a similar axis to what you see in Europe. The axis isn't so much right-left, it's white nationalism against pluralistic nationalism. Right? I love the Democratic Convention. Instead of that laundry list of progressive ideas that we always do, they were actually talking about America that's inclusive, that works, that the promise of America is realizing its ideals as we become more diverse. Diversity doesn't threaten American ideals, it's to fulfill the promise of American ideals. So I'm optimistic that we are winning the big argument. We are winning the big policy arguments. We're frustrated by a deadlocked Supreme Court, by a federal district court judge in Texas, and by Republicans in Congress who are dead-enders, as far as I'm concerned. who will be written in the history books as the people who may have blocked reforms for a few more years, but they ultimately failed. Because the American people want policies that are pragmatic and humane and are as good as our ideals and values. And that's at the federal level. I can see if the Republicans in the courts want to keep blocking federal reforms through Congress, et cetera, and through executive actions, I imagine there's going to be more advances every day at the state and local level, particularly in blue states. But you're going to have more and more policies designed to normalize, welcome, integrate, and treat equitably immigrants even if they don't have papers. I can imagine a day, I know it freaks out my legal friends here who fought Arizona and state-based policies. I can see a Colorado-like marijuana legalization bill translated into a state-based employment project where they defy federal law and they say, if you have a driver's license, you're eligible to work in our state. I can see it. If they keep blocking, because there's too much power in our movement. There's too much conviction in our society. There's too much of a demand for getting it right. So, I will end with this, I swear I know. So here's the thing. A lot of us used to think that it was like immigration reform or nothing. I think we need a new way to measure our success when we look at state, local, federal, administrative, and legislative changes. I think that there's an axis that we need to articulate that where on one end it's legalization measures, and on the other end it's decriminalization measures, and we're trying to enact a whole set of policies at the local, state, and federal level to decriminalize community trust policies, what the opponents call sanctuary cities. I mean, telling cops not to collude with ICE agents so that you undermine community policing is not sanctuary, that's smart policing, right? Decriminalization measures that reduce deportations, that get people out of detention, that allow people to live without the fear of that knock on the door, or that raid at the school. I know they're off limits, I know. Tell that to Wilden from North Carolina who got picked up at the school bus. And then the legalization measures. DACA, DAPA, deferred action, driver's licenses, in-state tuition. Let's come up with a way in which we're normalizing it. I admit, I thought that we would pass immigration reform, have a new paradigm, and spend the next 25 years detailing it, refining it, and making it work. I get it. Maybe it's going to be the LGBT model, where we're going to create facts on the ground at the local and state level and everywhere we can, and then the big federal win comes at nearer to the end. I'll take it. My approach, everybody asks, well, what's the approach next year? All of the above. All of the above. Because we got juice, we got power, we need to translate it into policy. It takes what it takes, you know. Everyone says, well, 40 years civil rights movement, it was really hard. Man, I am pissed off it's taken so long. But I am confident that our power and our drive and our resilience is going to lead, even if it's incremental and in stages, to people being treated not only just in a way that they're tolerated or welcomed, but that they're treated equally. Thank you.
So we have about 10 minutes or so for questions. 7 minutes?
A fact question. Frank, do you remember when I heard Lamar Smith really wanted to eliminate the brother and sister category, so EBs, family-based fourth preference, and that he got a lot of pushback from the South Asian and the Asian community because of the messages of discrimination, etc. And then what he did instead was raise the poverty guideline sponsorship. So it used to be you had to be at 100% of poverty line at a time. Through. Like he had to keep the 65,000 visas, but
yeah.
He raised the bar for everybody.
I mean, the way I remember it is that in March in the House floor, it was not predictable at all, but the split the bill move, an amendment from the floor passed. Lamar Smith's staff was crying on the House floor, which we felt pretty good about, I have to say. I know it's a little mean, but we felt pretty good about it. So then Smith went for the 125% of poverty for sponsors. And in fact, that was on the table and in the bill right before. I remember a meeting with Howard Berman, who was going, because Lamar Smith wanted Howard Berman's support to kind of give him bipartisan cover for the bill. Lamar and Howard called a bunch of us together and said, all right, he's giving me an hour, I can probably get 3 or 4 issues done. What I do, and there were like 20 of us in the room, and we were all like, our issue, our issue. But I remember our issue at the time was the 125%, because it would have effectively cut out, I was just looking at some old papers, 40% of legal immigrants. So it was a backdoor way to try to get that 40% cut.
Professor Wishney?
I know this is something you think deeply about and have thought deeply about for a long time, and I want to invite you to share some thinking about this. So one of the greatest fears of myself, but I think of many, is that at the moment of truth, a huge amount of enforcement is traded for some legalization. Enforcement against people with convictions, or documented, or otherwise undesirable. But what I thought you might reflect on is that process, because there's a fear that at that moment, it's a small group of people in a room in Washington, D.C. making those calls. And so when you hear calls like no more meetings about us, without us, how do you negotiate commitment to movement and grassroots that I know you grew up in and share with the reality that you don't have the entire movement in the room when the tough calls get made?
Yeah. Yeah, no, I've been in a few back rooms cutting deals that people didn't like, but it doesn't happen that way anymore. At least not in the same way. The movement is very strong, very diverse, and very capable of making their voices heard in a way that gives, I don't feel nearly the pressure I used to feel, quite frankly, because there's going to be a movement expressing itself with a variety of opinions, and members of Congress trying to figure out how they're going to make their calculations. And to me, what I like about it is that the power of the movement is more important than the differences between us. And I don't spend nearly as much time getting worked up about some of those calls the way I used to, mainly because we were kind of responsible for making those calls. Not the case now. So in the 2013-2014 debate, Eleanor and I were talking about this. I mean, you know, there was an awful last-minute move to get this Corker-Hoven amendment that had $44 billion in border enforcement and taking some money away from benefits for immigrants through the Social Security system. And it was to get the last handful of conservative Democrat and Republican votes to get to 68 votes. And that was a move that none of us liked. We all protested. And almost all of us, once it happened, said, yeah, but we should still pass the bill. It was very modest peel-off as a result, mainly because we had the House to fight for. And here's the thing about the Senate bill that I think needs to be said a little bit more. I'm a little bit worried about the live stream, but let's just try it. There were a lot. I mean, the 2007 bill was loaded up on enforcement that would make you cry. The 2013 bill had targeted enforcement and a lot of improvement mechanisms throughout. Asylum, humanitarian parole, right? Very little interior enforcement in the same way. So we're making progress because of the movement's strength. And so I don't get so caught up in the specific things as much. It's like, how can we cultivate that power so that overall the center of the debate is much more in line with where we are than it was 10 years ago. So, you know, the good news is that undocumented immigrants are getting into the meetings. You know, I sat next to Lorella Praeli of United We Dream in the tensest meeting with Obama, where, oh my God, it was ugly. March of 2014, he was saying, I can't do executive action. We have to keep waiting on John Boehner for legislation. And half of us in the room were saying, that is such bullshit to be waiting on John Boehner when he already told you can't do it. You're just using it as an excuse not to use your own authority to move forward and make people's lives better. And, you know, Lorella is now the Latino outreach director for the Hillary Rodham Clinton campaign, and probably going to be in the White House, you know, carving this stuff out. It's like, she's not only in the meeting, she'll be calling the meeting. And Bernie's people had tremendous folks better part of it, et cetera. So to me, that it's so different now than it was in the mid-90s, in the best way. That the idea of a small, even if we wanted to, a small group of us, you know what? Whenever there's an attempt like that, sometimes there is on specific issues, and a small group will go into a member of Congress or staffers and say, this is what we really want. And the first thing they say is, yeah, and what kind of blowback are we going to get from the movement? That speaks to our power, and as far as I'm concerned, that's a good thing.
So I have a queue of 3 questions, and so maybe we'll just take all 3 at once, and then you can just take a couple minutes to respond. So we'll start here, and then go to Professor Ramji Nogales, and then
my question's about, I'd just like you to comment on the fourth branch of government, implementation and administration. You've got CBP and ICE officers in open mutiny. They have their own ways of doing things out on the border and on the line and at the airports and everything else. And I would say to people, you can enact legislation, but ultimately that legislation is going to have to be carried out. And we know the attitudes of these government employees are. They've come out forcibly, organized, to criticize the things that they don't like. And it concerns me, I used to work for the government, that ultimately when you talk about prosecutorial discretion, when you talk about arrest, when you talk about apprehension, implementation, and all these other things, you're dealing with a lot of resistance. I just wonder if you can comment on that.
So you talked a lot about preferences shifting, and I wanted to hear a little bit about your thoughts about the way the demographics of this country are changing and how that has influenced the shift we see and how they influence the shifts going forward. I think in California, this is now majority minority as that comes across the country, right? How's that going to change? We saw in the last election the role that Asian Americans, Latinos played in electing Obama, right? The most recent polls are showing that Asian Americans are leaving the level of party roads. So how has that affected the shift and how has it affected the shifts going forward?
So just so folks who couldn't hear in the back, the question concerns not just preferences shifting, but also the changing demography of the country. How is that affecting the shifting in terms of the debate? And then last question.
I was actually looking at 5 in the morning.
Oh, all right, good. So, which I have blown right through. So, Frank, what's your last name?
I agree. I agree with you that we have a huge problem. The unions at CIS and CPB and ICE are mostly fully in line with the hardline anti-immigrant groups in this country. At least 2 of the unions are supporting Trump for the first time. And we all know that they've been operating mostly with impunity and accountability for way too long. So I just think it's a long time. You know, I'm watching carefully the kind of efforts at police reform, because I think that that's going to help us figure out how to. There's not been enough energy. There's been great work at the border. There's been great work in individual communities on holding ICE directors accountable. New Orleans, Detroit, some places like that. There needs to be a whole lot more. And I think, quite frankly, some progressives have been a little afraid of going after unions that are part of the AFL-CIO. I think that's going to end. And plus, the AFL-CIO has its own problems with these unions. So I do think that we need to up our game on pressuring politically, as well as holding more accountable in terms of the performance of their duties. So I'd say we're at 5 after, and we need to be at 10 of. We've got a long way to go. In terms of demographics, that is so fundamental to the shift that's going on. What happened in California from a purple state to a blue state, a state where now there are no Republicans holding statewide office. The legislature is controlled by a supermajority of Democrats. And it's almost impossible for the Republican Party to survive in that state. That is a cautionary tale for many other states that are now flipping. So you'll see it in this election. Nevada, Colorado, New Mexico's already gone blue. Florida, of course, North Carolina, Virginia, and even smaller populations of Latinos, Asians, and American Muslims are making a big difference in some other states. So I do think that the demographic shift means that, I mean, the smart Republicans scream from the rooftops, you cannot win an election by trying to maximize the white vote. So during the immigration reform debate, when there was so much post-Mitt Romney, he got spanked by Latino and Asian voters, we better pass reform or else, there was an alternative strategy. It was popularized by a political scientist by the name of Sean Trendy, called the missing whites theory. That, yeah, maybe you can increase your percentage with Latinos and Asians, but there's all these whites who are disaffected and don't come to the polls. And if you had a special kind of candidate who could appeal to the missing whites, then you could write off the Latinos and Asians and I've already written off the African Americans, and appeal to those missing whites, produce a huge turnout, and turn this demographic argument on its head. Well, we're about 25 days from a grand experiment in the missing white theory, on steroids, turbocharged, in a way that none of us could have ever imagined, honestly, at least for me. And I get the white nationalism in the GOP, but this is wow. And so the missing white theory, if it's discredited this time after being fully tried, I think is going to mean that at least those elements of the Republican Party who realize that they might want to see the White House before they die are going to have to actually change and modernize. But it's good. There's going to be a civil war in the GOP. Immigration reform, in a sense, is hostage to that civil war. Is it Paul Ryan's party or Donald Trump's party? All that stuff. I don't, I'm kind of like, I don't have a lot to say. I don't have a lot of influence on that. I'm interested in making sure that our movement gets stronger, that we pressure at the local, state, and federal level. We get Democrats to lean in. We get Hillary Clinton to be held accountable for her promises. We get local and state legislators and administrators to do the right thing. And we make life better for as many people as we can. And we take our shots when we get it.
All right, great. So join me in thanking Frank Cherny.
Maybe my organization.
Okay, sounds good.
Somewhere where we can sit down.
Is this on? It's a tough act to follow, such an inspiring keynote address. And I just wanted to say one other small way that maybe that Frank can inspire us is that I've been informed that at least earlier in the morning, some of the people following on social media, maybe in the back of the room, are having a little bit of trouble hearing from the microphone. So if we could let Frank's voice and projection be an inspiration for how we talk for the remaining panels. And I feel very lucky to be sitting at the table with this wonderful group of panelists who are going to be talking about contemporary strategies to advance immigration rights. But before we start the panel, I just want to remind everybody that the symposium is being streamed live and will be recorded. And please silence your cell phones. For individuals participating by live stream, if you wish to join the conversation on Twitter, please use the hashtag #Drexel LR16. And if you wish to email questions, send them by email to Drexel LR16@drexel.edu. So as I said, this panel is Contemporary Strategies to Advance Immigrants' Rights. And our panelists are Allison Parker, who's the director of the U.S. program Human Rights Watch, the Honorable Helen Gim, Councilwoman at Large for the Philadelphia City Council, Caitlin Berry, Assistant Professor of Law and Director of the Farm Workers Legal Aid Clinic, and co-director of the Community Interpreter Internship Program at Villanova University Charles Widger School of Law, and Michael Wishney, the Deputy Dean for Experiential Education and the William O. Douglas Clinical Professor of Law, and the Director of the Jerome N. Frank Legal Services Organization at Yale Law School.
Key fundamental human rights violations that are represented.
But my intention today is to map out for you
Where we're still very concerned and still fighting, and then offer a few places where we've had some success. I thought I'd start out by just outlining for you 3 of the key violations that I think are amongst those that are most concerning in the laws, many of which you've heard about earlier today, but just to rename them. The first is the establishment of expedited removal, which has the unfortunate effect of returning people to places where they fear persecution and suffer harm. We at Human Rights Watch have been engaged in trying to document how these procedures have worked in fact, in real lives. There is a report available on our website called "You Don't Have Rights Here," which is a direct quote from a Border Patrol official to a person fleeing from Honduras. And what this report shows through interviews that we conducted in Honduras
is that CPB is in fact not letting people through into the credible fear process, and that people who are in fact fleeing for their lives are being sent back. The second area that I wanted to highlight for you is the fundamental human right to family unity. There's been a lot of reference to this as well, obviously, in our discussion today. The fact that there is no longer a means for most people to have a balancing test before they're removed from the country that takes into account their family relationships constitutes a violation of international human rights law. There is a good decision on this coming out of the Inter-American Commission for Human Rights, a case we were involved with called Armendariz. And this case shows that the U.S. law is in violation of the American Convention because of the failure to provide that kind of test. The third area that we have been very engaged with has been the problem of widespread and unnecessary use of immigration detention. And that's where I really want to focus my attention today. Immigration detention in this country is not per se a human rights violation. The U.S. has a right to regulate migration, and civil detention of immigrants is permitted under international human rights law. However, as Eleanor Acer explained earlier today, the United States is bound under international human rights law to refrain from engaging in arbitrary, prolonged, or indefinite detention, to refrain from detaining vulnerable populations such as children and refugees, to provide a prompt and periodic opportunity to challenge the basis for detention to detainees. Essentially, immigration detention should be a measure of last resort. Under the concluding observations under Article 9 of the ICCPR, which is a treaty that the United States is bound by, there should be individualized detention decisions, and the necessity for detention should be justified in those decisions. We've also seen in the most recent concluding observations that detention should be non-punitive in nature. Both the European Court for Human Rights and the European Court for Justice have also rendered their own decisions on immigration detention in the European context, putting very important limits on detention in that continent, of course, in the context of a very serious crisis in migration from the perspective of some European leaders. So it's important to keep that in mind as well. And the Working Group on Arbitrary Detention, which is operating under the Human Rights Council, has stated that a maximum period of detention must be set. So, given all of these provisions, it will come as no surprise to all of you that the U.S. is in violation of most of them. U.S. law mandates detention in many cases for thousands of immigrants. The period of allowable detention is not explicitly set by statute, and additional mandatory detention provisions, many apply, of course, to people with a criminal history. Others, of course, apply to people in the expedited removal context. Detention conditions are often punitive. In sum, the U.S. detention system is hardly a non-punitive system of last resort. So, as we all know, the fact that the U.S. is out of step with international standards has not been sufficient to prompt radical reforms in this country. Nevertheless, I will say, I believe the constant drumbeat of condemnation and pointed questions that have come from treaty bodies over the years have kept the pressure up. The other tool that human rights professionals use, and many colleagues in this room use, and many other colleague organizations, is the tool of investigating and reporting on the operation of these laws in practice. At Human Rights Watch, this means combining two things: lots of FOIA requests for data to show the widespread and systematic impact using the government's own data
as well as first-person, human, real-life stories about how these laws are harming people every day. So what I want to do is give you a sense of some of the places where we're still very worried about these laws, and then, as I said, give you some of the places where we have had some success. But I thought I'd start that part of my presentation by just telling you about someone that we recently interviewed in San Diego. We spoke with a man by the name of Sylvester Owino. Mr. Owino, I want to go back to my, there we go. Mr. Owino is a Kenyan national, and he was detained, he was arrested, he was tortured in Kenya. He also received death threats. He came to the US in 1998 on a student visa. A couple of years after coming here, he developed a drinking problem, began drinking heavily. He was convicted once for driving under the influence in 1998, and in 2003 was convicted of second-degree robbery, for which he spent just over 2 years in prison. ICE took custody of Mr. Owino, and he was held mandatorily. He was shuttled between detention centers in California and Alabama. Subsequently, he was found ineligible for asylum, but he appealed, and he sought protection under the Convention Against Torture. The legal proceedings in Mr. Owino's case plodded along for 9.5 years. He thought about signing his deportation order, but he said that he also felt defiant and he didn't want to give up. He said to us, I had seen what they had done to other detainees, people who did not understand the law, who did not speak English. The more they did bad to other people, the stronger I got. Owino told us about being very concerned about people with cognitive disabilities in detention whom he met, one of whom he said, as a kind of jailhouse lawyer, he helped prove was a US citizen and who was ultimately released. Mr. Owino's case has still not been resolved, but he was released on bond under Rodriguez. The 9.5 years he spent in detention are more than 4 times longer than his criminal sentence. Mr. Owino said, a huge chunk of my life is gone. His mom died while he was in detention. His brother died. He said, I've lost all of them. I've lost friends. I think this case, and there are so many others, as so many of you in the room know, highlights several issues that we at Human Rights Watch and all of you remain concerned about. And his case actually highlights a few that we've made progress on since the '96 laws. So let me start with the problems that remain. And I think what I'll do is try to outline a few of these using some data that we haven't yet released, but will be coming out in a report that really is going to try to just map out the widespread and unnecessary immigration detention that's occurring in this country. As many of you know, when the Obama administration came into power in 2009, it promised to make immigration detention truly civil and more humane. And what this recent data set we've received, which is data from 2011 to 2014, shows, but many others have referenced this, is that our detention system is neither civil nor humane. In fact, the data that we have shows that 1.4 million people were held in and transferred between 697 county jails, private detention facilities, and ICE-run facilities. The system costs $2 billion a year. In 2004, our data shows that this system held 50% more people than it did 10 years earlier. As has been referenced by other speakers, the detention of women and children and asylum seekers in particular has been on the rise. 4 issues that we're concerned about. First, the harms of immigration detention. This has been well documented. Detention is damaging to detainees. A recent analysis that we have done has shown how subpar medical care in immigration detention leads to lasting harm for detainees. In fact, it's led to death. We're also concerned about the fact that detention remains very lengthy. Obviously, Mr. Owino's case illustrates this in a very extreme way. Our data shows that 34,000 people in our data set were held for over 6 months, and an additional 12,000 were held for over a year. A third area that's a serious area of concern from a rights perspective is the fact that detention has a severe impact on people's rights to due process and to access a fair hearing. As everyone knows, there's no public defender system for immigration proceedings. Detention further impedes people's access to lawyers, to evidence, and to prepare for hearings. The new data set that we've obtained that, by the way, I should say, should be, if in fact the government complied with our request, should represent every person held in detention between 2011 and 2014. Our data shows, just using the example of LaSalle Detention Center, which is, as many of you know, is located in Louisiana, about 1,000 people were held in that center each day. We looked at how many AILA lawyers are registered in that region within a 2-hour drive of the detention center. It's 3. Lastly, we've talked about credible fear. We've talked about border enforcement. But I just want to point out how expedited removal has also ramped up the use of mandatory detention. And I think we have to remember that the application of expedited removal is a discretionary decision. We've heard about that. But we now hear from the administration that their hands are tied with regard to detention of people who are in expedited removal. And, you know, let's just remember they're in expedited removal through a discretionary decision. Where have we had some successes? I spoke about how Mr. Owino had been transferred between California immigration detention centers as well as between California and Alabama during his 9 years in detention. This is an issue that we highlighted in 2009 and 2011 with Human Rights Watch reporting. And I think it's fair to say, as a result of our work, ICE has put out what it calls a transfers directive. The new data set that we're still analyzing shows that, in fact, the transfers of detainees between these far-flung detention centers has been reduced in line with that directive. And I think that that is an important achievement. Problems do remain, however, and transfers do continue, and transfers that harm individual detainee rights. Secondly, I think it's fair to say that really terrific litigation that's been going on, but also basic human rights methodology of telling stories has helped to roll back family detention. And that's something that so many people in this room have been crucial in achieving. And I think that is an important achievement. Last, Mr. Owino spoke to us about helping a detainee with cognitive impairments. And this is something that we at Human Rights Watch also engaged jointly with the ACLU in documenting just how difficult it is for detainees with mental health problems or with cognitive impairments to represent themselves in immigration proceedings. This led to litigation by the ACLU and a decision that does appoint counsel for detainees in Arizona, California, and Washington. Let me just end with a few comments on why international law should be applied in the immigration detention context. We've seen, as many of you know, in U.S. Supreme Court decisions that international law has been understood to be relevant to interpreting the Eighth Amendment of the Constitution. I think international standards are helpful in informing both statutory questions and also constitutional ones. International legal limits on detention have often been briefed to the court and have been quiet, offstage cues at times in some of the key rulings. I think cases like Zedvitas or Ma v. Reno, some of you remember, more squarely relied on international standards, and of course some of the Guantanamo rulings do as well. Human rights law involves human beings. It's not about citizen versus non-citizen. That's a key reason to raise it in the immigration context and when we're talking about detention. We've heard so much about the plenary power and about executive power, both of which are rooted in international law. Well, there are checks on those powers that are also rooted in international law that we shouldn't forget. Lastly, I'm very concerned, as I know many of you also are, by the increased move to work extraterritorially in setting immigration policy by this government and many others. Well, extraterritorial action is definitely the domain of international law. So let's apply it to these new policies. So let's keep all of those legal doctrines in mind in our work on immigration and on immigration detention, but let's also think about the very practical ways that the human rights methodologies of reporting on real human stories, using data too, can continue to show and hopefully roll back this very wasteful and harmful immigration detention system we have, partly thanks to the 96 laws. Thank you.
Come on, go ahead.
Okay, great. Hi, everybody. How are you doing? So I guess I would open by saying that, you know, the fight for our communities is the fight for our humanity, and to lift up, to hold our communities and families whole, and to lift up our voices to shape a future that we can create with our own self-determination. And when we face up against the dramatic and staggering inhumanity of the U.S. immigration system, we have to think not only about the laws that shape it, but the communities that are going to organize against it. Because at the end of the day, legal strategies and to address what's happening with our immigration system, no matter how well-intentioned, are ultimately going to falter if they are not matched by mobilizing for justice that has to happen from the community-based level. And in 2006, for example, we had hundreds of thousands of people, immigrants, marching in the streets to talk about immigration reform in this country. And so it's important to remember that mass movements for immigrant justice are real, they're building, and they're very much alive here in Philadelphia today. In fact, a lot of the work that you will hear about a little bit in Philadelphia would not have happened were it not for the organized communities who are coming out for them. The fact that Philadelphia is an established sanctuary city, the fact that our sanctuary city status is among the most progressive in the nation, the fact that we were able to be on the front lines of talking about language access and broadening rights for immigrants, the fact that we're talking about the next stages of what a sanctuary city is going to look like, including things like protecting workers from wage theft and uplifting minimum wage requirements and making sure that labor standards are held up to par. That all of those things rely not so much on just a legal front, but very much on the ability to energize and tap into communities that are increasingly diversifying, that are in need of support and advocacy measures as they are in need of charity and services, and are, fully realized in terms of how they're maturing in Philadelphia. So my name's Helen Gim. I'm a newly elected city councilwoman here in Philadelphia, and 20 years of my life have been spent working within Philadelphia's immigrant communities, doing organizing, and talking about what it means to really have a voice in a political process. Not so much in a political process as just defined by electoral politics and a bunch of titles and voting, but a political process that's defined as much about the ability to shape ideas, to move them, and to get a large mass number of people behind you to talk about it, or to work for solutions on it. Our immigrant organizing groups here in Philadelphia are inspiring. We've worked on pushing back around welfare reform. We've talked about affordable housing and police accountability. We've addressed anti-Asian violence and Islamophobia. We're talking about a community that is maturing and growing and developing. We're heavily invested in our public school systems and in mass transit because that's how we get around. In 2008, 2009, when there was racial violence at a high school here in Philadelphia, it was immigrant youth, some of whom had only arrived in this country 6 weeks before, who really led the struggle to hold a school system and a city accountable for violence in our schools, and to begin to shape a racial justice movement that really tackled ending kind of the school to prison and quick to suspend, zero tolerance mentality that was governing a lot of our public schools, especially those in cities that are serving large numbers of students of color, and instead pushed the school system towards restorative justice practices, engagement of youth, and a stable and well-supported school system. And those are just some of the examples of how immigrant communities are maturing here in Philadelphia, how they are growing, how they are operating and thinking, and how ultimately then they are able to engage around this issue of immigration. This past year, in partnership with One Love Movement and a number of incredible allies all across the city, and indeed a number from New York and DC and other places, we hosted a historic council hearing in which we took testimony over Skype, for example, from Philadelphians who have been deported to Cambodia due to the '96 laws. We also hosted a family of young men who have been deported around these laws, who spoke movingly about the pain and suffering caused by the forced removal of their sons, partners, and fathers. When we tell these stories, these statistics and the laws and whatever bizarre rhetoric and hate that's moving around begins to come up against the realities of the families who are facing them. And we moved from those hearings to passing a resolution yesterday in City Council where we joined a whole host of cities across the country calling upon Congress to rectify the injustices wrought by the 1996 immigration laws. And what's important to recognize is that none of these things that move politically ever happen on their own. They really, you know, as much as I'd love to talk about myself or even my other colleagues, like, they're not going to come out of the goodness of our hearts. They're going to come out because people demand change. They're going to demand it, and they're going to move it. And then when people are at the forefront of addressing and organizing it, then they will shape the message that has to be delivered at the political level. And you know, it's one of those issues where it's so important to understand that organizing within communities has to be so deeply valued. City Council here in Philadelphia was not alone in joining the call for the revising of the 96 laws. I'm part of a national group called Local Progress, which is a hosting of municipal officials all across the country who are heavily invested in progressive politics, among those being the fact that we do have a responsibility and duty and sometimes an opportunity to take on immigration laws that are so often seen within the federal, international context, or which are seen beyond the power of municipal officials and at the same time often beyond the power of local communities to truly engage in. There's no question that sometimes when we hear about immigration and the kind of level of inhumanity that so many of our communities are subjected to, it's hard not to feel overwhelmed, to kind of feel defeated by the vastness of it all, the kind of the distance between what it takes to deal with what's happening on the ground to how policies actually need to change in Congress, a Congress that many people don't feel connected to and is frequently in gridlock. But at Local Progress, we believe that at the municipal level, we have an opportunity to really advance some progressive policies at the local level. We can exercise our rights to hearings and resolutions. We can raise up our voices. We can hold press conferences. We can do studies, and we can sell a story and tell a story that so often is not told at the national level. In Philadelphia specifically, we have a responsibility to really do a lot to make sure that our communities are even more engaged. And this marriage between the grassroots community organizing and the kind of policy levels that make people feel that change is not only necessary but possible is the nexus of what we're trying to do in local government. And among those things, we're talking about how to make the city services easier to access for all people who live here, including and especially including immigrants. Philadelphia voters approved a charter change requiring full language access for all city services at the voting booth, in our courts, when you go to the Register of Wills and file a deed. And now we have to work extra hard to make sure that that change is implemented at all points of interface when Philadelphians meet up with their city officials. There are executive orders ensuring that immigrants cannot be asked about their immigration status when receiving city services. And we're moving towards more aggressive policies protecting workers from wage theft and unfair scheduling practices. We're also heavily invested in our public school systems, where most of our immigrant communities land. We have to make sure that our programs for young people who seek language services are fully realized. We're talking about the need for diversifying bilingual program in the school district of Philadelphia. We have to have bilingual personnel who are meeting and greeting with parents. And then we have to constantly assess our climate and culture. If we think that there is bullying and harassment at the national level around the rhetoric that's going on currently, you can't imagine how that seeps down at the local level, on the schoolyard, in a classroom, between teachers and families who don't speak English. And we have to constantly engage at that level to ensure that when we tackle the big stuff, we're showing that we can also handle the day-to-day life that makes walking through this city feel possible for so many immigrant communities. I also want to briefly comment on a couple of other deeply important topics that are relevant to those of you, especially here at Drexel, to think about being in Philadelphia and being in Pennsylvania. And I know Professor Berry will also talk a little bit more about this, but an hour's drive from here is the county of Berks, and in there is a prison in which women and children are being held currently indefinitely. They've been held, we've been told that people are not held in detention for longer than 20 days, and many of these families have been held for over a year or longer. Many of them are in unbearable conditions, including insufficient medical care, abusive conditions, separation from their parents, reports of sick children failing to receive adequate medicine, sexual assault perpetrated by an employee have broken into our mainstream media and have shocked the senses about what is actually happening here, not far away, not in DC, but here in our own state. And we have to continue to stress that the existence of any such facility which criminalizes people who are fleeing war and conflict has to be shut down, and that those individuals, those women and children, must be released. And that has to be something that isn't going to happen right now through our legal measures. We're not going to do that quickly enough legally. But it can happen through political pressure, through voicing out, talking to our state senators. It's a power within our governor to be able to handle, and it's got to be something that we as a city, as our mayor and city councilor, need to be able to speak out about. And while the facility in question lies just outside of our borders, it's crucial to understand that many of our own residents may go there, that we weigh in, that we support this push, led by mothers who are being detained in that facility to end inhumane sentences that aren't even sentences because there hasn't been any kind of a trial or anything. And that's why I requested a visit to this facility that our local council members are hoping to visit, and intend to continue to use my position on city council to push forward, to challenge the Berks County commissioners, for example, for why they're holding open that facility. And we have to keep this crisis of a prison of children and mothers who are detained there in public view and under public scrutiny until we win. You know, at a time more than ever when we see the situations about communities who are facing off against such massive levels of disregard. I mean, I sat down with Jay Johnson, the Director of Homeland Security, last spring, and he was pretty unforgiving. You know, he pretty much talked about a system in which he would like to characterize as the worst of the worst people. And, you know, I challenged him by saying the Obama administration has embraced this idea of, you know, understanding that things that have shaped the 96 laws, including like especially the retroactivity, but the fact that there's mandatory sentencing. There was horrible juvenile justice laws. We rolled back welfare laws. We created the school to prison pipeline and a mythological war on drugs that really shaped the backbone of what Michelle Alexander calls, the new Jim Crow, that is the defining understanding of what American racism looks like in 2016. And that, that these kinds of situations, that understanding that, when he says that these are the worst of the worst, I'm not thinking about the people who are caught up in the system. I'm thinking about the lawmakers who perpetuated this on communities for the last 20 years without regard to consequence or to discerning certain circumstances or the impact on our youth and on our families for ages to come. And when we meet up against something like that, the solution, I could kind of go at him with like laws and whatever, but that's not really what's going to ultimately win. I think it's really going to be the fact that we're pushing back as a community, that when we stood and talked to Jay Johnson, that we're organized, and that we, in fact, if we have no other choice, will simply be defiant of the United States laws, because it is actually our right, and perhaps it is also our duty, to stand up and say that we are in defiance of what the U.S. is perpetrating right now, that the laws that are in existence are backwards and regressive, that we're in 2016 and we have an opportunity and a need and a responsibility to address these from a deeply different perspective. And so, I hope that as we continue talking about this, that this isn't a solution that just has to be solved by lawyers and bureaucrats and politicians, that this is a role that each and every one of us has a role to play in, has a voice in, and ultimately will shape for a future. Thanks.
Thank you, Helen, for saying everything I could ever want to say, so I think we can just end today. I apologize for the letdown that this will probably be after that incredible talk. That was really, really wonderful. And a lot of what I'm going to do is actually just going to be to give some context to some of the things that Helen talked about in terms of what has been happening in local organizing. And so here we just have a few visuals to keep us all awake this afternoon. So as everyone has been saying, and I apologize I wasn't able to be here this morning, I hope that this is not too duplicative. But one of the things I appreciated about the framing of this fantastic symposium today was that it wasn't just about the 96 laws, right? It was also about the gutting of the welfare system and the expansion of mass incarceration. Because anytime we're talking about the 96 immigration laws, we're not just talking about IRA, right? We're talking about an era that was focused on punishment and revenge through legislation. So we're talking about the gutting of welfare. We're talking about the criminal laws like 3 strikes, like mandatory sentencing, like truth in sentencing that force people to serve these increasingly draconian periods of time in prison. And 96 was, of course, also the year that Clinton signed DOMA, which perpetuated the U.S. policy of preventing queer immigrants from the right to obtain legal status through kinship, along with the HIV ban, which had been enacted in 1993, right, which disproportionately impacted queer and trans immigrants. So the culmination of all of these laws was to create and to reinforce hierarchies, right? Who deserves, over here. Who deserves our generosity? Who deserves the right to remain in their community? Who deserves really to survive? Who deserves to have the means to survival? And at the bottom of the hierarchy, who is disposable, right? As Helen was saying, who's being framed as the worst of the worst and beyond redemption. So it's crucial for us to remember that when we're talking about the consequences of the 96 laws, the Obama administration never would have been able to deport 2.5 million people without the school to prison pipeline, without mass incarceration, without a police force that's been encouraged to target and destabilize poor communities of color, right? That never would have been possible if those systems were not working hand in hand. And so when we're thinking about how communities started to organize to resist, for all of the reasons that Allison and Helen just highlighted, it was an incredibly difficult road to start walking, right? If you're facing mandatory detention and mandatory exile from your family and your community, that is a huge obstacle to be able to get up and fight back against. as the enforcement of the laws started to evolve to increasingly brutal methods of home raids, of apprehending people on the street and taking them directly to detention, of forced deportation to countries where some people had fled war and genocide as refugees, the Department of Homeland Security has become an agent of terror in our communities, right? And so organizing against an agent of terror is incredibly overwhelming. And the initial response in terms of the organizing that we saw was to find ways to fit within that hierarchy, right, which was very understandable. So we saw a lot of organizing campaigns saying, we're not criminals, we are not the worst of the worst, we're not the folks at the bottom of that hierarchy, to distance themselves from communities that they saw as bad, right? And again, it's understandable. Even just yesterday, I saw Martina White, who's running for the State House of Representatives on a very anti-immigrant campaign, sent out a mailer, and on one side of it, it said like murder, robbery, rape, all committed by undocumented immigrants, except she didn't say undocumented. And on the other side was a picture of all white adults and children, where she was saying, I'm not with those people, this is my community here, right? So it's understandable when you're facing that kind of rhetoric to want to find a safe place for yourself, and I'm not judging the folks who made those decisions. But over time, some organizing campaigns have instead said, you know what, it's our freedom and our survival is actually wrapped up with the folks who are resisting these systems of mass incarceration and deportation and who are resisting these hierarchies. And have found power in building solidarity around the experiences of the folks who are at the bottom of that hierarchy, who are being impacted by the harshest consequences of these laws. And I think there have been some really incredible examples of that in local organizing, a lot of which Helen just introduced. Because due to the reliance of the deportation machine on local law enforcement to arrest and imprison immigrants who would then be subjected to these harsh consequences, organizers have been able to find some local targets that could stem some of those consequences, right? So I'm just going to talk about two specific examples of local organizing that has tried to break down some of these divisions and shift the focus away from this criminal alien narrative towards a conversation about institutional violence, right? And addressing that violence locally. So the first example, which Helen mentioned, is Philadelphia's ICE Hold campaign up until its recent involvement with the Priority Enforcement Program and Jay Johnson's visit to Philadelphia. So ICE Holds, of course, were one of the key mechanisms in the deportation machine, allowing Homeland Security to use local law enforcement to apprehend people who would be subjected to, in many cases, mandatory detention and deportation. And when the former mayor of Philadelphia was initially considering creating an ICE Hold policy, his administration proposed a policy that would limit the use of ICE holds to folks who had been convicted of what they deemed to be serious crimes. And a number of local organizations, so including some of the ones that Helen mentioned, One Love Movement, Juntos, the New Sanctuary Movement, the Pennsylvania Immigrant Citizenship Coalition, and actually a victim services agency, Victim Witness Services of South Philadelphia, came together and said, why are we arguing over where to draw the line? Why don't we just not have a line? Why are we using convictions that occurred in a criminal system designed to destabilize black and brown communities as a dividing line between who deserves to remain in their community and who does not? And so they challenged the entire idea of that there have to be any of these divisions. And so I'm just going to put up on the screen here. I know it's a lot of text, but every word felt so important, which is one of the core principles of the Philadelphia Family Unity Network and how they went about addressing ICE holds in Philadelphia. And so it's talking about self-determination. It's talking about that people have a right to make a mistake and start over, and that people have a right to be their own best advocates. And not stigmatizing or shaming people who are not deemed to be deserving of justice and redemption. So part of the campaign involved holding a public hearing, which was prior to Helen getting onto city council, but we would have loved to have had her involvement. We had a lot of really great support from Philadelphia City Council, and the city council hearing magically occurred about a week after the Third Circuit issued its decision on ICE detainers in the Galarza case, finding that because detainers were not based on a judicial determination that probable cause exists to detain the person, local law enforcement may be held liable, so they went for their pockets for enforcing an ICE hold if it's discovered that it was based on bad information, i.e. racial profiling. So after the hearing, the mayor did sign a policy which requires a judicial warrant to be issued before any ICE hold may be enforced, which effectively ended the use of ICE holds in Philadelphia. So I'd like to show just a very short 2-minute video, which is bring some of the voices of the organizers behind the campaign into the room with us here. Let's see if this works.
Every Philadelphian, or a person in Philadelphia, has the right to feel safe, secure, and protected. And I believe that our new policy established by the executive order I'll sign shortly will promote safety because residents and others who are here will not need to fear that interacting with their government will result in a detention for themselves or their loved ones.
It was a joint effort, and while the community support, while our community partner, that wasn't happening long, but it was a movement led by the people for the people.
Para mí es ridículo que se tenga que castigar a 2 veces a un ser humano. Primero del sistema legal y luego la cual cosa es que no solamente están castigando a las personas culpables, sino que cometer un error. En mi caso, me castigaron también a mí, a mis hijos y a toda mi familia.
Immigration is a human right, and as such should be dealt with more humanely. And we ask the City of Philadelphia through its council to end the existing collaboration between its police department and the Immigration and Customs Enforcement.
We ask that our city's deeply rooted values of redemption, rehabilitation, second chances, and reintegration be applied and fought for all residents of Philadelphia, instead of allowing a mandatory indiscriminate federal deportation system to apply double punishment that directly disintegrates certain populations in our city.
Porque existe una historia de desconfianza en las comunidades inmigrantes, necesitamos un mandato claro que separe la policía local de las autoridades de deportación.
What is new about the campaign this time is that diverse community groups, service providers, and advocacy organizations came together and decided to reject the framework imposed upon us by federal immigration system of the good immigrant versus the bad immigrant.
Ninguna persona merece ser deportada sin importar su estatus migratorio ni récord criminal. Y no podemos definir a las personas si la persona es criminal o no es criminal.
When strangers sojourn with you in your land, you shall do them no wrong. The strangers who sojourn with you shall be as natives among you. You should love them as yourselves because you too are strangers in Egypt.
We need to stop attacking our community, our kids, our school, our people, our future. They are our future. Because when our communities are under attack, what do? We stand up and fight back. We stand up and fight back against any ICE on the city of Philadelphia.
We're the next best city and progressive movement here. But again, it's a starting point, not an ending point.
All right, so just getting to hear some of the actual words and some of the messaging that the organizers brought to that campaign. As Helen said, the follow-up to the ICE holds policy, which has been ongoing in Philadelphia, when Homeland Security rolled out the priority enforcement program and Jay Johnson was going around the country pressuring local municipalities to agree to these policies where they would be notifying police when people were being released. Our current mayor took the position that Jay Johnson needed to convince immigrant advocates and stakeholders to agree to that policy, and that if he did so, he would be happy to sign it. And Helen just explained how that meeting went. So far have not been convinced. And so the second example, and I'm just going to keep going here, of local organizing I want to highlight is the campaign to close the Berks Family Detention Center that Helen introduced. As Helen was saying, families incarcerated in that facility are subject to the expedited removal and mandatory detention provisions of the 1996 laws. It is a county facility owned and operated by Berks County, which was originally licensed by the state of Pennsylvania as a child residential facility, similar to a juvenile detention center. Because it's a county facility with a state license, advocates identified an opening for advocacy. And local attorneys who had stepped up to represent the families who were detained at the Berks facility started pushing the state to reconsider its participation in incarcerating families in Berks County. And when community organizers joined the campaign, from the beginning, they created messaging that built across these divisions created by these hierarchies in the law. So the facility in Berks at one point was being used by Homeland Security as a model facility for how to incarcerate vulnerable populations. They actually organized a tour for DHS staff who would be involved in planning a detention facility for transgender immigrants, which I'm assuming is a facility that is now opening in Texas that has a special wing just to house trans women. And so Juntos and the Pennsylvania Immigrant Citizenship Coalition partnered with GALE, which is a queer Latino social justice organization, to organize rallies and press events with a message that detention is not safe for anyone. Prisons are inherently violent institutions that facilitate the abusive practices that Helen described. And so during the Democratic National Convention in Philadelphia, there was a really incredible, joyful, powerful march in Philadelphia, drawing attention to the detention of families in Berks. And this is just some of the messaging from the march that I thought was so powerful, which really is trying to bridge some of these divisions. This is a video of the Philadelphia Student Union, which is a local organization that takes leadership from Black and brown students in Philadelphia public schools, marching with a banner that says "End deportation now" and chanting "out of the closets into the streets," which I feel like just makes me cry every time I look at it. I just find it so inspiring. So just as an update on the campaign to close the Berks facility, advocates and organizers have been successful in convincing the state to revoke its license. The county appealed, and it's still pending. They're scheduled for a hearing in November. But as Helen was saying, that campaign is ongoing and would absolutely love the support of the people in this room. So I'm just going to close by saying we are in an incredible moment in social movement history. There are vibrant, creative social movements addressing structural oppression, raising awareness about these issues across the country. The Black Lives Matter movement, the Not One More movement, all have chapters in Philadelphia, are all part of this incredible cross-community solidarity that we're seeing. And we're really starting to see a questioning of, is this sort of system that is geared towards punishment and revenge working? Is it actually making us safer? I saw last week the Washington Post printed an opinion piece calling for an end to the current institution of policing. We're seeing a questioning of these institutions even in mainstream conversations. And so for our advocacy moving forward in the immigrant justice movement, I think we should be asking ourselves, how are we supporting efforts to build beyond these narratives of innocence and criminality in our work and move those who have been most marginalized by these hierarchies and these systems towards the center of our advocacy? And I appreciated so much when Frank was saying what a movement moment that we're in, where undocumented folks are actually being invited into these conversations about policy and how to move forward. And so I think I'm also looking around and asking, where are the formerly incarcerated folks? Where are the trans women of color? Where are the former gang members? And I think Allison and Helen, I appreciate so much that you centered those folks in your talk. You know, when you're talking about who it is that we're choosing to listen to, it's folks who have experienced the realities of these laws. And so I just wanted to end with this excerpt from the Vision for Black Lives that was released last summer, which encompasses a call to end, to overturn the 1996 laws in their vision of what Black power and freedom would look like in the future. And I think it's just such a fabulous example of this kind of cross-community solidarity and resistance. So the question I'm thinking about as an advocate moving forward is, how is my work supporting making this demand a reality? Thank you.
Okay, so I guess I'm batting last. I don't think I'm going to have the ferocity of Councilmember Gim, and I definitely don't have the video and the voices, unfortunately, but here we are. I actually want to start where each of you guys left off in a way, which is, I think the challenge to lawyers and law students and advocates is to match the creativity and the boldness and the courage and the risk-taking of the people we just heard from. It's hard sometimes when you put on the suit and you're sitting in the rooms of power, you know, or what feel like the rooms of power, to continue to insist on first principles and not to start to compromise and be seduced. And I do think that is the challenge to us as lawyers and advocates, is to take some of the risks that our clients and our communities take every day. So somewhat in that spirit, they're not claiming that this is a kind of risk like I just described. This is the panel that is pivoting from looking backwards at 96 and what happened and the history since then towards the present moment, and I think the next panel will start to look forward. And I'm going to do a little bit of those two things. I think that the greatest sin of the 96 law, among very many sins, was something that we haven't talked as much about, which is the absence of a pathway towards legal status, what Frank called legalizing mechanisms. But unlike in 1986, where we had, in my mind, horrible new enforcement, but also legalization provisions, there was none of that in 96. And instead, there was, of course, severe restrictions on pathways that had existed, both for people who are in removal proceedings, so the elimination of suspension, of deportation, of 212C relief, and so forth, and also for people who are not in immigration court, who are not in deportation proceedings, the elimination of 245I, and the one-year bar in asylum, and other things we've talked about. So I'll also disclose that much of my professional energy over the last 20 years has not been devoted towards opening pathways to status. Rather, it's been resisting removal, resisting enforcement, resisting detention, trying to throw sand in the gears of the deportation machine as sort of the best you could do to try to slow things down, make them more difficult. But that was all arguably, I think, subject to the criticism of playing defense, because those were not strategies to find a path to status for those who lacked status. Now, I've also spent a lot of energy on the kinds of state and local measures that we've just heard about and that Frank talked about. Frank kept talking about how California was so great, and I was starting to get my dander up. So Connecticut, undocumented driver's licenses regardless of immigration status, Trust Act before California's Trust Act, in-state tuition, municipal IDs, first city in the nation, lots of cities now. Our current push involves pardons for immigrants, and in fact, and I would love to talk to you about this later, Councilmember again. So this spring, the state legislature, wanting to hear testimony from deported Connecticut residents, was unwilling to settle for Skype, and so issued legislative subpoenas to command the in-person attendance at a legislative hearing of deported Connecticut residents. And calling home their residents who had been deported based on state convictions, because our state legislators wanted to better understand how state laws were leading to deportations, and they also wanted to consider private bills to pardon those individuals so as to open up pathways to return home. So the legislature issued subpoenas to call home deported residents, and when ICE was unwilling to comply, you can imagine the conflicts that were generated, and we're in court, students are in court in 2 weeks on that, and we'll see what happens. But so I have spent tons of my own time, and students and allies and colleagues at work have done that work, and yet the piece that we haven't squared up to, and this is the big wind-up, is not just ameliorating the harsh conditions of life under the 96 laws at the state and local level, and not just sand in the gears, but actually how might one imagine pathways to status. Okay, so I'm going to take as premises, I think, somewhat where Frank was. I'm going to assume that Hillary Clinton wins the election. And I'm going to assume that the Republicans control at least one chamber of Congress, hopefully no more than one, but at least one chamber. And in that universe, thinking not so long term, but sort of medium term, what is possible in terms of securing status for those who lack it? So I'm delighted to hear that there will be a new push. I hope that that is in fact honored. I hope that something good comes of that, and I know people are working very hard at that. But I want to assume that for the next year or two, actually, we don't get sweeping new legislation through Congress. That's always the safe bet, right? If you're betting on anything, bet that Congress won't act, and that's the Vegas line, right? So that's the world I want to think about. So in that world, what, if anything, could be done in the next few years to actually secure status for people who lack status? So here's my thought, and I'm going to suggest a few ways that this is not total law professor speculation. Some forms of state-by-state programs coming either through the courts or the executive branch, because the legislative branch, Congress, is dead. So first I want to observe that there's been a lot of work over the last period of time challenging punitive state and local measures, like in Arizona, anti-lie and others, as preempted and violating equal protection and so forth, while also defending all the progressive local measures, like municipal IDs and institution and so forth, against litigation. So there's been a lot of talk about the role of states and localities in immigration reform. But I don't want to talk about that. I want to talk about federal action. If the federal executive branch or the federal courts were to act, could we have a world in which you had different immigration status programs in different states? Seems odd to legal scholars used to uniform national rules in immigration. But we know that ICE experiments with local programs. They have enforcement programs that they run as pilot projects and so forth that vary in different places on the enforcement side. We know that the immigration courts, EOIR, also run different pilot programs in different courthouses. So I want to ask whether USCIS, which could give out benefits or deferred action and work authorization, could also run pilot programs the way ICE and EOIR do as an exercise of federal power, so it's not going to run into any of the federalism concerns and preemption concerns and so forth. So is that possible? Well, here's 3 ways that I think is not wholly infeasible in the next couple of years in a world where we don't have congressional reform. So first would be simple state-by-state implementation of what the executive branch says it already wants to do, DAPA and expanded DACA, as Frank talked about. So the Obama administration says we want to have these programs. Candidate Clinton has said she wants to go farther than those programs, and the court in Texas has enjoined the implementation of those programs nationwide. But as some of you know, a couple of weeks ago, a month ago, we filed suit in New York in federal court asking a federal judge to say that order in Texas doesn't apply to residents of New York. And I have to tell you, having kind of worked up the legal theories and having spent about a year being told by many people that there were obstacles, and there were doctrinal difficulties, and there were nuances and subtleties that were challenging, we filed the case. Because our client, Martin Batalla-Vidal, was courageous and stepped forward by himself alone and said, I will do this. And lo and behold, we had our first conference in court a couple of weeks ago. And nothing has been decided, no rulings have been issued. But the judge said to my students, so, what are you doing in my court? There's an injunction down in Texas, and the student gave an answer. And then the judge turned to the government lawyer and said, well, what do you think? And he explained why this injunction in Texas meant nothing could go forward in New York. And then the judge said, I'm a judge in Brooklyn. We're sitting in Brooklyn. We're not in Brownsville, Texas. I'm not quoting any longer. But I am quoting when I say that Judge Gariff has said, I will not be hamstrung. That was his word, hamstrung, by the order in Texas. And then he said, I don't really know what's going on in Texas, but I know I am not marching in that parade. He then said, we had proposed an accelerated briefing schedule. He said, I don't like this schedule. This is too slow. And he accelerated our accelerated briefing schedule and set it for a hearing on cross motions in January, a few days after inauguration. So I don't think it's impossible. Who knows? He's decided nothing. I don't think it's impossible that in February there will be a ruling in a federal court in New York saying the injunction against DAPA and DACA expanded does not apply in New York. Could there be a world in which DAPA and expanded DACA go forward in New York under federal court order? I don't think it's impossible. I'm not assuming it. We have a lot of briefing and argument to get through, but it's possible. And as you saw a few days ago, a second lawsuit was filed by another courageous young man, Jose Diaz, in Chicago. If you put the complaints next to each other, there's a certain similarity. And we'll see what the judge in Chicago thinks about a judge in Texas telling him how to run his courtroom in Chicago. And maybe we'll see litigation in California or or Pennsylvania, other states with large immigrant populations who are not plaintiffs in the Texas litigation. Okay, so scenario number one is that there's a logjam in Congress, perhaps despite best efforts by new President Clinton, and there start to be federal court orders, at least in some states, saying DAPA can go forward, and DAPA can go forward in these states. Not impossible to imagine. Second scenario. So let me tell you a story about PEP. You heard about the PEP program, the successor to Secure Communities, right? The kindler, gentler version of Secure Communities. You heard about some of the resistance to PEP. So apparently, when DHS was rolling out PEP, they reached out to jurisdictions like California and Connecticut that had adopted trust acts already against secure communities and detainers and ICE holds, hoping to work something out whereby those jurisdictions might participate in some way in PEP. So DHS reached out apparently to the state of Connecticut and said, you know, we'd like to engage with you and see if you would participate in PEP. And a variation of it sounds like what happened in Philadelphia, though in my view a much worse scenario. The state of Connecticut said, well, you know, there's been class action litigation brought against us. We have laws here. We're not comfortable going forward until you talk to Wishney, me. We had brought class action litigation. There were consent decrees about detainers and so forth. I don't represent the state of Connecticut. I don't represent any government agency. And the government officials who apparently made the suggestion didn't tell me they'd made that suggestion. So not too long after that, I got a call from DHS. They were a little sheepish, I have to say. And they said, so we're the people trying to roll out PEP, and we reached out to Connecticut, and Connecticut says if Connecticut's going to play ball, I'm paraphrasing, we have to talk to you. I don't get those calls a lot in my life, right? We have been pretty adverse to DHS in many, many, many matters. So I said, you know, okay. I took the call. It happened that I was in DC for meetings with some of the advocacy community that Frank talked about soon after that, and had the opportunity to explore a little bit with some DHS officials. And what I realized, and other advocates realized, was that for all the pressure that the federal efforts to co-opt state and local police into immigration enforcement has meant, all the coercion and pressure, it also means the feds want something out of the locals, which means the local authorities, state, county, municipal, have the option to bargain. So I said to DHS, speaking for nobody, just spitballing, what if the governor does a press conference about PEP? Well, I mean, we have law already. We're not enforcing detainers in Connecticut. We're not communicating at the municipal level. We have all the confidentiality and stuff like that. So we're not changing our laws. But what if the governor does a press conference and says, consistent with our laws and our limitations, I'll enforce PEP. How about you start handing out deferred action with work authorization? I'm not talking DAPA or DACA program, but you have your Connecticut people start doing deferred action the way all those generations of prosecutorial discretion memos authored by Alex Lanikoff and Doris Meissner and everyone who's been in those positions has said, the little kind of paper airplanes from headquarters out to the field saying, please exercise prosecutorial discretion that tend to be ignored at the field level. What if you actually implemented those? And out of those conversations came a further wrinkle. What if the state and local folks certified, kind of like a U visa certification, the facts of an application? So-and-so coaches soccer, so-and-so does have a family, so-and-so does work in the community. What if there was some state or local certification of the facts of someone's life that gave a little bit of a local imprimatur to the application, still reserving to USCIS the decision whether to grant or deny deferred action and work authorization? What if in exchange for some limited participation in PEP, there was actually a robust program of deferred action with some local certification process? I will just say that there was openness to that kind of negotiation at DHS. So then I came back to the community groups in Connecticut that my students and I represent, and I said, so I've had these weird conversations where ICE called me because they were trying to dial Connecticut, and then does this seem like anything of interest to the grassroots organizations and unions and church groups in Connecticut? And there was a process, a kind of a conversation, and the decision last summer, that's 2 summers ago, was no, actually, we are resisting PEP. We are not going to in any way embrace PEP. So we are not going to endorse the governor doing a press conference in exchange for deferred action and employment authorization, because we're sort of in the not one more, PEP resistance. That was the end of it. That was our judgment in Connecticut. So I said to everybody, I'm done. So nothing further happened in Connecticut. But it suggests to me that even in a world in the next couple of years without legislative reform, and even if the courts don't untangle the Texas injunction, I don't know what prevents local jurisdictions from negotiating, from bargaining with Homeland Security. You want something from us? Well, we want something from you. We want deferred action and work authorization on serious terms, seriously given to large numbers of people, including perhaps a local certification of some kind of some of the basic facts of the application. I think that local governments and state governments have the ability to negotiate. And it may be that, as in Connecticut, the ultimate decision is that's not a path we want to go down, because we don't want to embrace anything about PEP or enforcement. And I would certainly find that a reasonable judgment elsewhere. But I've mentioned this story to say that I could imagine bargaining for some kind of state or local version of temporary relief without need for legislation or even getting free and clear of the injunction, which runs only to something called DAPA and expanded DACA. And finally, because I know my time is up, a third version would be actually to do this under the statute that already provides for cooperative agreements between ICE and local authorities, which we call 287G, which is phrased in terms of delegating some authority to locals to do enforcement. But if you read the statute, it says that the feds may delegate the function of an immigration officer, quote, in relation to the investigation, apprehension, or detention of aliens. Well, part of investigating those you actually target is taking out of the haystack all the hay you're not targeting. And so, in a way, the flip side of this is to remove from that basket people who you actually want to give deferred action and work authorization to. So I actually think that there could be, I don't think you have to go this route, but one could exercise statutory authority and enter into a 287G agreement providing for state or local authorities to do some sort of certification process, still reserving to CIS ultimate decision over an individual application that would actually bring it even closer to what Congress imagined in this kind of local bargaining. I'll stop with that. Thank you. What I'm trying to do, as I said, was to think, if we're in this world where we don't have comprehensive reform, do we just throw up our hands and hope for the courts, or hope for Mitch McConnell to confirm a ninth justice, or, or is there something that communities can do that they still have power that they can exercise and deploy?
Well, let's open things up for questions, and I'll start to see if anyone on the panel has questions for anyone else on the panel. If not, we'll go to the audience. And just a reminder, feel free to identify and introduce yourself when you ask the questions, and please, because there's no mic in the audience, please try to project as loudly as you can. Okay, go ahead.
Good afternoon, everyone. My name is Brittany Stepp. I'm a second-year student here at Drexel Law. And my question is, as a Berks County resident, where my home is, I have never even heard of this detention facility. It is mind-blowing to me that I live and have lived in this county my whole life. My question is, where is this detention facility?
I think it's technically in Leesport Township. It's right on the same road where they have the Reading County Fair.
Wow.
Next to the golf course.
Right down Berks County Prison.
Right across from the Berks County Prison, right there. And there was a big, it used to be the facility itself used to be a nursing home many years ago. But yeah, I remember going to the county fair years ago and realizing as I was driving in, I was like, oh my God, this is right next to the family detention centers.
I'm sure there are many others in Berks County who have no idea.
Did you want to?
I've found your ideas of different alternatives to organizing and getting things through, but I also think that the sense I have is that there's this dichotomy between comprehensive immigration reform over here and some other kind of actions that Professor Wishney, you were describing. I'm wondering, and I've thought about this for quite some time, is there some way, rather than going for the whole big pot, is it advisable to carve out certain areas that are perhaps important? And I remember when I was in practice, one of the things that I really hoped would come back was 245I, for instance, and to focus energies on getting 245I, and there might be a trade involved. But in other words, focus some ideas on focus energies on particular statutory improvements, since we can't get, since it's unlikely we're going to get a whole broad sweeping immigration package. A, is that a good idea from a strategic point of view? And B, those of you who think it is a good idea, give me your top 3 statutory changes.
Just to repeat the question for the social media audience, it was whether it's a good idea to target particular statutory reforms as opposed to going for comprehensive reforms, and what would be the top 3 choices of what you think.
I'm tempted to just pass it back to Frank. As someone who doesn't work in D.C., and I have ideas about it, and there may be others on the panel, but I also thought we should invite Frank in as well, a little bit of a voice from that world. But Councilmember Gill.
Yeah, I think that especially, I'm going to speak from way outside of DC, but I think 2006 and 1996 were, well, especially 2006 was a really big wake-up call about the failure to enact comprehensive immigration reform and the reasons why it fell apart. I mean, honestly, like, if comprehensive immigration reform is a mishmash of, like, the absolute worst ideas of the far right wing mixed in with, like, a temporary path that was going to expire for most people in the country within, like, a limited status. Like, a lot of communities didn't want a part of that. I mean, I think that the 2006 negotiations broke down because, well, there was a lot of problems with it in general, but a lot of us at the grassroots level were wholly disgusted with what was being purported to be a measure of reform, that it was in fact just going to be another pathway where we're going to end up in 10 years with the same level of problems, and we had already accepted probably some of the most regressive ideas and validated them for right-wingers. So there has been a lot of discussion. I mean, obviously, DACA didn't, quite make it all the way through. I mean, that's a big kind of, cold water in the face about that. But I do think that the belief is that if at this point comprehensive immigration reform requires us to settle for the worst of the worst in exchange for something temporary, then most communities are more willing to go in on those specific measures that you are talking about. I think, like family, making sure that family connections are at the forefront of immigration reform, rather than like subjecting us to Braceros programs or worker visas or these kind of regressive things. And ending this mass detention, indefinite mass detention, I think has to be at the top of the table, and as well as automatic deportation. So I think that those are some of the things that people are moving towards, and then seeing these opening up to pathways that are really centralizing families.
Yeah, I think I've had the same question recently, thinking about judicial recommendations against deportation, and is there any way to be able to bring that back without having to? Right. Yes. This is all. I'm going back to 1990. Yes. Yeah. But I'm so far out of DC, I would have no understanding of whether or not that was in any way realistic.
Jill Family from Widener Law Commonwealth in Harrisburg. So I used to practice immigration law in Philadelphia, and I moved to Harrisburg to teach. And one thing that's really bothered me ever since I moved is sort of a lack of leadership at the state level in terms of immigration issues. And I don't mean community groups, I mean like within state government. It's really hard for me to think of anyone within state government whose sort of sole mission is thinking about immigration in Pennsylvania. And I'm just wondering if, Caitlin or Helen, if you have any thoughts. Am I wrong? Have there ever been efforts? Are there efforts underway to maybe push Governor Wolf to, incorporate somebody like that in his office?
The question was whether there's any strong state leadership on immigration reform.
What happens in the Pennsylvania legislature is an eternally defeating question. I think, I was reading an interview recently about some of the anti-sanctuary bills that have been introduced, and one of the organizers' response was like, well, no one can get anything passed in Pennsylvania, so I'm not that concerned about these anymore than I am about these other efforts. I think it has been a real challenge. I think the Pennsylvania legislature has been dominated by a lot of anti-immigrant rhetoric, so I don't know, I feel your pain. There are some candidates running in this election for the state legislature that are coming out with some creative immigrant justice messages, so I think researching who's up for election this round could help push us in that direction.
I don't know that I have that much to add. I mean, I think, we've got lesser evils than what has gone before, but, I think that Governor Wolf would generally be in the vein of not wanting to see these things happen, but, this issue isn't of like what your intent is or where your heart really truly is, but the ability to think creatively when we have a federal structure that is really defeating of a lot of things. So you can't just be a good intentioned person who's got their hands tied. You really have to be extremely proactive. You have to invest. You've got to figure out how to win politically in an issue in which, at the presidential level and certainly at the Senate race, people are being hammered on immigration because it's an easy scapegoating thing in a political election to talk about. And still right now, there's a really great statewide group that's fighting for, driver's licenses at the state level. And, they're slowly making their inroads. Like we've got a couple of state senators on board and a couple of, reps and other things. But we can't wait for them, at some point. Like we've got to really push on this issue. The closing down of Berks is like an aggressive push, not beyond the timeline of, like when the hearings are and all of that kind of stuff. So we still have to figure it out, and then for me, politics will follow. Politics will never lead on this issue. It will be something that comes out of organizing, but it will never lead. It'll be us being super organized, and then the politics will ultimately have to come through. And that's where I think a lot of our strategy is.
And that's certainly what has happened in Connecticut. I was bragging before about all that our communities and allies have accomplished, but there's no champion in either the legislature or the governor's mansion. There's no immigration commissioner or immigration office. Driver's license went through the transportation committee and the commissioner there. In-state tuition went through the higher ed committee and those commissioners. Trust Act went through judiciary committee and dealt with, Department of Corrections and so on. And there's no, it's the movement that pushed the politics, not the other way around.
Yeah.
My question for Michael. When the immigrant rights community was pushing back against state legislation in Arizona and other state restrictions, they were using preemption arguments, including the undesirability of having inconsistency among jurisdictions, constitutional preemption, and all that kind of stuff. So, in regard to what you might be proposing, could you anticipate that you would get the same kind of response in reverse?
Yes, I would anticipate it, but it would be wrong and it wouldn't work. The first point, of course, is that preemption only applies to what the states do. And so, yes, people like Annie and others have been very skillful in deploying preemption arguments against bad state action. And in Connecticut, we've had to defend progressive state action against preemption challenges. But what I was proposing were federal actions, so there would be no preemption. The question would be, can you have patchwork of federal immigration programs when we're used to thinking of uniformity? But that's not a preemption question because there's no state actor there. Even if there's a state bargain, it's still the feds deciding to do it in the ideas I was sketching out. It could be, and I actually think that could be statutory authority, but I don't think you have to do it pursuant to that. And certainly when DHS was wanting to discuss PEP arrangement, I did say What are you talking about, like a contract? Who signs? I'm a lawyer. I mean, just like spell it out for me. And they were not thinking 287G. They were willing to do MOU or agreement or something. So I don't think it has to go through 287G, though I think it could. I think the different challenge would be to uniformity, which is not quite preemption. Could you have disuniformity? And I was suggesting that I think you could, and noting that ICE has disuniform enforcement practices. EOIR, the immigration courts, has had disuniform adjudicatory practices, running pilot projects here and there about certain docket management practices. I don't see why USCIS couldn't have disuniform benefits practices. At least the easiest case would be on a pilot basis, which is often how EOIR has done it, for instance, to run it and see if the program works, with the idea that they might scale it up at some point.
So I wanted to ask about the role of immigrants' home state. I had an interesting conversation with someone from the Philadelphia community the other day who was talking about what the Mexican government has done for its nationals in terms of consular ID cards, bank accounts, et cetera. And she's from the Salvadoran community, her husband's from the Guatemala community, and they were thinking about, right, can we push our consulates here in Philadelphia and elsewhere to do the same for us? So I was just wondering what you think of that as a local transnational strategy. What are the promises and what are the perils of that?
So I'll just say something really quickly. We have a really wonderful group here in Philadelphia called One Love Movement, which really works significantly on Cambodian deportation issues. And their strategy has actually been to, like, a group of folks is leaving in a couple of weeks, I think, to go to Cambodia in November. Because I think that the strategy is to talk to the Cambodian government about, fundamentally, if they refuse to take deportees, and like they're coming here, they're bereft of resources, they're struggling with family and other types of things. There's no obligation on the part of the host country to accept the United States as deportees. And to see if there's an ability to kind of force the removal. Now, obviously, they have to deal at the national level. They're trying to build up kind of the movement that goes on from the, folks who are in exile in Cambodia, and working, cross-nationally with the communities that are, they're trying to move themselves up. But to me, it's another interesting kind of place to push on. It's hard for me to assess, like, value, but, as much as people organize, it's where the heart of the organizing is that will ultimately determine where it goes. And even if it's like the end run isn't the perfect thing that you want, like, there's just an enormous amount of global connections that are being made, and that those conversations ultimately seep themselves, start to seep up and, think through, like, just a more creative dialogue. 'Cause at the end of the day, this is not the U.S.'s right just to sit there and deport, thousands and thousands of people and dump them in countries bereft of almost anything, It's got to be a question of international, jurisdiction as well, so.
Two quick points. So there are currently two kind of competing proposed treaty or documents that would govern the rights of deportees. And Dan Canstrom at BC is leading one of those efforts, the more progressive efforts of the two, as best I can tell, to try to develop and then put out for, I'm illiterate in the international law, so I'm using the wrong verbs, I think, but to try to protect the rights of deportees during the process of deportation and after deportation. But so there are initiatives underway, and there's a competing one that's a more conservative kind of set of things. The second point, though, is that my own experience with this is that some nations can resist some deportations for some amount of time. But when the U.S. puts its foot down and says, we're sending them back, whether it's Cambodia or even nations that are larger or richer or more strategically important to the United States, it doesn't matter. And the United States can make a country. So my own experience trying to work home country resistance has been that it's unfortunately limited by sort of geopolitics and the willingness of the U.S. to threaten, to put at risk trade and all kinds of big issues that leave the host country unable to say, okay, we won't take back that person.
Yeah, I would just add my experience with this is similar to Professor Wishne's in the sense that, as he says, governments can only resist for so long, and unfortunately, sometimes the interests of those governments are not to protect their nationals. So that they're using their leverage in order to find out when the flight's going to show up so that they can lock people up immediately upon arrival in the country of origin, which is not the result anyway that we were seeking. And similarly, the sort of ignorance about the role that the country of origin could or should play, particularly in the asylum context, has been very troubling. So there's this sort of thinking like, oh, they should be able to talk to their consulate. Well, this is the government that has been persecuting these individuals. And so I think that's also a little bit of a reason to be cautious.
Thank you so much, everyone. I think we're out of time. Thank you for such a thought-provoking discussion.
I'm on the web, for sure.
So what if we have Pennsylvania, what if we have a Pennsylvania client?
So the particular
I'm actually the chief director. I will probably faster with the car. I'm Mike. Nice to meet you.
Get Indian? I'm like, oh.
I've got your card. And do you have a card? She was just asking me that. I don't think I do. I'm on the web, but I can find it. Yeah, and my email and phone number is also on that. Okay, for my name. I'm at Yale. Thanks. Thank you.
I've worked with that organization, yeah.
There is our clinic did FOIA work on this years ago about how the agreement
Yeah.
you folks have that already or something else.
I would imagine that they do, but I would love to make sure that they did it. So, yeah.
I just want to make myself available. I actually don't have a card.
I give you a card? It's called
No, I mean, okay, we're based on your
Okay, I'll send it to you. That would be great. I should just mention to you. So our clinic did, I said, information for years.
Thank you so much. That's wonderful. No, it was more this was good too.
Yeah, well, I was just thinking I should dig it up and get it to you. Can you just give me your address or I don't have a card on it.
Okay, no, I thought it was great.
You know, I always felt bad that we never really got to do anything much with it. I'm trying to put pressure on it. It was very, very safe.
That was the goal of this.
Now subminister.
I like the way, did you make a flush?
We got it here about halfway.
Yeah, so these are really great. And this is not.
Right. Well, they're actually working for Cambodia.
I think the ESP is just somebody came before a certain age, somebody
Baby's first flight.
Well, we went to Alaska, but we're in Washington State, so it's a pretty quick jump. She was like 6 weeks old. Yeah. No, not at all. Yeah, it was like 2 to 4 a.m. She's like, I'll be awake. I was like, this is unacceptable to me. But all right, I guess we will, in fact, hang out. In the middle of the night. Yeah. But she's mostly been a good traveler. It's just that one stretch last night.
Great. I think we're going to finally get started. We're having a few technical issues because we have a fourth panelist who's coming in through Skype, and so we're sort of addressing some of those issues. You can't hear me? Okay. Are they on?
I think we just have to.
Can you hear me now? No?
I don't know if they amplify.
Are they on? They're not on. They're on. Okay. So I was just saying that we're going to go ahead and get started. There was a little bit of delay because we have a fourth panelist who's coming via Skype, and there's some technical issues with that. So we're going to just go ahead and get started and hope that you can join us. So thanks so much. I'm really excited to be able to moderate this concluding panel of the symposium, which continues really the work of the last panel in terms of foregrounding advocacy strategies to look at what the future has in store for really disrupting the legitimacy, the ideology of the current immigration system. And if I would sum up this panel in one word, I would say solidarity. And so you're going to hear from folks about the ways that they can build solidarity with communities challenging the criminal justice system, resisting narrow conceptions of relief from removal, as well as using the concept of liminal legality to reframe discussions about immigration policy to create commonalities across groups of citizens and non-citizens. So with us today, to my right, I have Angelica Chazaro, who is an assistant professor of law at the University of Washington School of Law. And then to her right, we have Annie Lai, who is assistant clinical professor of law and co-director of the Immigrant Rights Clinic at the University of California, Irvine School of Law. And then to her right is Jill Family, who is a Commonwealth professor of law and government and director of law, and the director of the Law and Government Institute at the Widener University Commonwealth Law School. And joining us by Skype, she's not there yet, is going to be Jennifer Chacon, who's a professor of law at the University of California, Irvine School of Law, where she's also the Senior Associate Dean of Academic Affairs. So I guess we'll just go ahead and get started. Just a reminder that the symposium is streamed live and will be recorded. Please silence cell phones. And to remind individuals participating by live stream, if they want to join the conversation on Twitter, they should use hashtag Drexel LR16, or they can email questions by sending an email to drexellr16 at drexel.edu. Okay, so let's go ahead and get started.
All right, thank you so much. I will have slides about halfway through to wake you up in case my first half of my talk puts you to sleep, so you have that to look forward to. It's such a pleasure to be here with all of you. A year ago, I was at the meat market at this time as an applicant, so this is so much more pleasurable, and so thank you all, and thank you for the organizers for putting this together. I want to start by talking about the November 2014 Immigration Accountability Executive Action as the most recent example of immigration severity, since that's one of our themes today. While it offered the possibility of relief from deportation to part of the undocumented population, the executive action simultaneously refocused enforcement efforts on the ideologically acceptable target, the criminal alien. Specifically, I want to talk about the expansion of the criminal alien category through the reification of the significant misdemeanor category and the 3 misdemeanors or more categories. Then I'm going to talk a little more hopefully about 3 possible future directions. Immigration activists, as people have been talking about, have filled the vacuum created by the failure of comprehensive immigration reform and the increased immigration severity with some really creative responses that I want to spend a little time highlighting. So to start with the first half, I agree with Ingrid Eagle's observation that the federal immigration enforcement system has become, in essence, a criminal removal system. This is really a problem because it presumes that the category of criminal alien is one that has some integrity. In fact, it's a category that's highly constructed and often downright unjust for so many of the reasons that have been discussed today. As you all know, the criminal alien category includes an incredibly broad range of crimes, including increasingly more and more misdemeanors. Rather than being a just or even just efficient means for distributing removals, the system of criminal alien removals is disproportionately targeted along lines of social vulnerability, including race, class, and ethnicity. The example I want to focus on of this expansion is the executive action in November 2014 that reinforced this category of significant misdemeanor to prioritize low-level offenders for removal. This is a category, as you know, that was created by the executive, so it didn't require, there's no statutory basis for a significant misdemeanor category, and that to me is a little bit frightening. The significant misdemeanor was first introduced as a disqualifying factor for the initial deferred action for childhood arrivals program when it was first unveiled in June 2012. And so I remember being in practice and being very excited, to see DACA unveiled and getting a call from a client that day who'd gotten pulled over that day for a DUI and realizing, oh my goodness, this new category that's never existed before, the significant misdemeanor, is now a disqualifying offense for this new form of relief that was unveiled today. And so for a while, that was disappointing and that was difficult, but at the very least, it was only a disqualifying factor for this discretionary form of temporary relief. What happened, though, in November 2014, when Obama unveiled the Immigration Accountability Executive Action, with a series of memos that Jay Johnson released simultaneously, is that under a memo titled Policies for the Apprehension, Detention, and Removal of Undocumented Immigrants, what I call the Priorities Memo, the significant misdemeanor was introduced as now a basis for focusing enforcement efforts on those who fall under that category, which again includes anyone who's committed a DUI. So priority 1 under that memo are threats to national security, border security, and public safety, so terrorism suspects, individuals caught crossing the border unlawfully, gang members, convicted felons, as those who must be prioritized for removal. Then the memo goes on to list priority 2 as misdemeanants and new immigration violators as people who are the second highest priority for apprehension and removal. And the subsection to that includes people who have committed any 3 or more misdemeanors and are convicted, or anyone who has even a single significant misdemeanor as those who should be removed. This is a notable development, again, because until then, it was the category didn't exist at all until June 2012 when it was created with DACA, which was supposed to be a program that ostensibly benefited the most respectable and sympathetic group of unauthorized migrants in the U.S., those who came to the U.S. as children under DACA. So it was created, DACA at least, with the purpose of offering deportation relief, but with a significant misdemeanor making the leap from a program that offered relief in 2012 to the Priorities Memo in 2014, the act of curbing deportation became directly linked to the expansion of this categorical criminalization of immigrants in a way that I find really frightening and problematic. And part of the reason that that's significant, I think, this expansion to the misdemeanors, is that misdemeanors really make up a bulk of criminal convictions. It's most of the action in the criminal realm. 10 million misdemeanors cases yearly versus 1 million felony cases yearly. And because also most misdemeanor arrests become convictions through pleas, and so all of the problems of the plea system, that other people know much more about and have written really well about, all those flaws are cumulatively piled onto the immigration system when the immigration system takes misdemeanor convictions now so seriously in terms of priorities for enforcement or removal. Prior to the executive action in 2014, the highest number of those deported with criminal records, and so, when the government would say, we're deporting criminal aliens, who is it that we're deporting? The highest number were people with a misdemeanor illegal entry conviction. And so putting those aside, the second highest number of those deported with a conviction were those with DUI convictions. And so by making DUIs a significant misdemeanor, the executive branch was reflecting what was already being done by local actors, so local ICE officers, local immigration judges in detention centers, really prioritizing those with DUIs as sort of easy pickings for detention and removal. So you could say that the significant misdemeanor category was just reflecting, kind of catching up with a trend that was already occurring locally, with the executive branch simply saying now what was already happening. But I don't think that's the whole story, at least in Washington State, where I live and work, and which has the largest detention center on the West Coast, the Northwest Detention Center in Tacoma. What we're seeing post-November 2014 is that ICE officers and immigration judges are using the new priorities memo as a reason to deny people with DUI convictions, even when those convictions are over a decade old, to deny them bond. So pointing to the executive action memo saying, oh, well, these people are now second highest priority for removal. And so no bond at all, or setting a $50,000 bond, which is the equivalent of no bond in the immigration system. And so what I think I'm seeing to some degree is sort of an expansion of mandatory detention in a way. We're in a moment where we don't need Congress to legislate severity anymore. The executive branch is doing that for us, as they did with this creation of the significant misdemeanor. So it's almost a new form of mandatory detention, even if that were rolled back legislatively. If the practice locally continues to be to deny bond or to set incredibly high bonds for people with anything from a misdemeanor on up, the congressional changes might not have the effects that we want them to have. The ideas behind 1996, I think, have been fully infiltrated into local practice, even as I think members of Congress have started to question some of that severity. Locally, I don't see that being questioned at all. We talked, other panelists talked previously about the problems with the ICE unions and the CBP unions. That culture of severity really, I think, has so fully infiltrated and the executive branch is sort of following the lead of that infiltration by creating new categories to be responsive to local immigration enforcement practices of sweeping wider and wider nets for immigrants who commit crimes and reinforcing those practices. And that's concerning also because of the continuing partnerships between ICE and local law enforcement. And there's been so much amazing work done with trust acts and all sorts of local movements to push back on that. But despite that, ICE, the Obama administration has been incredibly successful at placing ICE officers in jails across the country, whether virtually through Secure Communities, now the Priorities Enforcement Program, or in person through the Criminal Alien Program, which continues to be in place. And has created this huge infrastructure that future administrations could choose to ramp up at will. I also want to live in the world where we imagine Hillary winning in a few weeks, but if we don't live in that world, that infrastructure is there and is in place to cause even greater destruction than what we've seen with the 2.5 million deportations under Obama. I think there's also a limit to the possibilities of reform. This total buy-in to the integrity of the criminal alien category and the righteousness of distributing removals along those lines of alleged criminality means that even as we're starting to see reforms on the criminal justice side, those reforms are being bifurcated from any possibility of immigration reform. And so one of the clearest examples we saw of that was Obama's announcement last year that 6,000 people imprisoned for drug convictions would get early release due to sentencing reforms. For the criminal justice system, this seemed to be a recognition from the highest levels of government that a moment of acknowledging that the drug war had been a failure. And yet of those 6,000, 1,700 who were non-citizens were going to be released into the arms of ICE and probable detention and deportation. And so while we're saying the drug war has failed, the drug war I guess is still okay if you're a non-citizen. And so those, that conversation still seems to not be united. So, I do think, though, because there is this current crisis of legitimacy in the criminal system, that calls for the end of mass incarceration, calls for the end of biased policing, that there is a duty and also an opportunity to create a similar crisis for the criminal alien paradigm. And I think there is this opportunity because there is this energy and interest in rolling back mass incarceration. That movement might have its own pitfalls. The Cook brothers ACLU merger is terrifying in terms of criminal justice reform, or interesting, depending on how hopeful I'm feeling on any given day. But there does seem to be a consensus that criminalization has gone too far, with this big asterisk, except for immigrants. And so how is it that we move immigrants into that conversation? I think Caitlin and Michael and others talked about how those movements are happening already. And so I want to spend some time, if it's possible, but it's okay if it's not, I can describe the pictures. It's more important to get Jennifer here. Yes, it is possible. Thank you. To talk about, hello again, how we evaluate reforms in this climate, how do we make sure that we're not contributing to the good immigrant, bad immigrant distinction, where do we go now that comprehensive immigration reform has failed, and so 3 approaches that I've seen coming from the grassroots and that I'd like to propose is ways to roll back the harms of '96. So the first is this idea of harm reduction. And so this is basically asking the question, would this intervention reduce the harms associated with living without lawful status? And so the harms associated with living without lawful status include, of course, vulnerability to detention, vulnerability to deportation, to workplace abuse, exclusion from public benefits, exclusion from in-state tuition, just to name a few. A typical response has been, okay, people are vulnerable because they lack status. Here are the ways that they're vulnerable. If we kind of push them to the side of having status, then that vulnerability would be erased. If you had status, you wouldn't face the harms associated with lacking it. But, as we know, the kinds of compromises that even the best CIR bills have proposed increase the vulnerability of those who are left out of the protections. And so even as some people might be pushed to the side of having status, those who are left out of those bills, even the best of those bills, end up more vulnerable as a result of the passage of those proposed bills. And it doesn't seem like we're anywhere close to getting back to CIR at this point anyway. So an alternative approach, which I've seen coming up, especially from the Not One More movement, is this idea of reducing the harms associated with lacking status. And so this is a picture taken outside of the detention center in Tacoma, Washington. There was a 56-day hunger strike in 2014 there. That was part of the national movement to push for deferred action that eventually resulted in the announcement in November 2014. And so there was a simultaneous demand for a moratorium on deportations with a request of deferred action for all. And so again, reducing the harms associated with lacking lawful status by giving people work permits. Another approach is those that have already been mentioned, so state-level driver's licenses, state-level DACA, state-level citizenship bills like the one we saw introduced in New York. And of course, there are some limitations. If you don't actually get to lawful status at any points, you do create this liminality that I hope Jennifer will be able to discuss with us. But I do think that taking a page from sort of the harm reduction folks on the criminal side and thinking of what are the harms associated with the lacking status and how can we, what are the interventions that could decrease those harms rather than focusing solely on status, although I agree with Michael that at some point we need to have that conversation as well, I think is one way forward. And I see a lot of groups starting to think in those ways. Another interesting demand that I see emergent is the demand to dismantle the removal mechanisms that have become so well developed and so well funded in the post-1996 world. So, under Obama, obviously, local practices that led to detention and removal thrived through the influx of resources. I saw this in Washington State when I was still in immigration practice with a huge influx of Border Patrol officers to the Olympic Peninsula, which led to all sorts of issues, including too many Border Patrol officers not having enough to do and thus being used as 911 operators because they spoke Spanish, being used as translator during domestic violence calls, problems that we continue to see today. And so what we started to see is groups calling for dismantling ICE, dismantling DHS altogether. And so this is a picture from an action in this past February blocking inbound traffic to the regional ICE field office. And to me what was notable about it was that, again, it was a link not between immigrant activists and also Black Lives Matter activists. And so I want to read from a statement that Asada's Daughters, one of the groups that took part of this action, released as to say why they an African-American group were blocking ICE. They said, undocumented people in Chicago and nationally are living in fear daily of being taken from their homes and away from their families. We as Black American community organizers can relate to that fear. Our communities experience that fear when Chicago police officers patrol our neighborhoods, stop and frisk us, occupy our schools, and arrest us en masse. Our struggles are distinct but connected. When enforcement is overfunded, that is money that is not being spent on services that actually keep us safe. And so again, here it's this interesting moment where even though on the immigration side there seems to be this bifurcation of criminal justice reforms or police reforms and immigration reforms, that bifurcation does not exist in the activist realm. Those connections are already being made by people on the ground, as you can see in this photo, which then was made into this gorgeous artwork. That these are the sorts of images and ideas that are circulating in that realm. Another campaign that I see that's part of this sort of dismantling the infrastructure of removal is a current campaign in Arizona, the Basta Arpaio, which is trying to have a victory this November and actually finally getting Sheriff Arpaio out of office. Obviously Sheriff Arpaio, the famous sheriff of Maricopa County, who's advanced a really virulently anti-immigrant agenda that goes hand in hand with Trump's proposed agenda. And so to me, this is an example of a local campaign to dismantle immigration enforcement because Arpaio has focused so greatly on funneling people into ICE, into CBP custody, even though the federal government has pushed back and said, we don't like what Arpaio does. They nevertheless have accepted folks transferred to their custody or place people in removal, or accepted the convictions that people have had under Arpaio's watch as reasons to make them ineligible for DACA or even removable. And I know Annie's clinic has done some great work on this front. So again, the Basta Arpaio campaign is a different kind of electoral campaign, not just to defeat Trump, but to actually have an active victory to change the lived conditions of people in Arizona who've already been living under Trump-like conditions, for the 2 decades of Arpaio's rule. And then finally, I'm also seeing the beginnings, and similar picture to yours. I think I just have a smaller frame, Caitlin, of engaging with abolitionist demands. So this is, I think, both part of the engagement with dismantling infrastructure, but also almost a step beyond it. The logical end, I guess, of dismantling the DHS infrastructure would be to end detention altogether. And so I see groups like Juntos and others here in Philadelphia as part of the Shut Down Burks campaign, calling not to reform Burks or to make Burks a little less bad, but to shut it down altogether. And so again, with family detention, that seems like an obvious ask, but this is, again, taken outside the detention center in Seattle, in Tacoma, right outside of Seattle, about a year ago at one of the shutdown actions there, where again we see the banners asking for a full end to detention, not just a reform of the conditions inside, but a full just release of everyone who is detained. And so, it's clear that this may not happen tomorrow, but activists are starting to make moves and demands in this direction, which I think moves the entire conversation over to a different place. To me this is relevant because I think we have an opportunity with next year's terrible anniversary of the creation of DHS, 15 years of DHS, to think about what it would mean to dismantle that agency. They haven't finished, the federal government hasn't even finished building the headquarters for DHS, so I say, if they haven't finished the building, we have a chance still to say, that just declare it a failed experiment and think about what would it mean to have immigration functions of a government under an agency that doesn't have the word homeland or security anywhere near it. And so I don't think it's too late for that, and I think that activist organizations are already thinking in those directions, and it behooves us to kind of move there with them. And then finally, a campaign that's close to my heart, again, with making the links between the movement against mass incarceration and bias policing and the movement against immigration detention and immigration enforcement in general, activists in Washington State are moving seamlessly from fighting a project of King County, the county where Seattle is located, to stop the building of a new youth jail that the county's trying to build for $210 million, and then going down to Tacoma on the weekends to try to block detention buses. There is no distinction for them among those campaigns because they see the continuities between criminal enforcement and immigration enforcement. And there's continuities that are just on a very practical level. The same architect that built the detention center in Tacoma has been hired to build the new youth jail in Seattle, to just the continuities of being against detention in all its forms. And so this kind of thinking is very hopeful to me. And again, I would invite us as scholars to kind of take the lead from activists who are already thinking and pushing the conversation in directions that maybe we haven't quite yet caught up to. Thank you so much.
Hi, I'm Annie, and I came yesterday from Arizona. I wanted to thank Professor Callahan and Drexel Law School again for inviting me and for having this conference. I think it's not an easy feat. I think it speaks a lot to, Anil, your role in all of this, that you can pull this group of people together. So thank you. Also, I want to acknowledge that I'm in the room with a number of former mentors and former professors. And so while for me 1996 is not a trip down memory lane, I was not even in law school then, it was, I know about 1996 because of them. And people like Nancy and Mike really, when I was in law school, sensitized me to the issues of criminalization and the connection between the criminal justice system and the immigration system. And so I think it reminds me of our dual role as scholars and thinkers and advocates, but also as teachers, that we have been living now since 1996 under a regime that has spanned multiple generations of advocates, and that as we continue, we have to continue to also recover the history of a time before 1996 and to instill in people, law students, the possibility that there could be a different world. So, thanks, guys. I also wanted to thank my research assistants who have helped me with what I'm going to present today, Nora Cassidy and Ann Kam, both of whom are clinic students in our Immigrants' Rights Clinic. And I want to speak, because we've been talking about reform, that's I think the purpose of this panel, I want to speak about the possibility of post-conviction rehabilitative relief as a potential place to start, and maybe by the end of my presentation I will have convinced you that we should look more closely at that, that kind of turn in 1996 and where we should go from here. And so, for those who are not students of immigration law, there is a rule in immigration law that as a general matter, expungement and other forms of dispositions based on rehabilitation and even pardons are not effective for stopping immigration consequences, removability, as well as eligibility for relief. This is one of the stealth provisions Nancy spoke about this morning. For decades before 1996, going back to the 40s and 50s, BIA cases treated a conviction that had been set aside, dismissed, expunged, as not a conviction, really, in the immigration system. And the House bill that was intending to codify the 1988 BIA decision, matter of Oscock, that Nancy spoke of, that had 3 prongs, when it went into the conference committee, came out with 2 prongs. And matter of Oscock was intended to remove a disparity between the treatment of people who receive a deferred sentence and people who receive deferred adjudication. And both of those serve a similar function in the criminal justice system. And so the BIA decision was kind of intending to address that specific problem. Then when it went through Congress and the 3rd prong of matter of Oscock was removed in the conference committee, and I have some intelligence that that might have been because Lamar Smith had a pet peeve about the Texas deferred adjudication statute that he wanted to specifically address, and then became a nationwide rule. that BIA decisions in federal courts interpreting the kind of absence of that third prong in the Matter-Voskok codification then interpreted the provision to swallow more and more dispositions, including set-asides, dismissals, and expungements, and even direct appeal. And as Jason has observed and advocates argued at that time, this didn't flow from the statutory text of IRA, but it was a disputed matter of interpretation that I guess now, years later, we kind of take for granted. But the formal rule in immigration law, I think, is here to stay until there's some, I don't know, abolishment of Chevron deference. You know, if we're going to look forward to the next round of legislative change, I think this is worth looking at more closely. I think in the expungement rule in the definition of conviction in 1996 is an example of doubling down on what Jason discussed earlier and that Nancy has discussed, the criminal history, the use of criminal history as a proxy for undesirability and the primary mechanism by which we decide who stays in the country and who must leave. And moreover, the expungement rule treats criminal convictions as fixed at the time of adjudication or the admission of guilt, ignoring any post-conviction events. So, turning to 2012 and 2014, one of the things that's really interesting about the DACA program and the enforcement priorities memo in 2014, both of which reflect hard-fought gains, although at the same time really codified or I guess reflected and reproduced that feature in formal immigration law, the heavy reliance on criminal history as a bar to relief. There is a rule in the DACA FAQs and was after the 2014 enforcement priorities memo came out. In 2015, there were FAQs as well, saying that if a conviction has been expunged, and expunged in the kind of immigration law sense, which includes set-asides, dismissals, and I would argue deferred adjudications, that will not act as an automatic bar to relief, and instead the administration will consider whether you're eligible for prosecutorial discretion or DACA on a case-by-case basis. And so this is one example of a departure in these administrative actions from the rule in formal immigration law. And there's a couple of others I'll just briefly mention. I know people are doing work on this. Simple drug possession, which is a basis for removability in formal immigration law, is not a significant misdemeanor in the definition under DACA and the enforcement priorities memo. In addition, suspended sentences don't count towards the 90-day rule for significant misdemeanors. And so while these are limited, I think they do say something about where we are currently, about our values and in the immigration system, and where we were in the 90s and how much we were focused on drug offenses. But it also shows how far we have to go, because there's more activity happening in the criminal justice arena at this point than in the immigration arena. And so when you look at immigration and you see these limited departures, it kind of suggests there should be more. The expungement rule for DACA and the enforcement priorities memo has, it's kind of interesting to think about how that came about. It might be because of the ad hoc nature of DACA, something that Juliet Stump and Stephen Manning have called liminal law. DACA as liminal law, it kind of creates a space for experimentation when there is ossification in the legislative process and the creation of formal immigration law. I think it matters because, as Juliet and Stephen talk about, liminal law has a tendency to become sticky over time. And so it may be that the next time we go back to Congress and think about criminal bars, they're going to look at DACA and the enforcement priority memos and essentially codify those as the new criminal bars. It's also led to shifts in the landscape at a level that some might not think about. And so what has happened in California is that because of the DACA expungement rule, criminal reentry and clean slate providers who have for decades not served non-citizen communities because not, out of malicious intent, but because there is this rule that it's not effective, and they don't want to screw up somebody's immigration case by saying, well, I'll help you get an expungement, and then that person applies for naturalization, and the next thing they know, they're in removal proceedings. And so clean slate providers and immigration advocates have largely existed in separate spheres. And because of the expungements rule in DACA, there's now starting to be workshops where you have formerly incarcerated people who have contact with the criminal justice system, and immigrant advocates and immigrants coming and sharing a physical space, and that has led to some interesting conversations. Dreamers are at the forefront of this, as you can imagine, because they've also embraced the notion, not one more, that we have to start to build bridges between immigrants' rights and criminal justice advocates. Okay. But the reach of this expungement rule is still limited. On the ground, the practical effect has been that it has helped people who have a single DUI conviction. Now they're getting those expunged and then applying for DACA. But it's still scary if you have something more serious than a DUI, even if you have an expungement, to apply for DACA, because you may still end up in removal proceedings because the administration may still deem you somebody who should be subject to removal. Okay, so how am I doing on time? Are we going to be joined by Jennifer?
I don't know.
Okay. Okay, so I'll just give out, provide you guys a few reasons why I think, or what looking at eliminating the expungements rule in immigration law might do. So first of all, it is an incremental change. It certainly is not going to do away with the reliance in the immigration system on criminal convictions, which is, I think, eventually where we want to start to push or undermine that ideology and the construction of the criminal alien. But I think it can do a few things. So first, I think it can undermine our understanding of a conviction as the outcome of a process whose, in the criminal justice system whose primary function is to adjudicate guilt or innocence. There's been some literature on the criminology side observing that the criminal justice system has become more of a managerial model of justice as opposed to, especially for misdemeanors, as opposed to an adjudicative model of criminal law administration. The adjudicative model would posit that that the criminal justice system selects the right people for formal punishment, whereas the managerial justice model observes that the criminal justice system seems to be operating more to monitor and keep tabs on people and as a form of social control over their lives, and to kind of try to encourage people into certain behaviors through their engagement with the criminal justice system over time, and to sort and assess them over time for compliance with certain probation terms, et cetera. The Supreme Court's decision in Padilla even explicitly recognizes that a plea in the criminal justice system is the product of creative negotiation between a defense counsel and a prosecutor, and that it may not necessarily reflect the underlying conduct. And so there is a growing view that the criminal justice system doesn't just produce measures of guilt or innocence. And that also means that more people are coming into the criminal justice system, being pulled into it, and that there are more people with criminal history on their records. And so while mass incarceration is still a pressing problem, punishment no longer operates primarily through incarceration, but through the reduced liberties associated with probation and collateral consequences. Jenny Roberts has written about that. And the struggle for many people is the long process of proving oneself worthy after formal punishment has ended. So changing the expungement rule in immigration may help add to a debate about what the post-plea experience should look like, and hopefully question immigration as part of a basket of collateral consequences that are the sanctions imposed by the criminal justice system that overall we should be looking at as an area for reform and a site for possible amelioration. Second, in addition to proportionality, which many people have talked about today and have written about, I think that revisiting the expungement rules in immigration law can reopen a conversation about whether conviction history furthers the membership screening function, which is something that criminal history has become untethered from in the successive experiments in severity. If it doesn't serve a membership screening function, then it really is just punishment, and the procedural deprivations through its categorization, deportation is categorization of civil rather than criminal, have to be examined. But if we are to take seriously criminal history as a membership screening function, then that justification has to be looked at more closely. And to the extent that criminal history might be relevant at all, I think post-conviction events may be more informative. Expungement and these other dispositions, set-asides and dismissals, when somebody gets them, that tends to be a success story. It tends to be a redemption story. It marks positive engagement with the legal system by successfully completing probation. In cases where expungement is discretionary, a person has to demonstrate their desire to, be a good member of their community. They may express a desire to increase their family's stability, to become more involved in their community, and it provides an opportunity to reassert dignity of the individual, which is one of the hallmarks of clean slate programs and reentry programs. So it has an integrationist aspiration that criminal justice advocates have long been engaged in, and something that we can kind of bring into the immigrants' rights realm. And then I think ultimately the hope would be to erode the mainstream understanding of who is an immigrant with a criminal conviction, and to put those stories in the public eye. Frank's idea of changing the facts on the ground so that when we go back to Congress, maybe we'll have a different vision of who are immigrants with criminal convictions. And then the third is just a brief observation about what defense attorneys can do. So Padilla was a significant opinion, recognizing that defense attorneys have both an obligation to advise about immigration consequences, but also in the dicta of Padilla, a recognition that defense attorneys may be able to negotiate with prosecutors to get a plea that would avoid an immigration consequence. And there's been quite a bit written about Padilla and the importance of training criminal defense practitioners to be prepared to do this. But Padilla's vision of creative negotiation is severely limited for defense counsel because the prosecutors might not be willing to negotiate with defense counsel in many jurisdictions. And so even if a defense attorney wants to try to do right by their client, they may not be able to. Defense counsel may be better able to talk to prosecutors, however, about set-aside, dismissal, or deferred adjudication dispositions because the prosecutor might still be able to get their conviction, and then they can see how their client does over time. I think that the back end of the criminal justice system has been underappreciated as a potential area for reform and advocacy, and understudied by academics, although, Jason, you're an exception. And so, concluding thoughts. I want to note that I don't think that that revisiting the expungement rule in immigration law is mutually exclusive necessarily with restoring IJ discretion or with judicial recommendations restoring the JRAD. But expungements, set-asides, dismissals tend to be more automatic in the states where they're available, and don't necessarily require presenting yourself before a tribunal for your entire life to be judged. In many jurisdictions, and there's a lot of advocacy around this to push more in that direction, in many jurisdictions you can get a set-aside or dismissal just by showing you've completed probation, you've met certain kind of a checkbox of items, and then you can apply to the court. Now this is, the caveat is that this is only available for certain types of convictions. They tend to be misdemeanors and less serious felonies. And second, a caveat, or I guess maybe a reason to think about this, it's possible that our best chance for changing the expungement rule might come not through an immigration bill, but bundled together with other criminal justice reforms at the federal level about federally regulated collateral consequences. And the work on the ground to build bridges and plant the seeds between immigrants' rights advocates and criminal justice advocates may be our best way to get there. And so that's potentially something to look at. And finally, this is certainly not a perfect answer. It's just something I've been thinking about, and something that a small but hopefully growing number of advocates are thinking about. And there are people in this room who have connections to DC who might help us think about it. I think it really depends on, and I'm interested to hear what you think, but how it fits in your framework for dismantling the criminal alien paradigm, how it's done, and the framing of what its significance is, so that we don't end up drawing or solidifying another line. But I think the timing is right for that, because advocates are getting creative and thoughtful about where we go from here.
So I'm going to stand up because I feel like I'll be louder when I stand up. I feel like I'm in class and I'll be really loud, but don't worry, I won't call anything. So I want to thank Anil and the Drexel Law Review for bringing me here. It's been such a pleasure to be a part of this and to listen to all the presentations today. I called my talk, or my presentation today, The Future Relief of Immigration Law, and I specifically chose that title because it has double meaning. On the one hand, it narrowly refers to what relief from removal might look like some point in the future. On the other hand, it also more generally refers to the relief that our entire legal immigration system is craving, as we've heard so much about today. Our entire concept of immigration law and how we administer immigration law is in need of reform, right? We need something, and all the discussions today have been thinking about what is that something that can help relieve the pain and distress of our entire system. And the dual meaning of the title is appropriate for my presentation because I think that the future of relief from removal, right, relief from deportation in colloquial terms, is in fact tied to the future relief of immigration law as a whole. So I think we need to think about those two together. Now, many wonderful legal scholars have crafted powerful critiques of the stingy relief from removal that exists today. And if one looks at the progression of immigration law over the last 100 years or so, it definitely is a story that it has become much easier to be removable and much harder to obtain relief from removal. And I went back and I looked at scholarly critiques of cancellation of removal, of the kind of relief from removal that we have today because of the 1996 laws. And all of those critiques sort of surround a common theme, which we heard a little bit about today. And that theme is that current relief from removal is not proportional enough. That cancellation of removal fails to inject meaningful proportionality into our immigration system. And so some scholars in their critiques have looked to other areas of law to try to find ideas for how to inject more proportionality into our immigration system. One possibility is family law. Right? Family law is implicated here because family law has a lot of experience adjudicating the rights and interests of children who are facing separation or potential separation from one or both parents. And in immigration law, of course, U.S. citizen children face separation. removal will cause, quote, exceptional and extremely unusual hardship, end quote, to that U.S. citizen child. So some scholars have floated the idea that family law's best interest of the child standard would inject more proportionality into the immigration system, and that the exceptional and extremely unusual hardship standard of cancellation diminishes the importance of the interests of a U.S. citizen child. So importing the best interests of the child standard into a decision to remove a parent would raise the visibility and importance of a U.S. citizen child's interests. Other scholars who have looked at this lack of proportionality have looked to international law for examples of greater proportionality in decisions whether to remove an individual. Earlier, Allison was talking to us about the American Convention, and that's one example. Another example is the European Convention on Human Rights. That convention explicitly recognizes a right to family life. Article 8 of the convention establishes that right, but it's not absolute. It says that a government may interfere with an individual's right to family life, but only if that interference is proportional. So proportionality is injected into the legal framework. The language of the convention states that governments may not interfere, quote, except such that is in accordance with the law and is necessary in a democratic society in the interests of national security, public safety, or the economic well-being of the country, for the prevention of disorder or crime, for the protection of health or morals, or for the protection of the rights and freedoms of others. So a government under the European Convention may interfere with an individual's right to family life, but only under certain circumstances. And courts have gone through and interpreted that language and have sort of fleshed out what those circumstances are. But I think most interesting for our purposes is note under the European Convention framework, the default position is that the government should not interfere with an individual's right to family life. And immigration law, of course, implicates a right to family life because family separation is often a consequence of removal. So some scholars have looked to examples like the European Convention for inspiration on how to make the system in the United States more proportional. And we know that unlike the convention framework, U.S. law starts from the opposite position, right? U.S. law starts from the default position that we expect family separation in immigration law. And I think, a lot of us who work in the immigration law field, we talk about this all the time, and I think we should stop and just think about that position, right? That U.S. American law expects family separation in immigration law. The burden is on the family to show that they will suffer hardship substantially beyond the hardship we expect a family with immigration troubles to face. So far, the U.S. Supreme Court has not recognized any constitutionally based right to family life in the immigration context. Our legal system not only accepts, but expects hardship to U.S. citizen children. Because remember, relief is only available if they can show exceptional and extremely unusual hardship. If it's just plain old regular hardship, then you get no relief. And this is something that has always deeply troubled me. And because if you think about it, it's really become sort of this casual acceptance and acquiescence of hardship as a byproduct of our immigration system. Other scholars have critiqued cancellation of removal by connecting cancellation to other components of our immigration laws. So, for example, cancellation of removal is just one piece of a bigger system that as a whole lacks proportionality. So Professor Juliette Stump, she's observed that the ubiquitous immigration law penalty is always removal, right? She has proposed a more graduated system of repercussions for immigration violations. Professor Jason Cade, who we had the honor of hearing from earlier, of course, he's recognized that the slim opportunities for relief from removal moved the pressure point for proportionality much earlier in the system, right? This balloon photo with the hand squeezing it. So proportionality falls on the shoulders of those actors who decide whether to put an individual into removal proceedings in the first place. Because immigration agents have prosecutorial discretion, the decision whether to put someone into removal proceedings at all becomes the main focus for equitable consideration. Similar, Professor Stephen Lee has shown us how actors in the criminal justice system hold equitable immigration law power, because charging and plea decisions in the criminal justice system have the power to determine whether removal will be the immigration consequence of a criminal conviction. So I go over all of this with you because I absolutely agree with all of these scholars that lack of proportionality in relief from removal is a major problem in immigration law. But I think we need to take a broader approach and look at how the lack of proportionality through cancellation of removal actually illustrates much bigger problems about our immigration system. So the problem is bigger than just a lack of proportionality. So there are three other problems that I think relief from removal illuminates that I'd like to discuss with you. The first is what I call the conflicting signals of immigration law. The second is the dysfunctional immigration adjudication system. And anything I'm saying on that topic, I just want to say at the very top, present immigration judge company excluded from whatever I'm saying. And the third topic I'd like to discuss with you is looking through a lens of relief from removal, what that can tell us about the system's adherence to an outdated notion of sovereignty. So I'll start with conflicting signals. So what I mean when I say conflicting signals is the mixed messages of immigration law. And if you look back in history, conflicting signals have always been a major feature of immigration law. The immigration statutes have been designed and are designed to give and take at the same time. This fits with the discrepancy between the popular narrative as the United States as an immigrant nation and a much more complicated reality. If one scratches a little deeper beyond the surface, we see that our national commitment to our immigrants is at best hedged. The existence of expansive removal grounds and hard-to-achieve relief from removal illustrates the fundamental dichotomy of our immigration system. We want to say we are a nation of immigrants, but we don't really want to be a nation that fully commits to its immigrants. And the structure of cancellation of removal, I think, reflects this hesitation to truly commit to the immigrant narrative. Relief from removal exists, right? We want to say we have relief from removal, but its coverage is narrow. It's very difficult to obtain. And the history of relief from removal shows these conflicting signals popping up over time. Right? For over 100 years, Congress has been trying to find the balance that it likes when it comes to its commitment to immigrants. Congress has fiddled with balancing legal immigration opportunities with varying removal grounds and varying forms of relief. Hedging has always been a prominent feature of our immigration system. It's just that in more recent times, the balance has shifted even further away from a commitment to our immigrants. So I think that the lack of relief from removal is part of this bigger trend and a historical trend. The conflicting signals that have always haunted immigration law. And the conflicting signals, relief from removal included, reflect an attempt to have it both ways, to maintain a narrative of immigrant pride without fully committing to those immigrants. So next I'm going to talk about the adjudication system. Maybe you should just cover your ears.
I might agree with you.
Okay. Good. The reputation of the immigration adjudication system is poor. As has been observed, immigration judges decide cases with death penalty-like consequences with traffic court-like resources. The backlogs in the immigration courts are notorious. There are over 500,000 cases awaiting adjudication in the immigration court. And immigration judges famously suffer from more workplace burnout than prison wardens. The U.S. Court of Appeals judges have signaled out bad actors among the immigration judge corps, although not all of them. And from my perspective, the substance of immigration law, including the stingy availability of relief from removal, contributes to the troubles of the immigration adjudication system. Because the removal grounds are so broad and harsh, because there is little relief from removal, the job of immigration judge includes not enough room to consider equities and to basically act like a judge, right? That's what judges do. Immigration judges are perhaps more accurately described frequently as just conduits for decisions preordained by a harsh statute. I think this contributes to the weaknesses of the immigration adjudication system because the job of immigration judge may be less appealing to prospective candidates if it doesn't involve much actual judging. It is a system where immigration judges are not trusted to be judges, okay, and are not given the necessary tools to manage caseloads, but we somehow expect quality candidates from a wide variety of backgrounds, and we expect top quality work. So that brings me to my last topic, and that's sovereignty. I think that relief from removal also illuminates the continuing importance and influence of traditional notions of sovereignty in immigration law. While immigration law has progressed somewhat from its 19th century constitutional roots, the plenary power doctrine of that era is still a major force in immigration law. The combination of broad categories of removal and limited relief from removal reflect a system where the nation retains the leverage to revoke the right to remain under a wide variety of circumstances. Individual rights of the foreign national and the foreign national's connections and contributions to the nation are suppressed in order to strengthen the government's power to remove. This reflects a plenary power approach to immigration law, where thoughts of individual rights are viewed as threats to sovereignty. Under this approach, more generous relief from removal is seen as antithetical to government control over immigration law, and the goal is to maintain complete control. After all, the 1996 changes to immigration law narrowed the ability of immigration judges to grant relief precisely because supporters thought that immigration judges were too generous and were letting too many foreign nationals escape removal. The 1996 restrictions on judicial review followed the same logic. Federal judges should not be able to second-guess administrative immigration decision-making because those judges were giving away too much. This was seen as a threat to sovereignty. Which brings us back to proportionality. The effort to inject proportionality into decisions to remove necessarily implicates thoughts about immigration sovereignty. If proportionality means that individual rights take on greater importance in removal decision-making, then there is little room for proportionality in a plenary power system. Greater proportionality in relief from removal is therefore dependent on broader advances in how we envision government power in immigration law. So, relief from removal does suffer from a lack of proportionality. I completely agree. But my goal today is to show how relief from removal is also emblematic of and tied to other deep and broad problems affecting immigration law. I firmly believe that immigration law is in need of a comprehensive reset, and that meaningful improvements to relief from removal are tied to a much broader reconceptualization, not only just on questions of, a path to legalization, but also the legal framework, right? Shedding our plenary power notions of immigration law and establishing a system that recognizes and will accommodate individual rights. Thank you.
So next, we're going to be joined by Jennifer Chacon by Skype. Hi, Jennifer. So I think we're glad that you could join us, and go ahead.
See you next movie. Maybe unmute?
Hang on, we're working on sound issues. Looks like she's getting equipment out. No, we still can't hear you. We're still working on it on our end.
Yeah, talk a bit of fun.
Right. It depends. Just have her talk on the phone.
We can call her and then put her next to a microphone.
Everybody call her at the same time.
Yeah. It's so stinks today. It never works. It's like, what if you call mom? Or it works, but like something is wrong. When did we do something?
4:45. Yeah. I think so, yeah. Because 4:45 to. Yeah. I think it's 4:45. There's lots of. It's fine. I can't. I used all my words for the day. The gap, it's everywhere. It's all over the place. I'm excited about your paper.
Oh, if it ever gets written. It will. I think you've just arranged something, like if I can't write it, I would just put out to the research.
Yeah.
That would be more for funders
It would be great practice advisory too for, ILRC or...
ILRC's been doing
Yeah.
a lot of the work.
Oh, really? Okay, so they have those.
Okay.
Oh, nice.
I mean, they've been training the clean state providers, which is really great.
Yeah, it's really neat that, Washington State, there's so many, my former clients who are just like, oh, I want to do UI.
Yeah. Well, it's one from someone who has been a practitioner for a while, including like before 1980. Who was saying that they're used to clinics,
like the JRAD one.
Yeah, exactly.
I didn't even know about JRAD.
But like for legalization, we're doing like massive clinics.
I'm like, oh, it's so dreamy, Like, gives me a chill.
Back in the day, it like, wasn't a thing.
It's amazing. But I also love the not, what you talked about, it not being like I have to have my whole life on display and see that I'm a good person, because that works into like a bad economy. So,
that's what the categorical approach is.
Right.
Like, we kind of don't want judges to
No.
be deciding
Oh, hell no.
based on the details of the offense, whether they should be
No.
arrested or they didn't.
Yeah.
they've been working the system for decades
Whether that's
Yeah.
the thing, yeah. Even if it was, I feel like, yeah, just it goes against the organizing so much to have to like build these cases of like, he's a good immigrant, not like all these others, you know, and then at the same time, the same groups are trying to fight against like, the good, bad. Right. Like there's so much about it that taking away the discretion or just making it more automatic seems like such a smart move. Yeah. It's really interesting. Jennifer!
Is it a battery?
Is it a battery? Good. Just hang out.
It's so bad.
Just a typhoon headed to Seattle.
What?
There's a giant storm headed to Seattle. It's historic.
Are you supposed to go out tonight?
Supposed to leave tomorrow, but it hits tonight and tomorrow, so maybe I'll meet you in New York.
Sounds good. It'll be fun.
Yeah.
So he says that we do have Q&A time because we can go into their last 15 minutes.
No,
So
I
you guys can't escape.
would never want to. The wrap-up seems so important. Only really need to bring it all together. Yeah. I won't know what they would have said. Yeah.
Okay, this might work.
I'm hopeful. Oh.
She's calling someone.
She's talking to Anil.
Hello? How does this sound? Is this terrible?
Yeah. You can hear them.
Can you hear?
Oh no, I think it was her.
Try again. Try again.
All right. So nothing I say could be worth that weight.
Maybe this one is more powerful. Yeah. Yeah, but at least we.
All right, go ahead, Jennifer.
Okay, so can you hear me now?
I have to try really hard.
Concentrate.
Somewhat.
Somewhat.
Somewhat. Okay.
It's not.
Do you want me to go ahead? Shall I go, or should we just let the panelists feel? Okay, I'll go. Cut me off if it gets to be incomprehensible.
Okay.
So I want to say thanks to Anil for inviting me and for letting me participate in this unusual way. And I want to also apologize for not being there, but to let you know that I'm at AALS doing interviews. So I'm in a conference room with my colleagues all day, and for so many reasons, I'd rather be there with you. So mindful of the suboptimal effects of this way of participating, I'll be brief, and hopefully incendiary, so that we can have some conversation, time for conversation at the end. So our panel is called Rethinking Immigration Severity, but I admit that as I approached this project, I was really thinking of it as either what the 1996 laws mean to me today, or how the 1996 laws gave us Donald Trump. So when I think about the 96 laws, I mean the three intertwined pieces of legislation: the Illegal Immigrant Reform and Immigrant Responsibility Act, the Antiterrorism and Effective Death Penalty Act, and the Welfare Reform Act, that passed together and had related goals. And when we grouped these laws together, we could see the triumph of the ideology encapsulated in the mid-90s Contract for America, a triumph of purportedly small government neoliberalism that in fact expanded the carceral state at the expense of the welfare state, and that stripped poor immigrant and minority communities of resources while simultaneously increasing state spending on mechanisms through which these same communities would be monitored, policed, incarcerated, and excluded from political participation. And of course, from the physical borders of the nation. When I think about the most significant byproducts of these laws, I see 5 distinct but interrelated achievements, and I use that word ironically, of the 1996 laws. And I'm just going to briefly catalog them because I don't want to put you through this for too long, but I'm happy to talk about them more in Q&A. So the first is the overcriminalization of immigrant communities. For reasons discussed throughout the day, reliance on criminal records in immigrant sorting is a poor proxy for public safety or community benefits, but that's what the 96 laws achieved. These imperfections are not accidental. These laws were dog whistle politics embodied, and these laws achieved precisely what the dog whistlers wanted, insofar as they created an almost foolproof way to selectively screen out poor brown men whose overrepresentation in the criminal justice system is now at last widely acknowledged. This leads to a second and interrelated effect of the 96 laws, which is the facilitation of racism without racists. The 96 laws, particularly when read along with the crime legislation that they mirrored and built upon, helped us normalize the vilification of illegals, criminals, terrorists, terms which replaced other, more racially derogatory terms for blacks, Latinos, Muslims, justifying their surveillance, their disproportionate exclusion, their incarceration, and their banishment, in a rhetoric that fits comfortably within a framework of post-civil rights racism. Third, we see the normalization of immigration enforcement federalism, where this racism runs from top down and bottom up. INA Section 287G was the product of 1996, and this sleeper hit changed the landscape of immigration enforcement, not only by allowing for contractual immigration enforcement federalism, but also by planting the seed of the idea that states and localities could and should view federal immigration enforcement as part of their routine law enforcement mandate. This was reflected in secure communities at the federal level, in Arizona's SB 1070, in Alabama's HB 56, but also in countless acts by which state and local authorities either attempt to regulate immigration directly or target it indirectly through the enforcement of criminal laws, prohibiting things like driving without a license, identity theft, smuggling, etc. The fourth related trend is one that Hiroshi Muramura has documented quite well, which is the declining salience of lawful permanent resident status. And I want to link this to a fifth and final trend, which is the emergence of new forms of liminality that striate citizenship status and that ironically lead to a declining salience of federal citizenship and immigration status. And I say it's ironic because I read the 1996 laws as intended to create clear, bright-line rules between citizens and everyone else, and to reserve federal largesse for only the most worthy of citizens. And yet, I would argue that these laws have not done that, really, but have instead weakened the power and significance of federal citizenship as a sorting mechanism. I don't want to be dismissive here. Formal legal status matters. Most obviously, it protects people from certain forms of banishment. And yet, federal citizenship matters less as a result of two important 1996 engendered shifts. First, the 1996 laws have ultimately created a paradigm where states and localities are exercising great power in shaping the experience of their residents. At the same time that enforcement has ramped up and national borders have hardened, state and local governments and their administrators have become the primary enforcers of immigration law and the primary gatekeepers of social benefits for immigrants. including various forms of welfare, health care, and educational benefits. Suffice it to say, states and localities have exercised that authority in very different ways. Consequently, at the aggregate level, it means something very different to be undocumented in California than to be undocumented in Arizona or Georgia. So state and local membership has begun to matter more when federal citizenship status matters less. The 1996 laws have not only weakened the importance of federal citizenship vis-a-vis state and state laws, but they've also weakened or at least failed to shore up formal federal citizenship vis-a-vis an ethnic nationalist vision of belonging. The 1996 laws did important work to reify existing exclusionary notions of citizenship as the domain of those who could be imagined as part of a nominally diverse but really homogenizing white nationalist ideal. Focusing on the collective experience of unauthorized immigrants, of LPRs, and of citizens today, one is struck by the ways that intersecting categories of race and place and class are often far more important than formal status in defining one's American experience. Given the ways our immigration laws are enforced through police actions based on collective racial understandings and folklores of illegality, race, class, and geography will often do more work than formal immigration status in determining who will suffer exclusionary and punitive government action. Our collective folk wisdom about who is an immigrant and who is a dangerous outsider is doing important work in guiding formal practices of exclusion and inclusion on the ground. I don't want to oversimplify here in my discussion of race because the racial narratives that 1996 helped to shore up are not simple narratives. We daily witness the way they produce complex racial meaning where Latinos are constructed as the iconic illegal alien, but where Latinos also make up a significant chunk of the policing agencies that enforce internal and external borders, where migrants and their co-ethnics seek to forge alliance with more privileged groups of society or with the more marginalized, depending on their own political priors and their current situation, where perceptions of which groups belong here and the justifications for their inclusion shift over time. Ultimately, however, I think it's important to see how Donald Trump's ability to appeal to a readily invoked white national sense of U.S. identity has very much been facilitated by the groundwork laid in 1996 and the concerted implementation of these laws in the intervening years. Seeing a way forward out of 96 requires all of us to see with a clear-eyed realism, to name the resulting social problems with accuracy, and then to forge the solutions, be they technocratic or more radical, that portend a more inclusive and fair architecture of social belonging. Ultimately, what I'm suggesting is that reform proposals, the way forward, have to understand, engage, and explicate the role of racial animus in generating these laws. Activists and grassroots organizers are not afraid to name racism and white supremacy when they see it, and as scholars who are diagnosing the ills that these laws create and charting the potential ways forward, we can't be afraid to say these things either. So I'll stop there.
Great. Thanks so much, Jennifer. So we're going to now open it up for questions. You have to give it a day. Becky.
I obviously but I want to share with you some perspective I received when I was doing some saying
groups that are trying to center blackness within immigration, because that has been erased so much, and sort of the disproportionate effect of the 1996 laws on black Dominicans in New York and in other places with large black immigrant populations. And so that is part, I think that's part of the answer, is first of all, where are the black immigrants in our movements? And then also, what I liked about the Asada's daughter statement that I read was that they're saying, we're in solidarity, but this is not the same struggle. We see that policing affects both of our communities, but it affects us differently. Nevertheless, we'll show up for each other, but it's not drawing of false equivalencies where they don't exist. And so I do think that lack of trust is there for the good reasons that you articulated. And so I think it's sort of a careful way forward. I know that the Not One More folks who did so many actions that led up to the deferred action announcement, shutting down ICE facilities, were invited to Ferguson, and just showed up not as a Not One More delegation, but simply as people who wanted to provide some help during the Ferguson uprisings on what it looks like to be pushing back against the federal and local and state government. And so providing that sort of support and logistical support when other movement moments arise, and not just expecting the movement for Black lives to show up for immigrant lives, I think is also key. Saying, that this is a moment where the immigrant rights movement, the immigrant justice movement needs to show up for the movement for Black lives if there is to be any sort of coalition building that is going to push us through to the next stage.
Questions? Jason. Okay.
Thanks to all of you. I really enjoyed this panel. And I think the takeaway, one of the takeaways, which I certainly agree with, is that criminal history is a very, very poor proxy for undesirability in all cases, but especially when you're talking about misdemeanors or so-called convictions that are not even convictions under state law. Right? I'm really glad, Annie, that you're focusing your attention on this. And I don't really have a question, but I did. You probably already knew this, but I was really surprised in 2013 when the Obama administration's immigration reform kind of leaked, and convictions, getting rid of the deportations on the basis of convictions was part of that. And so I have memory didn't show up ever in the Senate bill, but to me it gave me hope, and just like reasons you identified in the prosecutorial discretion memorandum, that people in the administration right now care about this and are aware this is a pretty serious injustice. Jill, I had one question for you.
Sure.
And that was, I thought it was just, I agree with everything you said, and one place where I wondered, or I guess just wanted to put a question to you, was it seems to me that in the earlier parts of the 20th century, we both had more proportionality and a stronger sense of sovereignty and plenary power. And in the sense that we had actual statutory vehicles for balancing and for some legalization. And so I wonder, I guess maybe this is because I already have a truck in this now, but I'm sort of thinking is the legacy of the 1996 laws in part that it was one bridge too far, and it's actually the extreme disproportionality that we have now that might be a sort of a point of attack on plenary power itself, or on notions of sovereignty, or maybe it's a feedback loop and we have to sort of fight all fronts.
Yeah, I think it's definitely true that it's definitely, as I said, it's become easier to become removable and harder to get relief from removal. But as far as plenary power, I guess I see it, I guess the first question is, how much do you really buy into the fact that plenary power is really weakened? Yes, there's been some inroads, but the Third Circuit case that was mentioned this morning a bunch of times, the Third Circuit sort of heavily relies on plenary power in that case. So, even if, we acknowledge that plenary power is weaker than perhaps it once was, I think that I still think that at its core, our view on immigration sovereignty hasn't really changed all that much. And I think, to see a similar manifestation of this, I've written another article about, that talks more about the European Convention in the context of the UK, because the UK even formerly put the European Convention rights into UK law, but then we still saw Brexit sort of fueled, at least in major part, by this sort of fear of the other and immigrants. And I think that what was going on in the UK was at least partly a reaction to sovereignty, right? This idea that by being a part of the European Union and adopting the European Convention, that the UK had given up too much immigration sovereignty. So I think sort of similarly here, I think at least in terms of popular mindset, people still view immigration law very much in a plenary power sort of mode of thinking. And I think that until we sort of move that, I don't know how successful we're going to be in moving away from this system that's always hedged.
So I think we have time for one more question, so we'll give it to Nancy.
So I wanted to follow up on Annie's comment about the way that these, these provisions that aren't really quite law, that are guidance and so on and so on, become sticky and become people's ideas of the way things should be. So, like, it seems the upside is something maybe about expungements or other forms of relief there. But what I really worry about is what's happening with this idea of a felony and 3 misdemeanors, or some misdemeanors are significant and some are not. And how that concept is getting ingrained. And, in New York, we have this huge problem that there are all sorts of things that aren't even crimes, that are violations, and they aren't considered convictions, that get counted by DHS as misdemeanors. So that people have the least possible process. They might have lawyers involved or whatever, but these things are really considered very minor in the state. And then suddenly they're getting grouped together in a way that, our inadmissibility and our deportability law, maybe it will do that on certain things like drug offenses or whatever, but there are a lot of things that don't get, like a disorderly conduct is not a ground of inadmissibility or deportability, but it can be, it seems that that's happening. I don't know if you have thoughts about that or what you've done with that.
I have a quick thought, and you should jump in if you want to. I mean, in thinking about reform, I think ultimately, if it's going to be incremental, we need to think about the sequence and where to, which battle to take on first. And so there is a way in which, if the discussion is about expungements and rehabilitation and doing away with that, it can make more permissible rules, criminal bars that exist now that we otherwise would be able to point to as severely disproportionate or problematic. And so, I'm interested in hearing others' thoughts, but it does seem like the promise of changing the expungement rule is to introduce to the broader public a group of people that we have largely written off in the immigration system as damaged or ineligible, and assumed to be, on their way out the door. So I think it's tricky. But another promise of it is the idea that there are these state criminal justice movements to try to reduce collateral consequences, and we can kind of piggyback on those in various places where those movements are taking place, and then have those people protected from deportation.
Yeah, I'm happy with that. All right, so I just want to give out a thanks to all our fantastic panelists, and a special thanks to Jennifer for joining us with all the technical difficulties. So thanks so much, everybody, for a fantastic panel.
So what you all read in the program as closing remarks is really just buffer time for technological potential problems. That actually is why it's in the program. So I don't have a whole lot to say by way of closing remarks, except to really thank all of you, all of our participants, for being here and coming from places near and far to share their insights with us. And I also want to echo what Annie Lai said a minute ago, or a little while ago. I too have mentors and former colleagues who among you, and it's really quite wonderful to have you all here. We very much wanted this not to be a backward-looking sort of defeatist kind of conversation, and it's really encouraging that in what is a look back at a really difficult and traumatic and dystopic moment, there is a lot of empowering and inspiring creativity and insights that all of you have brought to bear on this conversation as well. So for those of you who are here for CLE credit, make sure that you do fill out the requisite forms. Again, my thanks to all of the folks who have made this day possible. And we have a reception on the 3rd floor, and I hope everyone will join us. And once again, thanks to everyone for being here.
Yes, when I write it, yes. Yes, I'm trying to. Yeah, this is like a mix of my job talk and like preliminary thoughts on any paper. Yeah, I want to take advantage of the DHS anniversary to talk about reorganizing it. Say like, make sure that it's or some version. Enough of it, yes. Enough of it is where I'm at right now. Yeah, thank you so much.
So you're like brand new.
Yeah.
That's awesome. You did a great job doing your essay.
Yeah, where is your case?
So sorry about that.
They gave me a room here.
Yeah. So you're able to really great job. Thank you.
No, we anticipated matching it to you.
It's like not easy. So it's really the credit for it.
No, find out. Are you taking off again?
Hi. Thank you so much.
Sorry about the technical difficulties. Oh, no worries.